Hello everyone, so welcome back to yet another video on the CMA Final Paper number 13 Corporate and Economic Laws. This is CMA Bhavya. So the first 5 to 6 minutes will be the details regarding my online recorded classes, offline batches, books, etc. So if you want to directly skip to the subject, yes, you can do it by using the timestamps in the description box down below. So first of all, thank you so much for all the positive response on my company law marathon. And the marathon for the other laws will be released most probably at the end of August. So yes, I have officially made the announcement because most of you are asking for that. The part 2 of the marathon, when will it be released, madam? Mostly at the end of August with my handwritten notes for the other laws as well. So coming to the offline batches, the face-to-face batch is right now ongoing in Hyderabad for the December 2024 attempt. So if you want to join the ongoing batch, yes, you can do that. And the topics, the recorded classes for the topics that we've already discussed, the backup classes will be provided. You don't need to worry about that. Then if you want to join for a new fresh batch for the face-to-face classes, the batch will commence most probably in the first week of September 2024 for the June 2025 attempt. Not only for law but all the subjects as well. And coming to the online classes, the online recorded classes for the paper number 13 law are available on BCCA app. The link will be provided in the description box below, and those will be available in 100% English. Okay, and coming to books, what about the books, madam? You will be provided 3 sets of books: the color handwritten notes, the color concept book, and the question bank with the MCQs. The question bank is specifically designed for the CMA final students based on the past 12 attempts. Okay, so and also it's a new syllabus, and we've only seen 3 attempts in the new syllabus, so that is why we included the questions from the textbook backside also. Okay, and how will my color handwritten notes look like? So this is the handwritten notes for FEMA. I will be, you can say it's a chart book as well, because I've used charts and a number of colors to make it appealing, because A, it's economic laws, B, it's theory subject, so that is why I made it much more colorful for you to enjoy learning the law. Okay, and the next detail is where will the books be available? You will be able to purchase that on BCCA app. The link is in the description box below, and you will receive the hard copies for the book. And the special announcement is that the freedom sale is on right now, so my books and the classes will be available for a much more lower price. Okay, so don't miss this chance to purchase the classes as well as books. And coming to the FEMA, and my handwritten notes will not be available for all the chapters, will not be available right now. So if you want to access the handwritten notes exclusively for the chapter of FEMA, you can purchase that on BCCA app. It will be available for a very minimal cost. And coming to the color concept book of the FEMA, that will be available on our Telegram channel, the link for which will be in the description box down below. And yes, I've provided the details for my offline class, online class. The freedom sale is on, so don't miss this opportunity to purchase the classes. The classes for all the subjects of CMA Final, CMA Inter as well as the Foundation are available on the app, so do access that. And the last one, exclusive notes, the handwritten notes and the color concept book for FEMA is available on the BCCA app. Concept book is on Telegram channel. Okay, coming to this class. So what is this class for, madam? This is a demo class for my regular classes. So this is how my regular classes in general will go on. So what are the sources for my regular classes? Of course, my handwritten notes, and this is my color concept book. So I've used the color red to highlight important points, side headings in blue, some other special points in green. Yes, and so this is how my concept book will be provided to you. And also the question bank as well. The question bank will contain the questions, answers, past paper questions, and the MCQ series. Okay, so This class is exclusively for CMA Final students. So the portion of CMA Final, the portion of CA Final and the portion of CA Inter are completely different. But all the students, not only CA, CMA students, pursuing other education as well, if you want to learn FEMA 1999, this class is very useful. The starting unit, the salient features of FEMA, where I discuss the introduction of FEMA, evolution of FEMA and the sections of FEMA. There you will have a clear picture with the starting first unit only, so you can listen to that. But CA final students totally depending on this class, or CA Inter student totally depending on this class will not work out because the syllabus is different. This is exclusively oriented for the portion which is there in the CMA study material. Okay, so that's all for the introduction. So let's dive into the regular Foreign Exchange Management Act 1999. Let the learning begin. Thank you. So let's start with FEMA 1999. Yes, so this is, here we will be reading with my handwritten notes as well as the concept book as well. Okay, so before we get into the discussions, first let's understand what is the content that is there in your chapter. So here we have around 4 units in our chapter, which is unit number 1, salient features of FEMA, that is introduction to FEMA and the sections of the act. And then unit number 2 is foreign direct investment. Unit number 3, external commercial borrowings and trade credit. Unit number 4 is liberalized remittance scheme. First units, okay, somewhere we have heard it. I think we can manage. Unit number 3 and unit number 4, oh my god, complicated words. I think advanced concepts will be involved. Maybe we can't write. No, my dear. Everything, all the 4 units are very easy to understand. Okay, you don't need to worry about that. I'm not going into the detailed concepts of each and every unit. So the concepts are simply given as a headings in your concerned study material. Sorry, your concept book. Introduction, importance, evolution, applicability, FERA. So likewise we have around, don't get scared, we have around, how many? 47 concepts. Oh my god, 47 concepts. Don't get scared. Very simply we can do it. I'm there, no? Okay, fine. Handwritten notes is also there to understand. Why are you getting scared? Okay, so unit number 1, shall we begin with this? Okay, so before we start with the unit number 1, actually, let's just ourselves answer for these 2 questions. Why, as a qualified cost and management account, I should be aware of the Foreign Exchange Management Act 1999? And what is the objective of the FEMA? Before you learn any act, not only economic laws, not only corporate laws, any law, you need to understand the objective, like why this law has been brought into India. What is the main purpose behind, what is the main thought behind the lawmaker? That one, if we understand, we can easily understand. Because if we are understanding the main thought of the lawmaker, then we will understand what is the law that he has made. Okay, so first things first, why as a qualified CMA you have to know Foreign Exchange Management Act 1999? Simple, you are a professional, you will be involved in the business decisions or a business environment, yes, and that business environment somewhere or the other, not only business entities, my dear, even individuals are involved in foreign exchange transactions. Why not business entities? So if a business entity is eligible to do that particular foreign exchange transactions, or is it eligible to enter into a foreign direct investment from that concerned non-resident, yes or no, in order to know the correct rules and regulations and the eligibility of that concerned company or else eligibility of that concerned transactions, you have to know Foreign Exchange Management Act. Then only you can say to your client that yes, you can do this foreign exchange transaction because it is allowed under FEMA. No, you can't do this foreign exchange transaction because it is prohibited under FEMA. So in order to be involved in the foreign business decisions where it involves foreign exchange transactions, you have to know the act. Very simple. That is why as a qualified cost and management accountant, you have to be aware of the Foreign Exchange Management Act 1999. Clear? Next thing. Very simple. What is the objective or the main purpose or the thought behind making this concerned Foreign Exchange Management Act 1999? This one we will get to know if we study the evolution of FEMA. What is it? Evolution. That is history of FEMA. When did the foreign exchange rules have first been implemented in India? In the year 1939 through Defence of India Act 1939. So, of course, 1939 we still didn't get the independence, so it has been released by the British government only, under which, is there any separate act at that point of time for foreign exchange transactions? No, there was Defence of India Act 1939. Under the Defence of India Act, in a separate column, there were foreign exchange rules and regulations that have been added as temporary foreign exchange rules by the British government. What is the main aim? Utilize the reserve for war. What is war, madam? War to we know. Why war? In the year 1939, that was the beginning of the World War II, where few countries were fighting against few countries. So British government was also fighting against this Adolf Hitler, who was the main man behind this World War II. Yes, so British government was fighting war with that concerned, where British country is located in Europe. Yes, here it is ruling India. Yes, and it is fighting war against some person, let's say Adolf Hitler, AH. Yes, now what happens? So here it is fighting war, and here it is one of the colony. India is one of the colonies which has been ruled by the British government. Okay, clear. Now, here in India, there will be foreign exchange reserve. What is foreign exchange reserve, madam? Let's imagine that to be a treasury where you store foreign currency. That is currency, that is money in the form of foreign currency. Let's say US dollars, euros, pounds, yen, etc. Different foreign currencies you store in this concerned treasury bin. Yes, this bin or this treasure is called foreign reserve. So whenever you are implementing a foreign exchange transaction, that means buying something from outside India, what you have to do? You have to pay them in foreign currency. Yes, so that foreign currency will be taken from this treasure. Okay, so likewise, Britishers Britishers are utilizing the foreign exchange reserve which is there in India and are purchasing weapons, war equipment, and etc. for fighting the war. Now, at this point of time, if all the foreign exchange transactions are freely allowed, what do you mean by all foreign exchange transaction? For example, during that war, business entity will come and say, I need around $100 million from the foreign exchange reserve because I need to establish a manufacturing unit. Then that Britishers will say, hello, excuse me, I am fighting a war here for you. You need a manufacturing unit now. Just go and sit in your home. Simply that they can't scold each and everyone. No, that is why they have released rules. As British government, we are fighting war. So we are implementing few rules and regulations for utilizing this concerned foreign exchange reserve. Don't utilize this for some other unnecessary purposes. We are fighting a war. We need foreign exchange reserve to purchase war equipment, to purchase weapons, to feed our soldiers, and to feed the citizens of British government where the war is going on. Yes. So that is why what they did, they have introduced a few restrictions under the Defence of India Act 1939. The main aim is utilize the reserve for war. Okay, it restricts all the transactions for the purpose of war. Okay, and after the war has ended in the year 1945, what happened is that small treasure with foreign currency has been utilized. Yes, only few very low reserve is there because they're fighting war. They've spent a lot of money on the war. So what happened is very less foreign currency has been left in the reserve. So this low reserve has to be protected. Yes, because if we utilize this low reserve for unessential purposes, what happens? India will not be able to survive. That is why what they did in the year 1947, March 11th, they have introduced a separate act. Till then, separate act for foreign exchange regulation was not there. In the year 1947, March 11th, Foreign Exchange Regulation Act 1947 has been commenced. Where, again, remember it is March 1947. That is, still we did not get any independence. We are still under the control of British government. Okay, so here British government before independence has introduced the Foreign Exchange Regulation Act 1947, and it restricts all the foreign transactions unless specifically allowed. Specifically, he'll say this for essential purposes like essential grains, spices, or essential equipments for the survival of the nation. If you are importing, yes, it is allowed, but for unnecessary purposes, you say at that point of time, I want to go on to tour, for some tourism purposes, for some studies abroad, which is studies abroad is one of the essential, but not essential for survival, no. Yes, so that is why what happens, they have restricted all the foreign transactions unless specifically allowed. Before, they have put restrictions for the purpose of war. Here they have put restrictions for the purpose of utilizing the low reserve. Okay, clear? So the aim is proper utilization of the low reserve. They have brought the Act Foreign Exchange Regulation Act 1947. Okay, after that they have given us the freedom, yes, in the year August 15th 1947. Okay, and now in the year 1973, Indian government, yes, 1947, who has enacted that? Yes, who has established that? British government. That was only being implemented till the year 1973, where they are restricting the foreign exchange transaction. They're not allowing any foreign country to come do business in India because they are scared of being invaded again. Yes or no? So what happened? The Indian government simply followed the 1947 FEMA Act. Okay, but in 1973, what happened is the situation became much more worst, critical. What happened is they did not allow any foreign exchange investment. They are not allowing any exports. Yes, if we allow exports, what happens? We will generate foreign income. Yes, if we allow only imports, what happens? We are going on spending the foreign exchange. Yes, so what happened is in the year 1973, the position was much more critical. There was very low reserve left. Now here also the Indian government made the same mistake. What did they do? In order to increase, foreign exchange reserve was there, which was extremely low. Yes, for the purpose of import of goods, import of services, or other equipment, purchase of other equipment. What happens? We need foreign currency. Yes, but there was very low foreign currency in the year 1973. Now what happened is, in order to again, they didn't thought of an idea to increase the foreign currency, but they thought of an idea to again protect the foreign currency. What they did? Again, with the new act, they have established restrictions on foreign exchange transaction. So, but what is the main difference between 1947 and 1973, Farah madam? Restrictions were much more stringent in the year 1973. Okay, see this. In the year 1973, another act has been introduced by the Indian government by deleting this FERA 1947. Okay, so here all the transactions were restricted and more stringent rule was implemented. What is the main aim? Very simple: optimal use of resources for essential purposes. Very low reserve was there. Yes, and India was in a very critical position. Okay, so that is why what they did, they have introduced a FERA with much more stringent rules. Why did they put restrictions in the year 1947? Because due to war there was a low reserve. That is why they have put restrictions. Here what happened? War was not there from 1947 to 1973. Still they were not able to increase the foreign exchange reserve. Because the main thing, we are scared of being invaded by some other country again. So that is why what they did nothing to increase the foreign exchange reserve, and the reserve is being utilized in the year 1973. What happened? The position was much more critical. Very, very low reserve was there, and again what they did, they are trying to protect the reserve. Rather than thinking of a way to increase the reserve, they are still trying to protect the reserve with much more stringent rules. Okay, so what happened? Going for medical treatment for outside India, or going for studies abroad for outside India, for tourism purposes, for making investment in some other foreign country, for generating funds, everything was restricted under the Foreign Exchange Regulation Act 1973, which is being implemented by the Indian government. Okay, so the aim was optimal use of resources for the optimal use of reserve for essential purposes. Now what happened is, a great mind of India, a great mind in Indian history, P.V. Narasimha Rao, who is the one and only Telugu person, one and only person from the Telugu states who has been in the position of the Prime Minister till now. Yes, so he has come up with a great idea that now it's time to break the rules. Yes, now it's not time for protection of the foreign reserve, but we want to do something to increase the foreign reserve. What happened is he has opened the gates in India with the LPG policy. What is it? Liberalization, privatization and globalization. What he did is, now he has announced that officially now India is open for making investment from outside India. So if some foreign non-resident is making investment in India, what happens? He's bringing dollars, he's bringing foreign currency in India. With that, what happens? Our reserve will increase. Yes or no? Yes. If we increase our export, what happens? If we increase our exports, we will receive the money from that concerned person who is buying our goods. Yes. Now what happens? Foreign reserve will increase. So with the introduction of liberalization, privatization and globalization policy released by P.V. Narasimha Rao with the help of Manmohan Singh, he's an economist, so he has brought up with this idea, and they have opened the economy for international trade. Now trading can be done between India and outside Indian countries. Yes. Okay, so with the introduction of LPG policy in the year 1991. But in the year 1991, for regulation of foreign transaction, which act was there? Still Foreign Exchange Regulation Act 1973 was only there. But here what they did? They opened the economy for foreign investment. But FERA 1973 is telling that everything is restricted. So these both are in a contradicting position. That is why what happened? They have to introduce a new act which will favor the LPG policy. That is why in 1997 a separate committee was set up, which is Tarapur Committee, in order to frame the foreign exchange rules in accordance with the LPG policy. That is when we have the Foreign Exchange Management Act 1999, which main aim is free flow of forex payments, ease of doing business. Simply, it's very easy to do business now, because simply if you want any investment, you can procure the investment from a non-resident. If you want any equipment from outside India, you can purchase the equipment from outside India. If you want to export the goods as a business India to some other country, you can do it. Through FEMA 1999, they have provided ease of doing business. Easily business activities can be done in India after the FEMA 1999, and also free flow of forex payments. And the next one is promotes external trade. Yes. So with this Foreign Exchange Management Act, we have the three main objectives. What are those? Free flow of forex payments, ease of doing business, promotes external trade. FERA was regulating, that is, it is putting restrictions. If you do this foreign exchange transactions, you will be sent to jail. This is FERA. Foreign exchange management transactions, please do foreign exchange transactions. No, we want to increase the reserve. This is FEMA. That is why it is management, that is regulation. Clear, everyone? I hope you understood the evolution. From where we are starting? 1939 Defence of India Act. First thing, 1939 Defence of India Act. The reserve was being utilized for war. That is why restrictions were put. 1947, after the war, low reserve was left. For utilization of this low reserve, they have put restrictions. 1973, they have Britishers, after giving us freedom in the year 1947, August 15, they have taken that low reserve also. Now what happens? Yes. So with that low reserve only, from 1947 to 1973, we have, survived in a very critical position. Yes. So in the year 1973, more restrictions were put, stringent restrictions were put in order to protect the foreign reserve. But in the year 1991, one of the greatest minds of Indian history, P.V. Narasimha Rao, has brought in the LPG policy and opened the economy for international trade. This will help us improve and increase our foreign exchange reserve. Clear, everyone? Who has framed this concerned FEMA? A separate committee was set up in the year 1997, that is called Tarapur Committee, and What is the main objective of the Foreign Exchange Management Act? What is it? Promotes external trade, free flow of foreign exchange transactions and foreign exchange payments, ease of doing business. Now got it? Now got the objective of FEMA, and why as a CMA you are reading FEMA? Now let's move on to the next concept. We'll open the, our concept book. So let's just read the concept also. Some unnecessary miscellaneous concepts which are not that important for your examination I have not included in your handwritten notes. Okay, so one of it is introduction, which is constitutional basis. Who gave the right for that concerned parliament to do act, to bring out the Foreign Exchange Management Act? Constitution. That is what we are learning. See, constitutional basis. Article 246 of the Constitution grants the Parliament the power to make laws on matters of union list. We have three lists. What is it? Union list, which is also called like a central list, state list, and then concurrent list. Concurrent list, both state government as well as central government has the right to make laws. State list, only the state government, that is the assembly, will come and do the concern, make the laws on that concerned matters. And coming to union list, who has the power? Parliament, that is the central government has the power to make laws. Which article says that? Article 246 of the Constitution states that, what is it? Constitution grants Parliament the power to make laws on matters in the union list. So in the union list, which is regarding the Foreign Exchange Management Act, what are there? Entry 16, foreign jurisdiction. Entry 36, we have currency, that is notes and the coinage, legal tender, that is the money, and foreign exchange, foreign loans, trade and commerce with foreign countries. For all these concerned activities, who has the power to make laws? Parliament has the power to make laws. For regulating all these activities, what did they brought? Foreign Exchange Management Act 1999. This is the simple introduction. And coming to importance of foreign exchange, very simple. Why is it important to bring this concern Foreign Exchange Management Act 1999? What is it? Global trade. When businesses import goods, export products, invest abroad, they deal with foreign exchange. For all these we need rules or regulations, no? So that is why they have brought in the Foreign Exchange Management Act 1999. And also economic stability. Effective management of foreign exchange is crucial. What happens if suddenly the foreign exchange reserve, because of we don't have any separate act, we are having all the transactions, yes? Now what happens? We are unable to increase our reserves. Our reserve is very low. What happens? The economy will become unstable, yes? Inflation, interest rates, everything will increase. It's very hard to survive. That Great Depression will come. So that is why for management of foreign exchange, you need a separate act. For economic stability and also for global trade, it is important for us to bring a management act. What is it? Foreign Exchange Management Act. Okay, clear. Now evolution we have already seen through the flow chart. Yes, 1940s Defense of India Act 1939, and then 1947 FERA Act, and then FERA 1973, and then economic liberalization was brought in the year 1991, and 1997 Tarapur Committee was been set up for framing the foreign exchange legislature for recommending changes to the FERA 1973. They have brought in the FEMA 1999. Okay, and in 2000 we've already we didn't still see the applicability and the commencement. That one we will see later. Okay, now let's directly dig into the concept of, before that we have to read this concept, FERA 1973 versus FEMA 1999. Maybe an answer might come up from this. Till now in your past they did not ask FERA versus FEMA, but maybe a question may be asked. So let's understand FERA 1973 versus FEMA 1999. We to basically know what is it. FERA is restricting everything, FEMA is allowing everything, yes? So but if we want to write in the form of differences, we have to learn the actual terminology. So what is the main difference? Objective. Yes, here the main objective of the FERA 1973 was protection, that is conservation and proper utilization of foreign exchange, and control over business activities of Indian companies abroad and foreign companies in India. Everything was being controlled. Any export or import or investment from outside India or investment we make to outside India, everything was being controlled under FERA 1973, and the main purpose is conservation and proper utilization of the reserve. When coming to FEMA, what they did, liberalize and manage foreign exchange. They are giving us freedom to do foreign exchange transaction. That is called liberalization. Yes, encourages international trade. That means yes, you are encouraging business. Go do some trade in foreign business. We are asking the foreign companies or non-residents to come do business in India in order to increase our reserve. What we are doing, we are allowing international trade and free flow of foreign exchange payments. Clear everyone? I hope I am clear with the first difference. What is it? Objective. Yes. And the nature of law. FERA was a criminal law. FEMA was a civil law. What do you mean by criminal law, madam? What do you mean by civil law, madam? Very simple difference. Criminal law means under FERA, if you don't follow a rule, what happens is you become criminal. For sure, you will be sent to the prison. That means you will be given a punishment of imprisonment for sure under FERA 1973, because it is a criminal law. If under FERA, if it is saying that this particular transaction is not allowed and you do the transaction, you are considered as criminal and immediately you will be arrested. But under civil, under Foreign Exchange Management Act 1999, what happens? It's not a criminal law, it is simply a civil law. Here all the cases will be dealt in civil court, where you will not be arrested. You will be arrested in very extreme situations. You will not be arrested. Simply you have to come to the court, you have to pay the penalty and you have to go. But under FERA, what happens? You will be arrested and you will be taken into the custody of the concerned police department. Okay, and here under the FEMA 1999, it is civil law. That means easily you will not get, for small rules or regulations, if you don't follow that, you will not get any imprisonment. Simply penalties will be levied. Imprisonment will be there in a very extreme case. Okay, I hope you understood this. Nature of law, criminal law, FERA, civil law, FEMA, and presumption of guilt. Until and so under FERA, first of all, you will be, it is your burden that I am not a criminal. Please, I am not being held guilty. You have to prove yourself innocent under FERA. But under FEMA, it is the job of that concerned enforcement directorate to prove you wrong. Clear everyone? Under FERA, what is it? It is your burden or your job to prove yourself innocent, that I am not a criminal. But here, if you do not follow any foreign exchange regulation or a rule, what happens? It is not your burden, but rather than the enforcement directorate's burden. Who is enforcement directorate, madam? Very simple. Enforcement directorate is like, you can imagine that to be a tribunal where it will ensure that all the persons for whom the FEMA is applicable, they follow FEMA. If not, what will they do? They levy the penalties. Whose job is it to levy penalties and take care that they follow the FEMA or not? Enforcement directorate, and take in the complaints which are raised by the concerned persons. Yes, so all this job is under the enforcement directorate. So if any wrong has been done by a person, so whose burden it is to prove them innocent, whose burden is them to prove that that person is guilty? Enforcement directorate under FEMA. Under FERA, it is the burden on you that you have to prove yourself innocent. Clear everyone? Presumed guilty until proven innocent. Here burden of proof on enforcement directorate. What happens? So if you follow a famous movie, Bahubali 2, what will they do? They won't actually interrogate the situation or something. Simply they will bring Devasena to that concerned court of King's Court with that, handcuffs. What she says, you have directly presumed me as guilty without hearing my case. Yes, without hearing my case, you have presumed myself as guilty. What kind of law is it? It is called criminal law. Clear, everyone? Okay, so even if you don't understand the case that I'm linking, just remove. Very simple. Under FERA, who has that burden to prove yourself innocent? Yourself. Under FEMA, what happens? In order to prove you guilty, enforcement directorate has the burden. Okay, very simple. Here penalties under FERA, I have already told you, strict penalties and imprisonment will be for sure, and then here relaxed penalties will be there. Arrest will be in extreme cases. And the next one, regulation. All the foreign exchange activities are regulated. That means all the foreign exchange activities are controlled and keep an eye on what happens in the FERA. And the next one, only specified activities are regulated. Okay, and here ease of transactions. Most of the transactions have complicated and strict restrictions, but here transparent, easy to access, and we can easily understand the regulations. Okay, and the last difference is foreign exchange reserves. Here what happened? There is a restricted flow from the reserve. Here promotes increase in foreign exchange reserve. How do they promote increase in foreign exchange reserve? Through foreign direct investment and through exports, yes, and through international trade. Clear, everyone? Very simple. Objective we have known: conservation of foreign exchange, control over business activities. Here liberalize and manage foreign exchange market, encourage international trade, and also free flow of foreign trade and payments. Here it is a criminal law, civil law. Here presumed guilty, you are presumed, that means you will be held guilty until and unless you are proven innocent. Here the burden of proof that you are guilty is under the enforcement directorate, and here penalties will be strict. Here relaxed penalties. Here all the foreign exchange transactions are regulated. Here only specific transactions are regulated, and ease of transactions, which is complicated, and here transparent, easy to access. And the next one, foreign exchange reserve. There is a restricted flow of foreign exchange reserves under FERA 1973. Here promotes increase of foreign exchange reserves. Okay, next let's move on to the next concept, which is structure of the Foreign Exchange Management Act 1999. As I've already told you, this is a regular class. I will be going very slowly in order to make you understand. Okay, let's start off with the structure of the Foreign Exchange Management Act 1999. Yes, what all are included under FEMA, what all we have to read under FEMA. Yes, okay. First things first, main act. You've already seen what is it, FEMA 1999. Main act, the legislation is also included in the structure. Main act, which is also known as supreme legislation, which has 7 chapters and 49 sections, and it is provided by whom? Parliament of India. I've already told you, under Article 246, Constitution gives the right to the Parliament to make laws on foreign exchange transactions, foreign jurisdiction, coinage, legal tender, international trade, everything. Who has the power to make laws? Parliament of India. Okay, so Parliament of India has brought in the supreme legislation to regulate the foreign exchange, to implement the rules and regulations for foreign exchange transactions. Okay, so this is called the main act. It has 7 chapters and 49 sections. Now let's see the next rules. Who has the concerned right? Ignore that music in the background, just a moment. So the first one is the main act, that is the supreme legislation, which is released by the Parliament of India. Yes, which is called the primary law, 7 chapters, 49 sections. And the next one is rules. So who has the power to make the rules? Who has the power to make the rules? The Ministry of Finance. Under company law, who has the power to make the rules? Ministry of, yes, Corporate Affairs. Yes, here we have the Ministry of Finance. See, this rules is also called as delegated legislation. Why is it called delegated legislation? Under the section number 46 of the Foreign Exchange Management Act. Let's see here. See, under section number 46 of the Foreign Exchange Management Act, who has given the right? FEMA in the primary act has given a right to the Ministry of Finance to make rules in order to understand the law. if bare act has been released and no explanations has been released, what will the people understand? So that is why the rules are being issued by the Ministry of Finance in order to understand the concerned primary law in a better manner. Okay, so under section 46 of the FEMA, it has given the power to whom? The Ministry of Finance to make rules. Clear? And here we have around 5 set of rules, and the power has been given under the section 46 of the FEMA. Provides guidelines to implement the main act. Now coming to the third one, regulations. So regulations are being released by whom? The Reserve Bank of India. Here again under the section 47, the FEMA Act 1999 under section 47 is granting the power to Reserve Bank of India to make regulations. What are these regulations for? Provides guideline to implement both the rules with the help of the main act. Okay, clear everyone? Much more in detail it will explain us how to understand the rules and how to understand the primary act. Clear everyone? So if you don't understand any provision under the main act, you have to go check that in rules. Yeah, again, if you don't understand in the rules also, you have to go check that in the regulations. So the delegated legislation is given to the Ministry of Finance. The subordinate legislation is given under the given to the Reserve Bank of India. Why it is called subordinate legislation? Because it is subordinate to both the supreme legislation as well as the delegated legislation. Clear everyone? Here we have 23 set of regulations under the Foreign Exchange Management Act 1999 section number 47. So in that concern section number 47, we don't have rules. That section number 47 is telling us that we have given the power to RBI to make the regulations. Section 46 says that we have given power to the Ministry of Finance to make the rules. Okay, next, some more which are included in the structure of FEMA. Structure of FEMA is master directions and circulars issued by RBI. Simply, basically, if it is foreign exchange, rules regarding the foreign exchange based on the economic trends, of course we have to make changes to the rules and regulations. For example, during COVID or during some inflation situation or during depression situation in the concerned economy, what happens? We have to make few rules and regulations. We have to change. For every concerned time, we can't amend the concerned act. Yes or no? If we want to amend the Foreign Exchange Management Act, we have to again, like the Parliament should amend the act. That is a very long procedure. So that is why if there are any new regulations or any changes, what happens? Simply RBI has been given the power to release master directions and master circulars regarding some other rules. For example, the Unit 3 and Unit 4 and Unit 2, FDI, ECB, LRS, all these are not there in FEMA 1999. They are part of master directions. Clear everyone? So new rules and regulations which are not there in the main act will be released through master directions and master circulars by Reserve Bank of India. Clear? And even FDI policy is also part of the structure of Foreign Exchange Management Act, which is released by the Department for Promotion of Industry and Internal Trade. Not DIPP, rather it is DPII. Okay, here I have given it is wrong, but on the structure it is right only. Okay, here see who releases this: Department for Promotion of Industry and Internal Trade. The FDI policy is periodically issued by DPII, and the policy outlines the guidelines and procedures for foreign direct investment. So separate regulation for how is this concerned foreign direct investment by this concerned person is allowed or not. In this concerned business activity, is it allowed or not? Yes, all that rules and regulations are in FDI policy, not in the main act. Clear? Okay. Next we have notifications and circulars. Few small notifications or small changes or small clarifications will be given via notifications and circulars, again issued by RBI. If you are providing a new set of rule like ECB, LRS and FDI, that is called master direction. Just a small change or small clarification, that will come under notifications and circulars issued by RBI. This is issued by RBI. Master directions are issued by RBI. FDI policy issued by Department for Promotion of Industry and Internal Trade. Okay, that is DPII. Okay, and the last one, Enforcement Directorate. I've already told you what is Enforcement Directorate. ED, madam. That is what my offline students told. Intelligent fellows. Okay, so Enforcement Directorate's main duty is ensures people comply with the FEMA rules and regulations. So compliance of rules and regulations being going on properly or not, that has to be ensured by the Enforcement Directorate, and looks into complaints and any violations made by the citizens, okay, or the persons who's applicable to. And the next, imposes penalties for any violations. Okay, so if anyone is violating the FEMA rules and regulations, the imposition of penalties is the duty of the Enforcement Directorate. Clear, everyone? So all these 7 things are part of the structure of FEMA. What is it? Main Act, which is FEMA 1999. Second one is first one is main supreme legislation. Second one is delegated legislation, which is rules issued by the Ministry of Finance. And the next one is regulations, which are released by the Reserve Bank of India, which is called subordinate legislation. And the next one is master directions and circulars. And the next one is FDI policy. And the next one is notifications, circulars. Okay, last one is enforcement directives. All these 7 are part of the Foreign Exchange Management Act structure. Okay. Now let's move on to the sections of the FEMA sections. Okay, so first section talks about, in every act, Indian Contract Act, Sale of Goods Act, Companies Act, Negotiable Instruments Act, Partnership Act, LLP Act, yes, everywhere section 1 talks about short title, extent and applicability, commencement. Here also short title, extent and applicability, commencement. Short title means name of the act. What is the name of the act? From starting we are reading. What is it? Foreign Exchange Management Act 1999. Okay, now next one, extent. It extends to whole of India, but also it is also applicable to whom? To all branches, offices, agencies who are located outside India but owned and controlled by person resident outside India. Person resident in India. Okay, what is the applicability? Extends to whole of India, but these branches, offices, agencies which are not in India, that is located outside India but owned and controlled by person resident in India, for them also FEMA is applicable. And the next one, any violation committed outside India. That means there has been some concerned violation to a rule or regulation which is done outside India but by a person to whom FEMA applies. Okay, like Indian resident or branches, offices, agencies located outside India but owned and controlled by person. But these branches or offices or companies which are owned and controlled by person resident in India and they have committed a violation outside India, for them also what applies? FEMA applies. Okay, so what is it? Extends whole of India and applies to all branches, offices, agencies outside India but owned and controlled by person resident in India. Ownership, not only ownership, you should also check who is the main person behind controlling that concerned office, branch, agency. Clear? And the next thing, any violation committed outside India but by a person to whom FEMA applies. Okay, so for example, what happens is, resident in India is not permitted to spend money on gambling activities. What? On gambling activities. Okay, now what I did is, FEMA is telling that I should not spend my money on gambling activities. Now I went to a person, let's say a bank, and I've taken foreign currency. But I did not say that I did not say there that I'm using the foreign currency for gambling activities. I'd rather said what I said is, I'm using that concerned money for my studies abroad. I've taken the money. I went outside India, let's say Las Vegas, and then I went to an unauthorized casino and I've started using my foreign currency in the form of gambling. Now what happens is, the police of US have come there and raided that concerned unauthorized casino and they've caught me. What I did, I have violated by doing gambling activities in unauthorized casino as per the US government. Here what I have done under FEMA Act, even if FEMA is not applicable to US but it is applicable to me, no? Yes, because I am part of India. I was a resident. Violation is committed outside India, but by a person to whom FEMA applies. Yes, so for that kind of person also it is applicable. Okay, I hope I'm clear. And the last one is commencement. So Act has been brought in the year 1999, but when it started being implemented, came into force on 1st June 2000. When is it? 1st June 2000. Remember this, okay? I hope we are clear with the section number 1. What is it? Short title, Foreign Exchange Management Act 1999. Extent and applicability, it extends to whole of India and also applicable to all offices, branches, agencies outside India owned and controlled by person resident in India. Clear everyone? And the next also applies to any violation committed outside India by a person to whom FEMA applies. And the last one is commencement. When did it commence? 1st June 2000. Okay. Let's move on to the next section, which is section number 2, where every act under in India released by the Parliament, section 2 is always definitions. Yes. Okay, good. First, we are not going to read all the definitions, for God's sake. Please calm yourself. Yes. Why are we learning these definitions? In order to understand those complicated terms. Okay. Because we will come across few terms where we will not be able to understand without understanding the definitions. So the first definition is foreign exchange. From starting we are reading foreign exchange reserve, foreign exchange transactions, foreign exchange management act, foreign exchange regulation act. What is the meaning of foreign exchange, madam? Very simple. It means foreign currency. That means currency other than Indian currency will also be, called as foreign currency, and that is called as foreign exchange. Main meaning of foreign exchange is foreign currency, but it also includes deposits, credits, balances payable in any foreign currency. So if any balances are payable to Indian government in the form of foreign currency, that is an asset to it. So that is why it is also forming part of foreign exchange. Or deposits or credits in bank account we have, but in the form of foreign currency, that is also called as foreign exchange. And next, drafts, travelers checks, letter of credit, bills of exchange drawn in INR. That is, we have drawn that in the in the form of Indian currency, but we are paying that in the form of foreign currency, then that will also be called as foreign exchange. Okay. And the next, drawn, all these drafts, travelers check, letter of credit, bills of exchange are drawn by person resident outside India but payable in Indian currency. Clear? So drafts drawn in the form of INR but payable in FCI, it is called foreign exchange. Drafts, travelers check, letters of credit and bills of exchange drawn by person resident outside India payable in INR, even that is also called as foreign exchange. What does it include? Deposits, credits, balances payable in foreign currency. Next one, drafts, travelers check, LOC, that is letter of credit, bills of exchange drawn in INR payable in FCY. What do you mean by FCY? Foreign currency. Okay, don't get confused. Drawn by person resident outside India payable in Indian currency. Okay, I hope I am clear. Now let's understand the next definition, which is authorized person. Who is an authorized person? Very simple. Reserve Bank of India will give an authorization that yes, you are authorized to deal with foreign exchange. You have permission to hold foreign currency. You have permission to sell foreign currency. You have permission to buy foreign currency. So that person is called authorized person. There are 3 categories of authorized persons. Number 1 is authorized dealer. Number 2, money changer. Number 3, offshore banking unit. What is the first one? Authorized dealer. Who is he? Very simple. He is authorized by Reserve Bank of India to buy or sell foreign currency. What do you mean by buy or sell foreign currency? So I am an Indian resident. I want foreign currency. Yes, I want foreign currency for tourist purposes. Okay. Now what I will do? I will sell Indian currency and buy foreign currency because I have around 100 rupees. Okay. Let's see. For example, 1 euro is 100 rupees. not right now, but 1 euro is 100 rupees. I want 1 euro. What will I go? I will go to an authorized dealer. I will sell 100 rupees and I will buy 1 euro. What is he doing? He's selling euros and buying Indian rupees. So he is authorized by Reserve Bank of India to buy and sell foreign currency and to facilitate foreign currency transactions. So I myself is an Indian company and I want to purchase an equipment from a German dealer. Now what I will do? I have to create an account in Germany. I have to send the euros that I have purchased from authorized dealers to that Germany account, and that from that Germany account I have to transfer to that German supplier. Yes, there is a lot of transactions involved. So all these transactions will be facilitated by authorized dealer. Now authorized dealer only will come. He will only open an account for me in the form of in order to deposit foreign currency. He will take approvals from that concerned government. What he will do? He will facilitate foreign currency transactions to me. He is called authorized dealer. Clear everyone? And the next, money changer. What do you mean by money changer? Very simple. He will convert foreign currency into Indian currency into foreign currency. His main job is simply convert INR to FCY or convert FCY to INR. Okay. So there is a money changer. His main duty is giving you dollars if you give Indian rupees. Giving you Indian rupees if you give dollars. That's all. He will not facilitate your foreign currency transactions. He will not open any bank accounts. He will not talk to that supplier. He will not take any permissions. Clear everyone? Money changer, simply his main job is converting currency. Authorized dealer, he will facilitate the foreign exchange transactions as well. Okay, next, offshore banking unit. These are offshore, that means they are located in India, not outside India, in India only. Okay, so where are they? I hope everyone knows about SEZ. What are those? Special economic zones. So here government will give tax reductions, exemptions, and also it will promote exports in order to increase foreign exchange reserve. It will delegate a location where exports are freely permitted without any transactions, and interest rate will be loans will be given for lesser interest rates, and also tax reductions will be given, tax exemptions will be given in the special economic zones. So in the special economic zones, what happens? More exports will be happening. They will be exporting services, they will be exporting goods. That means they will be frequently involved in foreign exchange transactions. In order to take care of all these transactions, what will they do is they will establish a bank in SEZ which will facilitate this foreign exchange transactions, convert the currency easily for them. For whom? For business entities established in SEZs. So offshore banking units are simply banks set up in SEZs, not only a special economic zone, but also they are established in export oriented units, and for ease of doing business, for increasing exports, and for facilitating foreign investment. Okay, so if any non-resident is trying to make an investment in a business entity established in SEZ, he can easily do that through an offshore banking unit. Clear everyone? So these three persons are called authorized persons. Who are those? Authorized dealer, money changer, offshore banking unit. Okay, I hope I am clear. And the next definition is foreign security. What do you mean by security at the basic glance? Shares, stocks, debentures, bonds, everything is called securities, right? So foreign security is also shares, stocks, bonds, debentures, and other instruments, but expressed in the form of foreign currency, and redemption or income is payable in the INR. Simply shares of a foreign company which will be expressed in foreign currency. That means their value will be in dollars, but if you purchase those, you will receive the income in the form of INR. So that is called foreign security. Clear everyone? I hope I'm clear. Shares, stocks, bonds, debentures, and other instruments expressed in foreign currency. Basically their price will be in foreign currency, but if you purchase them, you can redeem them, or your income will be generated, that is payable in the form of INR. Clear everyone? I hope so. Let's move on to the next classic, very important definition, which is person resident in India. Okay. I think we have skipped a bit. First we'll see this and then we'll go to the other definitions. Okay. Person resident in India. Around past 2 times it has come up. 2014 December and 2015 December. This does not come under old syllabus also. This is very old syllabus. Okay, but it is part of an important provisions, because everywhere under FDI, ECB, LRS and also upcoming sections you will come across the term person resident in India. But you should know the definition of person resident in India, right? Who will be called as resident, who will not be called as resident, that one we will understand with this definition. Okay, so the first definition, this definition is again divided into 3 categories. First one talks about individuals, second one talks about entities, third one talks about offices, branches and agencies. Clear? Okay. Person resident in India. First condition that you have to check. First of all, let's understand who is a person. All individual, HUF, company, firm, AOP, BOI, AJP. Where did you read this definition? Your direct taxation classes. Yes, where you will be under the residential status. You will understand who is a person. Person includes individuals, HUF, that is Hindu undivided family, companies, partnership firms, LLP firms, association of persons, that is AOP, body of individuals, that is BOI, artificial judicial person, that is AJP, all this, and also office, branch or agency controlled by above. Clear everyone? This is a separate definition under FEMA, not a definition under DT, similar to definition under DT. Clear everyone? So what is the definition here? Individual, HUF, company, firm, AOB, BOI, AJP and also office, branch or agency controlled by the above. Clear? Okay. Now let's understand who is person resident in India. Okay. So understand with this flow chart. Person resident India named as PRI. Person resident outside India named as PROI. Okay, first condition you have to check is, during relevant previous financial year, did he reside in India for more than 182 days? His stay in India in the previous financial year is more than 182 days or not? Yes, it is more than 182 days. Condition 1 satisfied. Yes. Next condition that you have to check, did he go out or stay outside India during the current financial year? During the current financial year, did he go out of India or did he stay outside India? And again, yes, second condition satisfied. Now, for what purposes? He went outside India, he stayed outside India. What is the purpose of his stay outside India? For these 3 purposes. What are those 3 purposes? For taking or on taking up employment outside India, or for carrying on business or vocation outside India, or for any reason that shows his intention to stay for an uncertain period. First main reason, for taking, that means for taking an employment, that means for searching for a job, or for already you got a job and you're going there, that is called on taking. Okay, and for taking, you're going for searching for an employment, that is like permanently you're staying outside for employment purposes. Okay, and the next, for carrying on business or vocation, for the purpose of carrying on business or vocation means profession, lawyer, as a lawyer or as a chartered accountant, or as financial services or consultancy services. These are all professional services. Yes or no? So for carrying on business, for carrying on vocation, or for employment, or for any reason your intention is, I'm staying for an uncertain period. I can't be sure that I'm staying for 1 year or 2 years. I'm staying for an uncertain period. So if you're going outside India for the following 3 purposes, yes, you will be called as person resident outside India. Yes, you are going outside India, but not for these 3 purposes. You will be called as person resident in India. Clear? You're not at all going outside India. Why? to check the residential status? Simple. You are a person resident in India. Clear everyone? First condition, did his stay in India for the previous financial year is more than 182 days? Yes. Did he go outside India? Yes. For the following three purposes? Yes. Then he will be called as person resident outside India. Okay. His stay is more than 182 days. Did he go outside India? No. Then what is he called? Person resident in India. Did he go outside India? Yes. For the three purposes? No. He is called person resident in India. Okay? Good. Now, the first condition is no. His stay in the previous financial year in India is not more than 182 days. That means it is less than 182 days. Okay? Okay. Now, did he come or stay in India? Yes. For which purposes? For the following three purposes? Yes. Person resident in India. An example, he is a foreign citizen. Till now he did not come to India. For the first time he is coming. That means obviously in previous financial year that 182 days condition is not satisfied because a person resident outside India. He is a foreign citizen, but he is coming to India for the first time in current year for the following three purposes. Yes, he will become person resident in India. But his stay in India in the previous financial year is not 182 days. Okay? And he came to India or he stayed in India in the current financial year, but not for the following three reasons. Then he will still be called as person resident in India. His stay in India is not more than 182 days and he did not come to India. He is called person resident outside India. Clear everyone? I hope you understood the cases. Very simple. First condition, stay in India in the previous financial year is more than 182 days or not? Yes. Okay. Did he go outside India? Yes. For the following three purposes? Yes. He is called person resident outside India. Stay in India is more than 182 days in the previous financial year. Did he go outside India? Yes. For the following three purposes? No. He is called person resident outside India. Next, stay in India is more than 182 days in the previous financial year. Did he go outside India? No. He is a person resident in India. Clear? And the next case. Stay in India in the previous financial year is not more than 182 days. That means it is less than 182 days. Okay? Very good. Did he come to India in the current financial year? Yes. For the following three purposes? Yes. He is called person resident in India. Okay. Stay in India in the previous financial year is less than 182 days. Okay. Did he come or stay in India? Yes. For the following three purposes? No. He is called person resident outside India. Okay. Stay is less than 180 days. He did not come to India. Then he is called person resident outside India. Clear everyone? The three reasons: taking up employment, starting a business or a vocation, and for any reason that is showing an intention to stay for an uncertain period. Okay. And the second part of the definition is any person or body corporate registered or incorporated in India. So if an establishment is controlled by let's say it's controlled by a person resident outside India, but it has been incorporated or registered under the Companies Act 2013, then what happens? It is coming under the person resident in India. Okay, even if it is controlled by person resident outside India, if any person or body corporate registered or incorporated in India, it will be called as person resident in India. And the next case is, it will be called as a person resident in India if an office or branch or agency location is in India only, but owned and controlled by person resident outside India. Then it will still be called as person resident in India. What is it? Office, branch, agency, location in India, owned and controlled by person resident outside India. Then still it will be called as, that office or branch or agency will be called as person resident in India. If location is outside India but it is being controlled by person resident in India, then that office, branch or agency will be called as person resident in India. Clear everyone? Okay, I hope I'm clear. And let's move on to the next definition. Here in this concerned flowchart, I have dealt with 4 definitions: foreign direct investment, foreign institutional investor, foreign portfolio investor, foreign venture capital investor. Okay, so first thing first, remember this. All these things are, these 3 are persons. This is investment. Here the foreign direct investment is made by person resident outside India. Okay, and here foreign institutional investor is person resident outside India. Here foreign portfolio investor is person resident outside India. Here venture capital investor is person resident outside India. First basic condition. Okay, next. Now what is the general meaning of foreign direct investment? Simply, foreign person resident outside India is making investment in the business of Indian company. That is called foreign direct investment. Clear? In detail we will see in unit number 2. Simply here is investment in business is called foreign direct investment. Business of what? Indian company. Clear? Okay, now foreign institutional investor, foreign portfolio investor, foreign venture capital investment, all 3 members should first be registered in accordance with the SEBI regulations. So in order to call a concerned non-resident as foreign institutional investor or foreign portfolio investor or foreign venture capital investor, first he should get that status from where he has to get registered under the SEBI regulations. Okay, fine. Now let's see what is he doing. What kind of investment is he making? Foreign institutional investor is simple. It has the word institutions. So institutions like mutual funds, pension funds, insurance companies will come and purchase the shares in the capital markets of India. He will be called as foreign institutional investor. What do? Investment in financial markets, that is stocks, bonds, shares, debentures in India. Clear everyone? So foreign institutional investor is like an institution, like mutual funds, pension funds, insurance companies. They receive money from their people and they have to invest in some viable assets. Yes, so that they will come and get registered as FIIs and they will invest in financial markets of India. That is, they purchase the stocks, bonds, shares, debentures and other capital instruments and securities in financial markets of India. That is why they are called foreign institutional investors. Okay, here FPI, foreign portfolio investors. Here not only institutions but also individuals can also get registered as foreign portfolio investors and they can make investment in financial markets of India. Clear? Here foreign institutional investor, only institutions can get registered as FIIs and they can make investment or trade in the financial markets. But here foreign portfolio investor, individuals plus institutions will invest in financial markets, stocks, bonds. Clear? And the last one, foreign venture capital investor. Foreign venture capital investor, simply he will come and invest in businesses which are startups in India. Venture capital, what is venture capital? If I go propose a who are the venture capitalists in India? Famous venture capitalists, Shark Tank. What are they doing? They are doing venture capital business. They are sitting here, they are sitting in that concerned show, they are listening to some startup ideas and some innovative ideas of a business and they will invest in that startups. They are called venture capitalists. Now if that venture capital is a non-resident, he should get registered himself as a foreign venture capital investor and then he can make investment in the startups of India. Okay, I hope I'm clear with these 4 definitions. Foreign direct investment, investment in business. Foreign institutional investor, investment made by mutual funds, pension funds, insurance companies registered with SEBI in the form of, where in financial markets, that is trading of shares, stocks, bonds everywhere. Okay, next. Foreign portfolio investor includes individuals and institutions and they can invest in financial markets. Okay, next, foreign venture capital investor, investment is made in startups in business. So that is why, in order to understand person resident outside India, I have finished that definition and then I have came here. Next, foreign currency convertible bonds. You will come across this concerned word frequently, so listen it carefully. Foreign currency convertible bonds are bonds, of course, Bonds are called bonds. Yes. What are bonds? Debt instruments. That means they are not giving us any ownership in the business. They are simply debt instruments. Okay. Issued by whom? Indian companies. In what format? In foreign currency. To whom? To non-residents, in the form of principal and interest payable in foreign currency. So, if a non-resident, non-residents want to purchase shares of an Indian company, he can't directly come and trade in Indian stock exchanges. It is prohibited. Trading in Indian stock exchanges without permission is prohibited. Clear, everyone? So what will they do? In order to easily facilitate and get money from foreign, what the companies will do is they will issue bonds, debt instruments. To whom? To non-residents, in the form of foreign currency. Why in the form of foreign currency? They can easily purchase, no? If they have to purchase Indian shares, what they have to do? They have to convert their money in Indian rupees. They have to come trade in the concerned stock exchanges in India, which is prohibited. It's not possible. So that is why what happens? Indian company will simply issue foreign currency convertible bonds in the form of foreign currency, which are debt instruments to non-residents, and their income and also redemption is also done in the form of foreign currency, because their income generation should be done in the form of foreign currency. No, not only the payment initially, but also the income should also be generated in the foreign currency for easy, in order to make an easy investment. Clear? Okay. Then why is it called convertible bonds, madam? Because very simple, later on after maturity period, they could be converted into equity shares. They will have the option to convert into equity shares or become the owners of that concerned Indian company. Clear? So that is why it's called foreign currency convertible bonds. What are those again? Bonds which are debt instruments issued by Indian company in foreign currency to non-residents, and the income, that is the principal amount and the interest, is payable in the form of foreign currency, and later on they could be converted to equity shares. Now, investment in repatriable basis. What do you mean by repatriable basis, madam? Repatriate means taking back the funds. Let's understand with this concerned pictorial presentation. See this. Non-resident is there. Follow the arrows. Non-resident is making an investment in an Indian company or purchasing an Indian asset. Now, the income that is generated in the shares, or income that is generated from the Indian assets, that is the income, dividend, interest, rent, and also the capital appreciation, all sale proceeds. What happens here? His income, he's generating income in India in the form of dividend, interest, rent, capital appreciation, sale proceeds. Now, if that income which is generated in India is taken back to their home country without any restrictions, it is called investment in repatriable basis. That means the funds can be repatriated after the income is generated. That is called investment in repatriable basis. Very simple. If a non-resident comes and invest in an Indian company, now he generates some funds. So is there any rule that he should definitely utilize the funds he generated in India only? He can't take back the funds. No. He can take back, but he has to make the investment in repatriable basis. Clear? There will not be any restrictions on utilization of that foreign currency. Of course, you have to pay the tax. Clear? Okay. Now, what is non-repatriable basis? Very simple. The income that is generated from the shares of an Indian company or an Indian asset, that money cannot be utilized outside India. Even 1 rupee also, a non-resident who has generated through investment made in non-repatriable basis, can he take outside India? No. He has to spend, or rather invest again in India only. He can't take back to outside India to his home country. I hope I'm clear. Okay, so first one is investment in repatriable basis. The income generated by investing in Indian company or by investing in Indian company can be taken back to their home country without any restrictions. But here, if made on non-repatriable basis, money cannot be utilized outside India, and you have to use it for expenses in India or investments in India. Okay, so why are we learning this definition? Restrictions will be there in unit number 2 and unit number 3, and you will use the word repatriable basis and non-repatriable basis. That is why you're understanding the definition in the first unit. Okay, done. And the last definition, person of Indian origin. Person of Indian origin. Who is this person of Indian origin? Very simple. He is not an Indian citizen. Indian citizenship you will get if you're born in India. Okay, but he is not born in India. He is not a citizen of India. Now what happens? He will be called as person of Indian origin if at any point of time he is holding Indian passport. What is it? He has held Indian passport at any time, he will be called as person of Indian origin. He has parents or grandparents who were Indian citizens. So parents and grandparents were born in India, but that concerned son or grandson is born outside India, he is not an Indian citizen, he will be called as person of Indian origin. Okay, and the citizen of country, that person is not a citizen. Okay, now is the spouse of an Indian citizen or a person of Indian origin. So your husband is a person of Indian origin when you are a citizen of India or person of Indian origin. Okay, I am a non-resident. Okay, imagine Mrs. R is an Indian citizen. Indian citizen. Since the last 10 years, Mrs. R is staying in USA. Okay, now she married Mr. R. So will Mr. R be called as person of Indian origin? Yes, because his spouse, that is his wife, is an Indian citizen. So that is why he will be given the status of person of Indian origin. Okay, simple. Another way of understanding this, Mrs. R is not an Indian citizen, but rather parents are Indian citizens. Now that is why due to her parents, she got the status of person of Indian origin. Now Mr. R is the husband of Mrs. R and she is a person of Indian origin. So will he be called as person of Indian origin? Yes. I hope you understood. The spouse of Indian citizen or spouse of person of Indian origin will also be called as person of Indian origin. Remember, there is an exception here. So person of Indian origin status will be given to any citizen of any country, but not for citizens of Pakistan and Bangladesh. So if you are a citizen of Pakistan or Bangladesh, you will not be given the status of person of Indian origin. Clear? Even if you have held Indian passport, has parents of Indian citizen, or your spouse is Indian citizen. Okay, I hope I'm clear. Now we are done with the definitions. That is, section number 1 is done and section number 2 is done. Now let's move on to section number 3, which is restriction in dealing in foreign exchange. That means section number 3 states 4 restrictions for persons whom FEMA is applicable. These 4 restrictions will be there in dealing in foreign exchange. That means these 4 restrictions will be implied if you are involving yourself in foreign exchange transactions. What is the first restriction? You cannot trade or give foreign currency or transfer foreign investment to anyone. Madam, FEMA is telling that everything is permitted unless and until restricted. No, here it is restricting everything. There is a twist involved. So here in my handwritten notes, I have not included the actual sentences of the Bare Act for section number 3. Those actual sentences are there in the concept book. So that is why I'm telling, depending only on handwritten notes for other laws is not the game. You have to refer both concept and handwritten notes. Keep that in mind. For company law, my handwritten notes alone is enough. But for other laws, you have to refer both my concept as well as the handwritten notes. Okay. So what is the first restriction given here? Deal in or transfer any foreign exchange or foreign security. What is a foreign security? Expressed in foreign currency, but the income is generated in Indian currency, to any person not being an authorized person. So if you are dealing, that means making payment or receiving payment or importing goods, exporting goods, selling a security, purchasing an investment without an authorized dealer in between you and the non-resident, that is restricted. But if there is an authorized dealer between you and you are passing the transaction through the authorized dealer, then it is permitted. Let's understand with a very simple example. See, I am an Indian company and I am trying to import machinery from Germany. If I'm trying to import machinery from Germany, I can pay them in Indian rupees? Not at all. I have to pay them in their currency, euros. So what I will do, if I go to an unauthorized dealer in some old city, in a very shady area, and I'll exchange the rupees with euros, and simply I'll pay the euros to German supplier, can I do that? It is restricted. So if I go to an authorized bank, that's the authorized dealer, and exchange my rupees with euros and make the payment to German supplier, then it is permitted. But unauthorized, through an unauthorized dealer, if I'm initiating the transaction, it is restricted. Clear, everyone? So that is the first restriction. Now let's move on to the second restriction. What is it? Not allowed to send money to a non-resident. You are not allowed to send money to a non-resident. What is this, madam? Again you are telling you are not allowed to make payment. How is it? It's Foreign Exchange Management Act. Everything should be allowed, no? Here also again the twist is, make any payment to or for credit of any person resident outside India in any manner, otherwise through an authorized person. So through an authorized person you are making a payment to a person resident outside India, it is permitted. Clear? Here also see, Akash is sending money to his son Vinay for the person who is studying abroad. For the education, he is sending the money to his son Vinay, who is person resident outside India. Can he do that through an authorized dealer? He is permitted. If he directly send money without informing the authorized banker, can he do that? No, he cannot do that. Clear, everyone? So what is this through authorized dealer, madam? Like, how can I make a payment? For example, your son is an Indian citizen. He recently went to US, but he has an account with the Google Pay. Yes, his UPI ID is registered. He has Google Pay in his phone. You also have Google Pay in your phone, so you can send money to him. Can you do that through his account? So he will exchange that in in US he will exchange that rupees in dollars. Can he do that? No, that is only called unauthorized transaction. If you want to send money to your son who is residing outside India, you have to first go to an authorized person, that is the authorized dealer, also known as authorized dealer banks. You have to tell that I am sending this amount of money to this son who is residing in this country for this purpose. You have to mention more details, and then you can do that. You don't need to take permission from RBI or government to do that, but you have to inform the transaction to that concerned bank who will initiate the foreign exchange transaction. So that is what it is called. Restrictions are put in so that the flow of foreign exchange, how much money is going outside from India, how much money is being entered into Indian foreign exchange, that has to be noted with the authorized bank properly. So that is why even a single rupee of Indian currency without a channel of authorized person cannot go outside India. So that is restricted. Clear, everyone? So that restrictions has been mentioned in the section number 3. Okay, so first one is deal in or transfer any foreign exchange or foreign security to any person not being an authorized person. Next one is making payment to or for the credit of any person resident outside India in any manner other than through an authorized person. That is the second restriction. Coming to the third restriction, receive otherwise through an authorized person any payment by order or on behalf of any person resident outside India. See, on behalf of a person resident outside India, if you are receiving payment or you are receiving payment for your services or sending goods, so can you do that through without an authorized channel? You can't. Let's understand with the handwritten notes. See this, you are not allowed to receive money from someone living outside India. Example, see this, Vinay is a freelance software developer. Okay, so he is a freelance software developer. He will provide software services. He will develop a software and he will send that to a foreign client. Now what happens? Software is developed online, it's shared online. So how will this person, how will the concerned government know that there is a foreign exchange transaction going on? It will not know. The flow of currency is still happening. So in order to know the flow of currency, they are restricting such transactions which are direct transfer of money to a person residing in India is prohibited. You have to do it through an authorized channel. So if you are a tax consultant and you are providing services to a US client, what he will do, he will not directly send you money. What he will simply send you through a bank account. Let's say Axis Bank or ICICI Bank. Axis Bank, ICICI Bank, all these are authorized dealers. They are authorized by RBI to deal with foreign currency. What happens? Your US client will send dollars to your Axis Bank account. Axis Bank is an authorized dealer. Now, is that transaction permitted? Is it allowed? Yes, you can do that. Should you inform RBI regarding that? Not at all, because it is permitted if it is through an authorized dealer. Clear, everyone? Okay, so direct transfer is restricted. Through a bank that is authorized person, it is permitted. Clear? Not normal bank, but the bank which is registered with the RBI as an authorized dealer, then only it is permitted. Clear? Okay. So third one also we are done. Receive otherwise through an authorized person any payment by order or on behalf of any person residing outside India in any manner. Okay. Now coming to the fourth restriction. What is it? Just a detailed explanation is needed for that, because you will get confused. Okay, see this. Let's read the provision which is given in the BEAR Act. Enter into any financial transaction in India as consideration for or in association with acquisition or creation or transfer of right to acquire any asset in outside India by any person. Did you understand anything? No, not at all, madam. That is why we are leaving FEMA, madam. I'm here. I'm there for you. Let's understand this. See, the restriction is simply stating that you cannot engage in any financial deals in India. What is it? You cannot engage in any financial deals in India if those deals are related to buying or investing assets outside India. Still didn't get it? I know. So that's why example is there. Let's see. So Arha is running a business, okay, and it wants to expand and acquire a factory in Vietnam. So Vietnam is a nation, okay. So she went to a foreign tour to Vietnam. She saw a good place where she can establish a factory for expansion of her business, and now she wants to purchase that manufacturing unit. Now what she wanted to do? Very simple. She went to an Indian bank which is not an authorized dealer, or it may be an authorized dealer, but it has mentioned that I am trying to enter into this project. I want to acquire this manufacturing unit. So please provide me a loan for this project. So she did not mention that this is for a foreign exchange purpose. She just mentioned that I want to expand my concerned business and I want to acquire a manufacturing unit. So please provide a loan. Now what happens? She has entered into a financial deal in India for the purpose of buying an asset outside India. So this loan amount she is utilizing to purchase or to for a capital account transaction outside India. Can she do that? No. So if you are procuring loan for purchasing an asset outside India, you have to procure a loan from an authorized dealer. If you procure a loan from a normal Indian bank for the purchase of asset outside India, then it is prohibited. Clear, everyone? So if you read this again, you will understand. Enter into any financial transaction in India as a consideration for the payment or for an association with acquisition, creation, transfer of right to acquire an asset outside India by any person, then it is prohibited. Clear? You enter into a financial transaction in India for the purpose of acquiring an asset outside India. Can you do that? No. You can enter into a financial transaction with an authorized dealer for the purpose of acquiring the concerned asset from outside India. That is permitted. But normal Indian bank, if you go and purchase a loan and you don't give the details that you're doing it for foreign exchange transaction, that is prohibited. Clear? So these are the 4 restrictions which are there in the Foreign Exchange Management Act 1999, section number 3. Let's just quickly read out the sentences for us. Deal in, transfer any foreign exchange or foreign security to any person not being an authorized person. Second one, make payment to or for the credit of any person resident outside India in any manner. Third one, receive any payment otherwise through an authorized person on behalf of any other person in any other manner. Now fourth one is enter into a financial transaction as a consideration or in association with acquisition, creation, transfer of right of an asset outside India. Clear? So remember this 4 sentences. Very simple. Okay. So this is section 3. So in the past attempt, June 2024, section number 3 and section number 4 combined together have been asked for 7 marks. So you can't ignore this. So first chapter, what is the important question I say is, first things first, the definition of person resident in India. 3 types of definitions: individual, incorporated in India, and the next one is agency, office, yes, branch. Okay, so first is person resident in India, second one is section number 3, section number 4, because these have been asked in the past question papers. Okay, now moving on to the section number 4. What's the section number 4? Restriction in holding foreign exchange. Previously was dealing in foreign exchange, making payment, purchasing goods, selling an asset. This is holding foreign exchange. What do you mean by holding foreign exchange? Holding the asset in your name. So can you hold a asset which is located outside India as an Indian with your name as the owner? Can you do it? Let's see in the section number 4. What is the heading? Restriction in holding of foreign exchange. I've already told you foreign exchange not only include foreign currency but also credits, deposits, payables in foreign currency, and some and the remaining. Yes, drafts, traveler's check, drawn. Yes, drawn by a person resident in India, drawn in Indian currency, payable in foreign currency. Okay, so all these are also forming part of the word foreign exchange. Okay, now let's move on to section number 4. What is the general restriction provided in section number 4? General restriction, simple. No Indian resident is allowed. No Indian resident is allowed to acquire, purchase, hold, own, possess or transfer any forms, foreign exchange, foreign security or immovable property located outside India. Not only foreign exchange, that is deposits, travelers checks, bills of exchange, letters of credit, and travelers check. Not only those, foreign security, immovable property located outside India. So you as an Indian resident, as per section number 4, are restricted to acquire, hold, own, possess, transfer foreign exchange, foreign security, immovable property located outside India. There is a twist at the end, unless it falls under certain exemptions provided down below. What are the exceptions? We will see. I hope you understood the general restriction. Indian resident cannot involve himself or cannot hold or purchase or transfer foreign exchange, foreign security and immovable property located outside India. That is a foreign asset. Okay, unless and until it's provided in the following exceptions. So what are these exemptions? Exemption number 1, you are holding a property. Okay, so property is held outside India. Okay, good. By whom? A foreign citizen. He is born and brought up in some foreign country, but for some purposes now he became resident in India. Previously, when he was a foreign citizen, he is acquiring some asset outside India. So is it prohibited? No, it is not restricted under the section number 4. So you can hold a property outside India if you are a foreign citizen who is resident in India, foreign citizen but resident in India. You can do that. Okay, and next, property has been acquired. That means you have acquired property because, you have acquired a property on or behalf or on that 8th July 1947 or before 8th July 1947. Then it can be held with the permission of RBI. What is the significance of 8th July 1947? If it is a face-to-face class, I would have asked you, but it's an online class, so I'm telling it by myself. It is the day of partition of India and Pakistan. So if you had few assets in Pakistan or Pakistan citizen had few assets in India, okay, what happens? That's your own asset, right? So you can't lose that due to this partition. That is your property. You have to hold that. So because of this particular matter, if you are holding an asset, okay, see, property acquired by a person on 8th July 1947 or before 8th July 1947 and it is held with the permission of RBI. Here simply you can't, as an Indian resident, simply you can't hold a property in Pakistan because it was there since partition. You can't do it. You can hold the property only with the permission of Reserve Bank of India, RBI. Okay, so the first exemption is, as a foreign citizen resident in India, I can hold a property outside India. Here I have acquired the concerned property on or before 8th July 1947 and I am holding the property with the permission of RBI. Then it is not restricted. Next, third exemption is, property has been acquired by way of gift. That means someone has gifted me or someone has inherited. Inheritance means maybe from my mother, maybe from my father or my grandparents. I have received a property which is outside India. So who can give the gifts or assets, gifts or inherit me that concerned property is the following two persons. So if I have received a gift, I have received a property through a gift or inheritance from a foreign citizen who is holding a property outside India and resident in India, it is allowed. Or from a person who has acquired the property due to partition and held with permission, he is giving me gift or he is inheriting me the property, yes, I can hold it. Clear? This is the third exemption. Gift or inheritance from the above two persons. And the next, last exemption is, property purchased out of funds held in resident foreign currency account. So resident foreign currency account, what is this account, madam? So previously I used to be in an employment in Canada. Now what happened is, I worked there for around 12 years and recently I have come settled in India. Now I will be earning a lot of money in Canada. Yes, I will be holding those funds in Canadian dollar. If I want, I can immediately exchange the Canadian dollars to Indian rupees and I can transfer the amount to my Indian bank account. But what is the advantage of holding it? Maybe after a while, Canadian dollar will appreciate or Indian rupees will depreciate, and if I sell, I will receive more money. Yes, that is why few persons will hold their foreign currency earnings which they earned during residing while they are residing outside India, and that will be reserved in a separate account in India, that is called resident foreign currency account. That account will contain amount in foreign currency which has been earned by the resident while he was residing outside India. Okay, so Now, understood the meaning of resident foreign currency account. I am a resident. Previously, I used to be working in some other country. I've earned some money. Now, I am saving that money in the form of foreign currency in resident foreign currency account. Now, if I will use that resident foreign currency account funds to purchase or procure asset outside India, then it is permitted. Clear? See, property purchased out of funds held in resident foreign currency account is permitted. Okay, so general restriction under section number 4, what is it? No resident Indian is allowed to acquire, hold, own, possess or transfer foreign exchange, foreign security, immobile property located outside India unless it falls under the certain exemptions provided under. What are the exemptions? Property held outside India by whom? Foreign citizen who is resident in India allowed. Foreign property acquired by a person on or before 8th July 1947 and held with the permission of RBI, it is permitted. And the next, property is acquired by way of gift or inheritance from the following two persons. Yes, it is permitted. And the next, property is purchased out of funds held in resident foreign currency account, RFC account. So these are the 4 exemptions for the general restriction provided in the section number 4. This is the same text which is given in the concept book as well. Excuse me. So yeah, what is it? General restriction: no Indian resident is allowed to acquire, hold, own, possess, transfer foreign currency, foreign exchange, foreign security, immobile property located outside India unless it falls under certain exemptions provided by the relevant rules. Okay, and exemptions: held by a foreign citizen resident in India, acquired on or before 8th July 1947 by way of gift or inheritance from the persons referred above, and the last one, purchased out of funds held in the reserve resident foreign currency account. So the definitions part we have already seen through handwritten notes. You can just refer the concept book, you will be easily able to understand. Okay, and then coming to the next section, what is it? Section number 5, current account transactions. Everyone know this. Yes, they only read current account transactions and capital account transactions and think that FEMA is done. Absolutely wrong, because that's not there in your syllabus as a CMA final student. For CA inter students and CA final students, and old syllabus CMA final has details regarding the current account transactions, permitted, restricted, limits and everything is there, but for you not there. If you understand the basic meaning, well and good, done. Okay, so what is the basic meaning of current account transactions? Irrespective of FEMA and all, you are a CMA student, right? So what is a current account transaction? Current assets rather. What are those? Involves payment for goods and services, interest payments and remittances. Very simple. These are everyday transactions that do not affect the assets and liabilities of the country. So these do not involve purchasing of an asset, making investment, receiving investment, or procuring a loan or giving a loan, or remittances, huge remittances. These are not called as current account transactions. Rather, these are called as capital account transactions, because they involve the changes to these assets and liabilities of the countries. So current account transaction simply involves payment for goods and services, everyday payments, interest payments and remittances, sending money. Okay, so this is the basic meaning of current account transactions given to you. Okay, now so what are the current account transactions permitted under the FEMA? What are the transactions which are prohibited under FEMA? Is it there for you? No. Simply schedules are there for you, and what transactions are prohibited under which schedule are only there for you. So foreign exchange management current account transactions rules 2000. who has the power to make rules under Foreign Exchange Management Act under section 46? Ministry of Finance has the power to make rules. So directly in the FEMA 1999 primary legislation, these rules are not there. Separate rules have been provided by the Ministry of Finance. So this rules says that the current account transactions are divided into 3 schedules: schedule number 1, schedule number 2, and schedule number 3. What is the relevance of these? Very simple. Schedule number 1 contains transactions which are completely prohibited, not allowed at any circumstance. And here basic example, these examples are also not there in your book, but simply for an idea I am telling you. Example, this lottery winnings, racings, proscribed magazines. What do you mean by proscribed magazines, madam? You have wrote a spelling wrong and you are pronouncing wrong. It is prescribed. No, my dear, it is proscribed only, which means banned magazines. Magazines which are banned by the government, that means you should not purchase that magazines, or rather invest in publishing of that magazines. Banned magazines. Example, magazines which promote terrorism ideas, promote pornography, or whatsoever it is. So those are called proscribed magazines. Okay, so involving yourself in the transactions which are lottery winnings, racing, proscribed magazines, etc. is completely prohibited under Schedule 1 of the FEMA Rules 2000 for current account transactions. Okay, so Schedule 1 contains completely prohibited transactions. Now, Schedule 2. Schedule 2 contains transactions which are allowed, but you need the approval from RBI. You need the approval from RBI. Okay, so what are those kind of transactions? What are the examples, madam? Cultural tours. So if you are a business organization and you are promoting your concerned, what do you say, product or your service through tours, big concerts in some other country, like cultural tours, not only a private organization, also state government or some government organizations are going outside India conducting concerts and tours, cultural tours to promote their products or services. For that you need the approval of RBI. And another example is advertisement in foreign print media. What is it? Advertisement in foreign print media. So if under Schedule 3, if you want to do a transaction which is prescribed under Schedule 2 of the FEMA 2000 rules, current account transactions, then it should require RBI approval. Clear? Schedule 2 transactions require RBI approval. Schedule 1 completely prohibited. Now coming to Schedule 3. What is it? Schedule 3, all the transactions are permitted. You don't need any approvals also, but there is a twist. There is an upper limit. What do you mean by upper limit, madam? For example, for this concerned activity, you can spend up to $10,000 without any restrictions. But if you want to spend more than $10,000, then you require an approval from the RBI. That kind of transactions are there in Schedule number 3. See, have an upper limit, the amount or a boundary which has been set in the terms of amounts, that this much amount, more than this cannot be spent. Okay, see, having an upper limit on the amount of foreign exchange that can be used. So example, very simple, up to $250,000 you can make payments for the current account transactions of medical expenses, studies abroad, tours, etc. Okay, so this is an example. Now what happens, madam, if a transaction that I want to do, transaction that I want to do is not listed in the above 3 schedules, then am I allowed to make that transaction happen? Yes. See, if transaction is not listed in the above 3 schedules, then it is permitted without any limits. Here in the 3rd schedule, it is freely permitted, but there are limits on how much amount you have to spend. Here, there is no limit, but they are not freely permitting also. You can do it, but you require approval from the RBI. Here, completely prohibited. That means you just can't go to RBI and ask approval for the Schedule 1 transactions, because it's completely prohibited. Even if anyone gives permission, even if you create fake documents of permissions, you can't do that concerned transactions which are prescribed in schedule number 1. Okay. So what are current account transactions? Current account transactions involves payment for goods and services, interest payments, remittances, etc. Everyday transactions that do not affect the assets and liabilities of the country. So this current account transactions, as per the rules 2000, have been divided into 3 schedules. Schedule 1 specifies the transactions which are completely prohibited. Schedule 2 specifies the transactions which require the approval of RBI. Schedule 3 specifies the transactions which have an upper limit but freely permitted up to the upper limit. But if any transaction which is not listed in the above 3 schedules is completely prohibited, freely permitted without any limits. Okay. I hope you understood section number 5. That's all with the current account transactions. You're done. Nothing much is there in your study material also. Okay. See, that is what I have given you in the concerned concept book as well. Current account transactions involve payment for goods and services, interest payments and remittances. These are everyday transactions. Do not affect the assets and liabilities. Okay. The foreign exchange management current account transactions rules 2000 outlines the transactions, how the transactions are managed. What did they do? They have given 3 schedules with the rules. Schedule 1 completely prohibited. Schedule 2 require approval, example cultural dues, advertisements, and Schedule 3 lists the transactions that have an upper limit on the amount of transaction that can be used for the purpose of those Schedule 3 transactions. And if a transaction isn't listed in this schedule, there are no limits on the amount of foreign exchange that can be used. Okay. Now moving on to next, section number 6. What is section number 6? Capital account transactions. So section number 6 talks about capital account transactions. So what is capital account transactions? Completely opposite to current account transactions. Those transactions which affect the assets and liabilities of the country. That's all. See, involves changes in ownership of assets and liabilities like investments, procuring loans, transfer of ownership of assets. So these all come under the category of capital account transactions. So those involves changes in the ownership of assets and liabilities will be called as capital account transactions. Simple. Now, what is provided? What else is provided in section number 6? Only the meaning? No. Of course, we have to tell, is it restricted or permitted? General permission. What is general permission as per section 6? Any person. That means individual, HUF, company, AOP, BOI, office, agency, every person under Foreign Exchange Management Act can buy or sell foreign exchange from an authorized person for capital account transaction. They did not tell directly you can do a capital account transaction. How did they twist the general permission? They said you can buy foreign currency or sell foreign currency from an authorized person for the purpose of capital account transactions. That means you can procure foreign currency from an authorized person for capital account transaction. That is a general permission given under section number 6. Okay. So now, what is RBI's role? As per this general permission, RBI with the help of central government will decide which capital account transactions. General permission is there, no, but for general permissions, of course, exceptions will be there, restrictions will be there, prohibitions will be there. Who has the right to do that? RBI with the help of central government decides which capital account transaction shall be allowed, which capital account transactions will be restricted, and for which transactions limits will be set on the amount of foreign exchange that can be spent or that can be received. Clear, everyone? So generally, what are the capital account transactions which are allowed? What are restricted? How much amount is allowed? Who can do that? Who is eligible to do it? Who is not eligible to do? All that nonsense is not there for you. Simple. What is the general permission as per section 6? Any person can buy or sell foreign exchange from an authorized person for the purpose of current account transactions. Yes, restrictions and permissions will be there, but those will be decided by RBI with the help of central government. It will decide which capital account transactions will be allowed, which capital account transactions will be restricted, and for which limits will be set. Okay, but for the purpose of two transactions, RBI cannot impose restrictions. What are those transactions? Loan repayment or depreciation of asset in regular business activities. Very simple. You've already procured a loan from outside India, and for repayment of the loan, that is a capital account transaction because it involves a lot of money and it will disturb the assets and liabilities, yes. And for making interest payments comes under current account transactions. Just remove that. Amortization, what do you mean? Payment of principal of that loan over the period of that life, yes. So that amortization of that concerned loan or loan repayment or depreciation of the asset. So for this capital account transactions, RBI is not allowed to impose restrictions. This can be freely done by any person in India. Okay, but why depreciation of asset, madam? Because it's a regular class. I will explain you what is it. So I have already purchased a machinery from outside India. Okay, so very simple. Now, Indian company, there is a company A. Okay, for this company A, there is a manufacturing unit, and in this manufacturing unit, the major role played is by this machinery B. On this machinery B, a foreign non-resident made investment and has invested in the form of that machinery B in the company A. That means this machinery has been brought by whom? By that non-resident. Okay, who has funded for this machinery? This non-resident has funded. Okay, now this is simply foreign direct investment only. Okay, now what happened is a new technology has been implemented in India and this machinery usage has become null. That means this is no longer used. This became obsolete. That means it will no longer be of some value. For example, usually this value is $100 million. Because of some new technology, people are simply selling off these assets for $10 million because they don't need them. Now what happened? This person's investment has been depreciated. In order to make fresh investment, because there is depreciation, you need to support the organization because your contribution should be done, right? So if you do that due to the depreciation of an asset, that is permitted, because procuring an investment from outside India comes under capital account transaction only. Okay, capital account transaction. So this concerned transaction due to depreciation of asset is permitted under the section number 6 capital account transactions, not directly permitted, but rather RBI cannot impose restrictions on that concerned transactions. So even if you did not understand this example, please just ignore it. This is a very small exemption. Okay. Now, so what are the two transactions on which RBI cannot impose restrictions? Loan repayment and depreciation of asset in regular business activities. Okay, fine. Now, that is the general provisions for the capital account transactions, meaning and the general permission. What is it? Any person can buy, sell foreign exchange from an authorized person for capital account transactions. What is RBI's role in this? Who will decide which are allowed, restricted and set limits are the RBI with the central government. Two particular activities it cannot impose restrictions on: loan repayment and depreciation of asset. Okay. Now, additional provisions related to the Foreign Exchange Management Act. What is the first provision? Person resident in India can hold, own, possess transfer foreign currency, foreign security and for property, immobile property outside India if it is acquired when he is residing outside India. See, as per section number 4, general restriction is, as per section number 4, see, what is this? As per section number 4, what I told you, general restriction, no Indian resident can acquire, hold, own, possess, transfer, foreign exchange, foreign security, immobile property. Yes. Here in additional provisions, one more exemption is given. What is this one more exemption? See this. Person resident in India can hold, own, possess, transfer foreign currency, foreign security and immobile property outside India if acquired when he is residing outside. Simply he is a resident in India only, but he went outside India for a certain period of time. At that point of time he has purchased the asset while he was residing outside India. He is still a resident only, but when he was residing outside India he purchased that asset. Can he do that? Yes. Okay. And if he has inherited from a person resident outside India, simple, I've already told you, if it is inherited from a person who is holding property, who is a foreign citizen or who has acquired due to the partition, is it permitted? Here also the same limit, same exemption is given. If it is inherited from a person resident outside India, yes, he can hold that asset. Okay. And the next, if foreign exchange or income from such assets which are held outside India is generated and that assets have been inherited from a person who lived outside India. See, very simple. You can hold the asset, you can transfer the asset if you have acquired while you are residing outside India. Okay. At the same time, if you have inherited from person resident outside India. At the same way, if you have an asset which is held outside India, that is held because you have inherited from a person who used to live outside India. That may be a person resident outside India or person resident in India, previously a foreign citizen. You can link this with a section number 4. Yes, if from that asset if you generate any income, that is also permitted. Clear everyone? Very simple. These are additional miscellaneous provisions of the FEMA 1999. With the section 6 we have completed the provisions regarding the FEMA. Okay. Now those are the two additional provisions regarding the holding of assets, which are foreign security, foreign exchange, foreign currency, foreign property, immobile property located outside India. You can hold, you can generate income only if you have inherited from a person resident outside India, if you have inherited from a person who lived outside India, or if you yourself have acquired that property while residing outside India. Okay. Next, two additional provisions are there more. RBI may direct exporters. Who are exporters? The persons who export goods or services outside India. That means selling goods to a person residing outside India. Simple. So RBI will give directions to exporters. Which kind of exporters and why? To ensure they receive the full payment for the export or the reduced value based on the market conditions without delay by giving instructions. Very simple. Take a scenario. I am an exporter. Okay. Now, what happens is I have to receive money. I'll explain with the example. So, Mr. B is an exporter who has exported few goods worth $100 million to a person residing in United States. Okay. Now, as per their agreement, he has to receive the amount. He has to receive the total amount by, let's say, 8th July 2025. Okay, 8th July 2025. At the time of agreement, what happened is the value of dollar to rupees, $1 is equals to rupees 80. Okay, now what will that person be, what will he be in a perception? Simply, I will be receiving around 80 into 100 million rupees. Yes. Now what happened is, on 8th July, the US dollar value has depreciated very badly due to some, you can say, recession or some other economic instability. What happened is, on 8th July 2025, the US value is around 40 rupees only. $1 is equals to 40 rupees only. Now what will the supplier receive, the exporter receive? Totally the half amount has been reduced because of foreign exchange fluctuations. Yes or no? So what happens is, that is why RBI is telling that when you are entering into an export transactions with a person residing outside India, please inform me. I will give you directions in order to help you recover the total amount, or else somewhat or the other reduced value based on the market conditions. For example, what kind of directions will RBI give, madam? What happens? In SFM you might have come across hedging contracts. I will hedge foreign currency. That means I will enter into a forward contract. I will enter into a forward contract that on 8th July 2025, I have to receive the dollar value at the rate of 70 rupees at any case. At the worst situation, at least I have to be able to recover 70. So what happens? At least you are not able to recover 80, you will be able to recover at least the reduced value. That is what directions will be given by the RBI to exporter. RBI will say, enter into this hedge contract, or else put a restriction, put a credit period of a lesser value, or else at least accept the reduced payment which is being given. In this situation, if you won't accept $40 also, after 1 month if you delay, it will become 20. Now what happens? You will receive even more lesser amount. At that point of time, what will RBI say? Please leave it. Just at least accept reduced value also. So those directions will be given by the RBI to the exporter. Clear everyone? So RBI may direct exporters that please inform us, so that I will give directions in order to help you recover the total amount, even with the foreign exchange fluctuations also, to ensure they receive the full payment for the export or the reduced value based on the market conditions without delay by giving instructions. Okay, that is the another provision. And the next, service exporters. Who are service exporters? Simply these software services, coding, tax consultancy services. All these are who? Service exporters. All these corporate slaves. 9 to 9 jobs are there, no? They will say in the agreement 9 to 5. What is 9 to 9 job? Sometimes 9 to 2. Midnight 2. Okay, what are these doing? What are these people doing? They are exporting services to a person residing outside India. For example, the software services or tax consultancy services. Okay, so what these service exporters have to do? They must provide RBI accurate details about the payment for the services. Simple. If you are exporting services outside India, you should first provide RBI the details regarding what are the services that you're providing, what is the amount that you have agreed to receive for the services. Those all details should be given to the RBI. Here it is told that service exporters must provide. Here RBI may give directions, because sometimes for every time foreign exchange fluctuations won't happen, but if some cases, very rare cases, huge fluctuations are going on, then what happens? RBI may direct. Here service exporters must provide accurate details regarding the payment for the services. Okay, These are the additional 4 provisions under the Foreign Exchange Management Act. With here we have completed the sections of the foreign exchange management, and we are left with 2 more provisions regarding the FEMA. Okay, so with this, after this 2 more, we will be completing the unit number 1, which is salient features of FEMA. Very soon, 1 page we will be done. Okay, let's start. So before that, we will just simply see the sentences which is in the concept books, because I don't want you to get confused with my handwritten notes and the concept book. See, capital account transactions involve changes in ownership of assets and liabilities. This includes investments, loans and transfers of ownership that I've already told you. Now, what is a general permission? Any person can sell, buy foreign exchange from an authorized person. Yes, from an authorized person for capital account transactions, but must follow specific provisions. Okay, that provisions will be given by whom? RBI, with the help of central government, will decide which type of capital account transactions are allowed, for which we have to set limits, and for which are prohibited. Okay. Now, however, there is an exception. RBI cannot restrict the foreign exchange for loan repayments or depreciation of investments in regular business activities. In your study material, you will come across the word amortization. You can ignore that and you can simply write this, loan repayments. Okay. Now, additional provisions. See, holding assets abroad. Resident Indian can hold, own, transfer, invest in foreign currency, foreign securities, properties outside India if they have acquired them while residing outside India or inherited them from someone who lived outside India. Okay, so next, inherited foreign assets. From that inherited foreign assets, you can generate income. See, foreign exchange or any income from assets held outside India by resident, if inherited from a person, is allowed. Okay, next, export value requirements. The RBI can direct exporters to ensure they receive the full value of exported goods or reduced value based on the market conditions without any delay. That is what we have learnt. And export service export declaration. Service exporters must provide RBI or other authorities with a declaration containing accurate details about payment of these services. Clear, everyone? Okay. Next, 2 more are left out, then we will be moving on to the foreign direct investment unit. Next, possession and retention of foreign exchange. What is it? Possession and retention of foreign exchange. Here we are exclusively talking about foreign currency in the form of deposits, cash, credits, payables, notes, liquid cash. Yes, okay. So, very simple. I am an Indian resident, so can I hold dollars in my purse? Yes or no? That we will read in this concern heading. See, authorized person. Of course, authorized persons is authorized by RBI to deal in foreign currency. Of course, he has to hold foreign currency, no? So he can hold foreign currency within the limits specified by RBI. Okay. Now, what about normal person resident in India? So, coins. No restriction, because some people have the habit of collecting coins from outside India, coins from Europe, coins from Asian US, coins from South Africa, coins from some Saudi Arabian countries. Yes, so coins you can hold without any restrictions. So, ma'am, can I hold like a big bag of coins? Yes, you can do that. Your wish. It is permitted under FEMA. Okay, now currency. What about notes? What about balances in bank account in the form of foreign currency? Can I hold that? Yes, up to a limit notified by RBI. RBI will notify that this category of persons can hold this much amount. This category of persons can hold this much of amount. So, as per limits notified by RBI, you can still hold foreign currency. But for coins, no restrictions. Okay. Now, coming to temporary residents. Who are temporary residents? Simple, they didn't come to permanently stay in India. They're foreign citizens, but they have simply come for some particular task or something, but they'll return again. So, can they hold foreign currency? Yes, they can do it without any restriction. There is no limit There is no notification by RBI, but one thing you have to do is you have to earn that foreign currency while you reside outside India. Previously you used to stay outside India, now you came into India, you have brought into India the money that you have earned in your country in the form of foreign currency. You can do that. First condition is acquired while residing outside India. Second condition is declared to customs. What is it? Declared to customs. That is, while coming in the airport, you have to declare to the customs that I am bringing these many dollars from my country because I am a resident, I am a citizen of that country and I am residing right now, but I need foreign currency to hold. Okay, you can declare that to the customs and you can hold how much ever you want without any restrictions. So these are the provisions regarding possession and retention of foreign currency. Authorized person can hold foreign currency but within the limits specified by RBI. Person resident in India can hold coins without any restrictions. Person resident in India can hold foreign currency up to a limit notified by RBI. What about temporary residence? Yes, he can hold foreign currency without any restrictions, but he should acquire it while residing outside India and he has to declare to the customs. Now, the last provision regarding this unit number 1, what is it? Forms of business. What is it? Forms of business conducted by foreign company in India. We already know what is the meaning of foreign company as per the Companies Act 2013. Company incorporated outside India and having a place of business in India. Yes or no? So what kind of place it has? What is the form of foreign company that is doing business in India? Two categories. First things first, they will totally incorporate a company and get registered themselves under the Companies Act 2013. Second, they will not be registered as a company with the under the Companies Act 2013. Simply they will set up offices. That means registration and incorporation is done in their own country, but simply here they will operate offices. Those are the two forms. Okay, now form number 1, what is it? Incorporate a company which is registered with the Companies Act 2013. So it can be two types. What is it? Joint venture or wholly owned subsidiary. That means you can incorporate a company in India only in two forms. What is it? Joint venture. Second one is wholly owned subsidiary. So 100% of the stake should be held with the foreign holding company. Okay, so example for joint venture is Maruti Suzuki. Maruti used to be a car manufacturing company in India and Suzuki is a car manufacturing company in Japan. Now what happened? Suzuki is like, Indian market is a little attractive, so I want to invest in India, but I have only two options, joint venture and wholly owned subsidiary. Maruti has brilliant idea and brilliant market in India, no? So that's why I'll enter into a joint venture with Maruti Suzuki. That is how Maruti Suzuki has been formed. Okay, yes. Now Google India. So Google India has been established in India as a wholly owned subsidiary. That means 100% of the stake is held by persons residing outside India. Okay, that is an example. Now setting up offices. Here you are not getting registered under the Companies Act 2013. You are simply setting up offices. Okay, like how? Liaison office. What do you mean by liaison office, madam? One more name for liaison office is representative office. Simply it is acting as a communication channel between persons residing in India and its main head office. Example, Mitsubishi Trading Company. Mitsubishi Trading Company has set up liaison office in India. Now what did they do? They are a trading company which will provide this materials for metro equipments and raw materials for the metro constructions. So here the office has been set up simply for communication. What communication, madam? What kind of material is required by this Delhi metro project? So is the material available in the head office or not? So is the consignment being reached or not? Or payments are done or not? So all this communication will only be done with this office. Clear? So that is what one type of office is, without being established under the registered under the Companies Act 2013. Second category is branch office. Simply you can establish a branch. See, Apple Incorporation branch is also established in India. At the same time, Apple India wholly owned subsidiary company is also being incorporated. Two are being done. Apple Incorporation branch office is also there in India. At the same time, Apple India wholly owned subsidiary is also there. Okay, so if you don't want to get incorporated, you can simply establish a branch office for the purpose of business activities, okay, without getting registered yourself as the Companies Act 2013. You don't you don't have the obligation to report to the ROC. Okay, next, third category is project office. Simply for a particular project purpose, you will come to India, establish your project, and you will go off. That's all. Example is Samsung CNT. Samsung CNT has established a project office in India, especially for the purpose of construction of this Bangalore airport new terminal, which is like beautiful right now. So that has been done by Samsung CNT by setting up a project office. They did not incorporate as a new company, but simply they have set up a project office for the specific project. These are the different kinds of forms of organization a foreign company can run business in India. First one, incorporation. Second one, setting up offices. Incorporation, what is the two types? Joint venture, wholly owned subsidiary. Setting up offices, liaison office, also known as representative office. Second one is branch office. Third one is project office. Okay, so this is the syllabus of the unit number 1. Okay, which is Salient Features of the Foreign Exchange Management Act 1999. So here let's just go through the sentences in the concept book. Authorized person, only authorized person like banks and licensed money exchanges can hold foreign currency within limits specified by RBI. Foreign coins, anyone can possess foreign coins without any restrictions. Foreign currency limit, residents of India can retain foreign currency up to a limit notified by the RBI. And next, temporary residents, people living in India temporarily but not permanently can keep foreign currency without limit. Okay, without limit, but they have to acquire while they are living outside India and declare to the customs when brought into India. Okay, here again I'm not explaining because I've already explained using my charts. Simple. Okay, done. Last, concept number 13, forms of business conducted by a foreign company in India. What are those? Incorporate a company under the Companies Act 2013. Two categories, joint venture, wholly owned subsidiary. Set up offices, 3 types, liaison office, representative office, project office, branch office. Liaison office is a communication channel, project office for specific projects, branch office for business activities. Done. I hope you have understood the unit number 1. Here we have seen introduction, importance, evolution, FERA versus FEMA, applicability of FEMA, that is the section number 1, and structure of FEMA. And then we have seen section number 2, important definitions, foreign exchange, authorized person, foreign currency convertible bonds, foreign direct investment, foreign institutional investor, foreign portfolio investor, foreign venture capital investor, foreign security, investment on repatriable basis, person of Indian origin, person resident in India. And then we have seen section 3, restriction in dealing in foreign exchange, section 4, restriction in holding in foreign exchange, section 5, current account transactions, section 6, capital account transactions, and then we have seen possession and retention of foreign exchange, and last, forms of business conducted by a foreign company in India. Usually in my offline class, what I do is I'll revise this again in detail to them, but this is an online recording class. You have the option to go back and listen to the video again. So go back and listen to the video again if you don't understand a particular concept. Okay, since it's a theory, the more number of times you listen to the video, you will be able to retain the content much more effectively, I have to say. Okay, so let's move on to the next unit. So don't be in a perception that it is taking a long time. Unit number 1 and unit number 2 will take a lot of time. 3 and 4 will go very fast, because the main reason 1 and 2 we are establishing a foundation by learning the meaning of very simple terms. There we will simply move on with the concepts because we already know most of the meanings. Okay. Now let's start with the unit number 2, which is foreign direct investment. So unit number 1, we have discussed very basic concepts regarding the definitions, the meanings, and the evolution of the Foreign Exchange Management Act 1999, and then we have seen the sections. Section number 1 talks about the applicability, extent, commencement, and then section number 2, of course, the definitions. Section number 3, we see the restrictions on dealing in foreign exchange. Section number 4, restriction in holding foreign exchange, and section number 5 talks about current account transactions, and section number 6 talks about capital account transactions. So, and then we have seen 2 other more provisions, which is possession and retention of foreign exchange regarding the notes, coins and all. And then last, we have seen the forms of business organization established by a foreign company in India. So I hope we are clear with this. Even if you have any doubts, please go back and listen to that particular concept again. You will get clarity regarding that. Okay. So let's move on to this unit number 2, which is foreign direct investment. So as a professional or as a person who wants to learn about the foreign direct investment, what are the rules, what are the regulations, and what are the procedural aspects, what are the provisions given related to the foreign direct investment, the first thing, we have around 2 documents to check. Number 1 is the FDI policy, which is released by the Department for Promotion of Industry and Internal Trade. Number 2 is the master directions released by the RBI. I've already told this, we have already discussed in the first chapter, which is structure. In the first chapter, one of the concepts, that is structure of Foreign Exchange Management Act. In that structure, we've seen main act, subordinate delegated act, and then we have seen the subordinate act. And then we have seen the master directions, master circulars, FDI policy, notifications and circulars, enforcement directorate. So in that structure, from where should we learn foreign direct investment? 1 is the master directions released by the Reserve Bank of India. 2 is the FDI policy released by the Department for Promotion of Industry and Internal Trade. In your ICMAI study material, before you point out the mistake to me, in your ICMAI study material, just a moment. In your ICMA study material, it has been given that the full form is Department for Promotion of Industry and International Trade, but that is wrong because I will also show you the source also. See, FDI policy, actual FDI policy, which is released by this concerned department. This is the official document. Yes, see this. Ministry for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, Government of India. So this department releases the FDI policy, not international trade. There is no such department existing in India, like as per the Government of India. The FDI policy is simply released by Department for Promotion of Industry and Internal Trade. Then madam, if in the examination they ask the full form of this concerned, they ask an MCQ regarding this full form, what should we write? Try to attempt Department of Promotion of Industry and Internal Trade only, but there is no such option, and there is only an option of Department for Promotion of Industry and International Trade. Then choose that, because as per your study material that is given, but actually the correct one is internal trade only. Okay, so I will also show you the proof in my Safari. In the Safari, I'll just open you. Directly we'll search FDI policy. What is it? FDI policy. There is a site which is displayed right here that you can You cannot see, just a moment. FDI policy 2020. See, DPIIT. Let's click on this. This is the document that I received. Department for Promotion of Industry and Internal Trade. Let's see the official site also. Yes, this is the official site, Department for Promotion of Industry and Internal Trade. Why am I telling you these many times? Because again you will be questioning me in the comment section that you, ma'am, has told something wrong, because in study material it is international trade, it is actually internal trade. So that is what you have to write in your examination. But unfortunately, if an MCQ shows up from this concerned full form and there is no option with internal trade in it and there is only one option regarding the international trade, then choose that, because we need marks ultimately. Okay, so we can't go sit in front of the ICMA, branch and just do some revolt, right? That's for at least for a small full form. So that is why it is Department for Promotion of Industry and Internal Trade. Okay, that's all. Let's move on to the subject. Okay, done. So I've already told you what is the source from where we have to learn the foreign direct investment. Number 1 is the FDI policy. Number 2 is the master directions released by the foreign Reserve Bank of India. Okay, so that is what we are learning in the introduction. FDI policy, the rules and regulations regarding the FDI are taken from the FDI policy, which is issued by the Department for Promotion of Industry and International Trade, which is under the control of Ministry of Commerce and Industry. The rules regarding the Foreign Exchange Management Act, that is the delegated legislation, is issued by Ministry of Finance. Here FDI policy is issued by DPII department, which is under the control of Ministry of Commerce and Industry. Okay, I hope we are clear. Now let's get into the actual meaning of the word foreign direct investment. Let's say a person resident outside India is making investment in the business of Indian company. What do you mean by investment in the business, ma'am? Like, is it purchasing shares? No, not only purchasing shares. It may be a whole new establishment, like a wholly owned subsidiary or a new incorporation with 100% foreign direct investment. That is 100% capital or ownership is in the hands of the person resident outside India. That may be one case. Second case, you are procuring shares or stake in an existing Indian company. That is also called as foreign direct investment. And the third one, joint venture. You're coming into a joint venture with an Indian company and you're starting a business in India. Example, Maruti Suzuki. The Suzuki company from Japan has established a joint venture with Maruti company in India, and they have started this car business, manufacturing and selling. So that is one of the forms of foreign direct investment. And the last one is merger and acquisition. This we already know, merging with an Indian company or acquisition of the whole acquisition of an Indian company. All these are different forms a person resident outside India can make foreign direct investment. It's clear? See, person resident outside India is making investment in business in an Indian company. It may be a new establishment. It may be procuring stake in an existing company. It may be joint venture. It may be merger or acquisition. So this is for the purpose of having a significant influence. What do you mean by significant influence? That means you will have a little control over the management, and also you will have a lot of voting right. That is called significant influence. In as per your Companies Act 2013, it will be 20% stake. Yes, but that provision, don't mix it with this. But the person who is making investment or making FDI will have significant influence in the business decisions and control of management of the company. Okay, so that is what is called foreign direct investment. Okay, so I hope we are clear with the actual meaning of foreign direct investment. It is investment in the business of Indian company. Clear? Next, Now let's understand the meaning or the actual definition of foreign direct investment as per the master directions released by the RBI. So as per the master directions released by the RBI, let's first understand the meaning of foreign direct investment. Foreign direct investment is investment by non-residents, of course, person resident outside India, investment by non-residents in what? First things first, unlisted Indian company. So if as a non-resident, as a person resident outside India, if I make 1 rupee investment or I purchase 10 rupees share, let's say, of course, 10 rupees share in an unlisted Indian company, I will be called as making foreign direct investment. What, ma'am? 10 rupees is also foreign direct investment? Yes. Because that is how the master directions are specifying here. Why? How will you say that, madam? Let's see the second one and then you will get a clarity. See this. Foreign direct investment is investment made by non-residents. First thing is unlisted Indian company. Second one, at least 10% of listed company equity capital on fully diluted basis. So, if in order to call that particular investment made by person resident outside India as foreign direct investment in a listed company, it should meet the criteria. Which criteria? It should be at least 10% of the equity capital on fully diluted basis. But this 10% limit, 1% limit is not there for unlisted company. No, that is why even 1 rupee, 2 rupee investment or else a very small amount of investment in an unlisted company will still be called as foreign direct investment as per the master directions released by the RBI. Okay, so that is the definition of FDI as per the master directions released by the RBI. First things first, foreign direct investment is investment made by non-residents in unlisted Indian company and or at least 10% of listed company equity capital on fully diluted basis. Okay, good. So we have seen the definition of foreign direct investment as per the master directions. Fine. Now let's understand one more definition which is a little bit related to the foreign direct investment only. Very simple. Foreign portfolio investment. Here the intention is not to have significant influence in the company or not to procure control over the management in the company. Simply they are trying to earn profits. So that is why it's called foreign portfolio investment. And this will be done by whom? We have already seen in the definitions part of the chapter number 1, that is unit number 1, foreign portfolio investor who makes investments in financial markets of India. So that is also called as foreign portfolio investment. The person who makes it is called foreign portfolio investor and that investment is called foreign portfolio investment. And the definition as per the master directions is, see, foreign portfolio investment is investment made by non-residents again in less than 10% of, in what, madam? Number 1, post issue paid up equity capital on fully diluted basis or each series of capital instruments. Here they did not specify listed company or unlisted company. Okay, here very simple, foreign portfolio investment is investment made by non-residents in what? Less than 10% of post-issue paid up equity capital on fully diluted basis and each series of capital instruments. Now what is the meaning, madam? Here, madam, we did not understand the meaning of two things. Number 1, what is fully diluted basis? Number 2, what is this post issue paid up? One more thing also, what is each series of capital instruments? Let me clarify you with this. Let me clarify all the 3 doubts with an example. Okay, so now since it's a regular class, I will take my sweet time to explain them with an example, but in marathon it does not go like that. Okay, so let's say there is ABC Limited, listed company. Now, here the company has a capital structure with around 10 million shares worth 100 million. Okay, this is rupees. This is equity capital. We are talking about the capital structure in the form of equity capital. And the second one is, let's say we have issued convertible debentures of a value 5 million. Like around 5 million convertible debentures have been issued by the company to the investors. Now, the word convertible debentures refers that after the maturity period, that concerned investor has the right to convert that debentures into equity shares. Now, what will we presume? That 100% of the convertible debentures will be converted into equity capital. Let's assume that. What is it? 5 million convertible debentures. Now these will be converted into rupees 50 million equity capital. This is in a perception that in future all the convertible debentures will be converted into equity capital. You have to presume that the convertible debentures have still not matured. Remember this. If I complete the total example, then you will get a clarity. Next, third one is we have issued around 10 million, not 10 million, that will be a huge number, around 1 million, 1 million stock options. What are those? Stock options to employees. Those are called employee stock options, ESOP. Now, here also we are presuming that all the 1 million stock options will be availed by the employees, and all the 1 million stock options will be converted into the prescribed number of equity shares. Now, here also let's say all the shares have been converted, and here we have the equity capital of 10 million rupees. Okay, now this is what fully diluted basis is. That means if you dilute all the convertible debentures, convertible preference shares and convertible bonds and equity options, share warrants, in future what will be the share capital if you dilute all this into equity capital? From that you have to calculate the 10%. Let's say here. Now, if we sum up this, we will be getting around 151 million rupees of equity capital. So, in order to test if this foreign investment is FDI or FPI, that is, it is more than 10% or less than 10%, that 10% should be calculated on this amount. This is called on fully diluted basis. Now, what is post issue paid up, madam? In the following, like FDI did not specify post issue paid up, but here I specified post issue paid up. But both the cases you have to follow the same procedure that I'm telling you. Now, in this situation, if a non-resident is willing to make an investment, okay, now he is willing to make an investment. Case number 1, what is it? Case number 1. Okay, now fourth, investment by non-resident by issuing equity shares. So the value has become around rupees, case number 1, around 20 million rupees, and case number 2 around 10 million rupees. What is it? 10 million rupees. Okay, just to be safe, let this be 30. Okay, 30 million rupees worth equity capital is held by this non-resident. In case 2, 10 million rupees worth equity capital is held in the hands of that non-resident. Now let's check if is it FDI or FPI. How do we check, madam? We have to calculate 10% of the post-issue paid up equity capital on fully diluted basis. Here we have already calculated this fully diluted basis. What is it? 50 million we have diluted into equity share capital. The stock options we have diluted into equity share capital. Now, what is post-issue paid up, madam? After issue of shares to that non-resident, that is post-issue, after the issue of equity shares to the non-resident, the value of equity capital that shall be taken as a base to calculate the 10%. Now in the same case, in order to classify this, let's see what is the total equity capital. This equity capital is called post-issue paid up equity capital on fully diluted basis. This value is called post-issue paid up equity capital on fully diluted basis. Here case number 1, till here it is 100, 150, 160. Before I wrote 151, please excuse me for my wrong math. 100, 150, 160, and then here we have 190. So the total we have around 190 million rupees of equity capital in case number 1. In case number 2, we have, just a moment, we have how much rupees? 170 million. Okay, now what is the condition that you have to satisfy in order to call it as FDI? It should be at least, first let's calculate what is 10%. So 10% of this is equal to how much? 19 million rupees. What is it? 19 million rupees. And 10% of this is how much? 17 million rupees. Okay, now, so how much actual investment is made by this non-resident? 30 million. So is it more than 10% or less than 10% of the post-issue paid up equity capital on fully diluted basis? Of course, it's more than $19 million. So that is why you call this as FDI. 30 million, more than 19 million, you call it FDI. Here, what is 10%? 17 million. But here how much investment has been made by that concerned non-resident? 10 million, which is less than 17 million is greater than 10 million. So that is why it is called foreign portfolio investment. That is the meaning of fully diluted basis post-issue paid up equity capital. I hope I'm clear. So all the future convertible debt instruments or future convertible bonds or future convertible stocks which will be converted into equity shares should first be converted now, and then we have to calculate the amount of foreign investment. Okay, so that is the meaning of this concerned sentence. Foreign direct investment is investment made by non-residents in unlisted Indian company. First, no limit for that. And for listed company, at least 10%. That means it should be equal to 10% or more than 10%. Okay, so listed company equity capital on fully diluted basis. Then what about foreign portfolio investment, madam? Very simple. Investment by non-residents in less than 10%. Here it should not be equal to 10% also. If it is equal to 10%, it is called foreign direct investment. If it is less than 10% only, then it is called post-issue paid up equity capital on fully diluted basis, each series of capital instrument. This is done. Here they did not specify listed or unlisted. Why didn't they specify, madam? Here we have already seen unlisted, any amount is called foreign direct investment. Why will they specify again here listed or unlisted? So that is why here we are talking about listed company only. Foreign portfolio investors are investors registered with SEBI to trade in financial markets. Financial markets, which kind of securities will be traded? Only listed company securities will be traded. Okay, so that is why we are talking about listed company securities in the foreign portfolio investment. So I hope I'm clear with this. Then what is this, madam? Each series of capital instruments. For example, you have to calculate 10% less than 10% in debenture series. Okay, this is coming a little too bold. I'll just write it in a new paper. See here. Let's say less than 10% investment in debenture series. Next, less than 10% investment in preference shares. Next, less than 10% investment in convertible bonds. All this will be called as still foreign portfolio investment. Clear, everyone? So if you are investing in some other capital instruments which is other than equity capital, even then in that series you have to satisfy that less than 10% condition. That is what it is mentioned as per the master directions released by the Reserve Bank of India. Okay, so if you are willing to take if you are willing to copy this example, you can do it by following the video also. You can do it, but if you want to take a screenshot, you can take a screenshot now, so that in future it will be there for you to refer. Okay, or else you can just simply write it in your notes. Okay, so that is the meaning of these sentences. I am deleting this page because I don't want to make this handwritten notes too long. Okay, so let's read it out. As per the master directions released by the Reserve Bank of India, the definition of foreign direct investment is investment made by non-resident in unlisted Indian company, that is A, unlisted Indian company, or B, at least 10% of listed company equity capital on fully diluted basis. Then coming to the definition of the foreign portfolio investment, it is investment made by non-resident in less than 10% of post-issue paid up equity capital on fully diluted basis. Number 2, each series of capital instrument. In both the cases, you have to satisfy one minute condition. What is it? Less than 10%. Okay, done. Then what is this, madam? Eventually, after the foreign direct investment initially is done, 10% condition is satisfied. Okay, and after that, what happened is the company has issued more shares or has issued bonus shares or some more new issue. For example, same thing. Now let's say the foreign portfolio investment is 10% of 100 million. That means the investment by non-resident is 10 million initially. So after a while, the company, sorry, I'm writing a little cross, just a moment. Okay, so let's say ABC Limited has equity capital 100 million rupees. 100 million rupees. And in this, 10 million rupees is held by non-resident. So this will be foreign investment. What is it? Foreign investment. Now, what they are trying to say is, eventually this is in the year 2024. In the year 2025, the company has gone for a new issue of shares. New shares were issued. New shares were issued. Then the equity capital has been increased to $120 million. 120 million rupees. Now what happened? The investment which is made by non-resident will still be 10 million rupees only. Will still be 10 million rupees only. Now, did the percentage increase or decrease? Of course, it has been decreased. Previously, out of 100 million, he has satisfied the condition of at least 10%. Now, out of 120 million into 10. Into 10% is 12 million. But he only has around 10 million. That is, which is, what do you say? Which is less than 10%. So now, will this person be still called as foreign direct? Will this foreign investment be still called as foreign direct investment? Yes. Even if the percentage has fallen below 10% after eventually later on, it will still be maintaining the status of FDI. That is what it is specified here. See. FDI status is maintained even if the investment falls below 10% later on. The 10% condition should be satisfied during the initial investment. Later on, if it falls below 10%, it will still be called as foreign direct investment. Clear? Okay, good. Now, I hope we are clear with the definitions. Foreign direct investment, foreign portfolio investment, and then we have completed the basic meaning. Who issues FDI policy? Department for Promotion of Industry and Internal Trade. Okay. Now let's move on to a new concept. What is this, madam? Investment vehicle. So are we talking about some movable property? No, we are not talking about a movable property. Rather than we are talking about a separate entity which is formed for the purpose of investment. Okay, madam. So if you have an idea regarding special purpose vehicle under securitization in your strategic financial management subject, this will be much more easier for you to understand. Okay, even if you don't get even if you don't understand the concept of SPV, the special purpose vehicle under securitization in SFM, that's not an issue. Let's learn it from the scratch. Okay. So let's get to know the basic meaning of investment vehicle. What is the basic meaning? Entities. Investment vehicles are entities used by investors to invest their money in different types of assets and projects. Okay. You are telling me that investment vehicle is an entity which investors use in order to invest their money in different projects, assets. Okay. Still confused, madam? Let's understand this with a beautiful flowchart here. Okay. Now, so here is a separate entity which is incorporated. Let's say company. Now the main duty of this company is not some manufacturing or providing services or something. It is oriented. It is established for the purpose of procuring money from the investors and making investment in few assets. or making investment in few securities. Imagine that to be a mutual funds, similar to mutual funds, but mutual funds is not like what we are talking about here, is not investment vehicle. Okay. See, separate entity is incorporated. What this entity is doing, it is first thing the investors, that is the common people, let's say I. Okay, investors is investing money in this separate entity, that is I am paying around 100 rupees to that separate entity which is incorporated, which is called investment vehicle. Now investment vehicle will issue units to me, like the same mechanism of mutual funds. What we do, we invest let's say 10,000 rupees, they will issue around 10 units worth 100 rupees. Okay, so that is what similar to what do you say, this investment vehicle. Okay, so let's say I have given around 10,000 rupees. Okay, now this separate entity which is incorporated has given me around 100 units of face value rupees 100, and it will also later on give returns also to me. That one we will see. Now money has been invested, not only me who is investing 10,000, everyone who has a perception, who wants return and who are ready to take a risk will come and invest in this separate vehicle. Okay, now what happens, this invested money which is received from the investor is again invested by the separate entity, that is the investment vehicle, in certain assets and projects. What are the certain assets and projects, madam? Let's say real estate business, let's say infrastructure projects, let's say private placement, let's say buying securities from another company. That is again coming under mutual funds. Okay, so main purpose of this investment vehicle is investing in certain assets and projects. Examples are given in your book. First, let's understand the mechanism. What happens? This separate entity is established. Yes. So this separate entity first receives money from the investors. This money will then be invested in certain assets and projects. Okay. And revenue which is generated from these assets and projects, that may be income, that is interest, dividend, or else any other form of income, or capital appreciation. Let's say you are investing in real estate business. What is the income that you receive? Rental income. Yes. And what is another type of income that you receive? Capital appreciation of the asset. Let's say you are investing in infrastructure projects. What do you mean by infrastructure projects, madam? Metro projects, Delhi Metro project, Bangalore Metro project, Chennai Metro project, and Hyderabad Metro project. All these are infrastructural projects. Expressways, highways, outer ring roads, all these are infrastructure projects. So if the investment vehicle invests in these infrastructure projects, what is the income that it will receive? Let's say in metro ticket fees, toll fare in the concerned expressways and ORR and all these. So the income which is generated from that certain assets and projects will be given to the investors in the form of returns. Simple. That is the purpose of investment vehicle. The picture looks like mutual funds only, but mutual funds are not investment vehicles. Mutual funds invest in securities of companies, in financial markets, but here we invest in certain assets and certain projects only. Now what are the examples for this, madam? See, examples are given in your ICMA study material only. First investment vehicle is real estate investment trusts. So this real estate investment trust will procure the money from the investors and it will invest in what? Real estate projects. Let's say in Hyderabad we have My Home Bhuja, Aparna Sarovar, Aparna Grande. Yes, My Home Tridasa, My Home Vipina. So many real estate projects are there. But as a normal human being or as a normal investor, I don't know which project will generate highest profits, and I don't know how to do the speculative trading. Then what will I do? Simply I'll go take my money and invest in this investment vehicle, and they will invest in certain real estate projects. Okay, and the second example, infrastructure investment trust. So here, what is the assets or projects that this concerned investment vehicle is investing in? Infrastructure projects. Let's say our highways, expressways, our metro projects, all these come under infrastructure projects. Okay, next, alternate investment funds. So this is also a kind of investment vehicle where the certain assets or projects will be private equity, that is the equity of private companies where they can't procure money from public, no. So that is why this certain investment vehicles will invest in that concerned private equity or hedge funds of any other sector. Okay, so this is how investment vehicle mechanism works. Okay, so these are the three examples. Here in your ICMA study material, there is a separate fund given, which is venture capital fund. Venture capital fund is not an investment vehicle. So venture capital fund is simply investment is made in early stage projects and startup companies. Clear? So under alternate investment funds, venture capital fund is also one wing, but that is not called investment vehicle. That is simply for the purpose of making investment in early stage projects and startup companies. This is done by whom? If you're talking about FEMA perspective, foreign venture capital investor who is registered with SEBI, yes or no, that we have seen in chapter number 1 definitions part. Yes, foreign venture capital investor is a person who gets registered himself as FVCI, that's a foreign venture capital investor, with SEBI, and his main purpose of registering himself is investment in startup companies or else companies in early stage. Okay, so in order to call yourself as an investment vehicle, you have to get registered yourself with SEBI. That is what here we have specified here. So what is the meaning of investment vehicle now? Entities used by investors to invest their money in different assets and projects. Very simple. Investors invest money and they receive units in that separate entity, and that separate entity will invest the money received from investors in certain projects and certain assets. Here, these assets and projects will generate income and also the capital appreciation. This income generated will be given in the form of returns to the investors. So that is called investment vehicle. So what are the examples or types of investment vehicles given for you? Real estate investment trusts. The project here is real estate projects. Infrastructure investment trust. Here the asset or the project is infrastructure projects. And then alternate investment funds. That means other than real estate, other than investment funds, alternate ways to invest the funds. Let's say private equity, hedge funds, all these come under this. All these come under the projects or assets in which alternate investment funds vehicle will invest. Okay, so in the last one, venture capital fund, this is not an investment vehicle. Remember this. The fund is just oriented to invest in early stage projects or startup companies. All these investment vehicles as well as the venture capital fund should be registered with the SEBI. Then only they can play the role of investment vehicle. Okay. So I hope I'm clear with the second concept. First concept, simple, the meaning of FDI, and the next one is master directions released, definition of FDI and FPI, and then investment vehicle. Let's just simply refer our study material, concept book. First, okay, FDI in India is regulated under FDI policy issued annually by Department for Promotion of Industry and Internal Trade, which is under the control of Ministry of Commerce and Trade. Okay, industry, Next, as per master directions, foreign direct investment involves investment by non-residents in unlisted Indian companies or at least 10% of Indian companies' equity capital on fully diluted basis. Okay, and last one, FDI status is maintained even if the investment falls below 10% after the initial investment. Okay, next, foreign portfolio investment. Here also simple, defined as investments by non-residents in less than 10% of post-issue paid up equity capital on fully diluted basis of a listed Indian company and less than 10% in each series of capital instruments of a listed company. Okay, let me be much more clear with you. I will just specify. Okay, no more confusion. That is what. Okay, next, holding options. So as a non-resident, is there any mandatory provision that I should hold only through FPI or only through FDI? Of course not. See this, non-residents can hold investments in Indian company either as FDI or FPI. Okay, that is, how do you determine if it is FDI or FPI? You follow the definition. Less than 10% FPI, more than 10% FDI. Unlisted Indian company, of course, every time it is FDI. Okay, next, coming to meaning of investment vehicle, entities or instruments used by investors to invest their money in different types of assets or projects. One, what are the options, like examples given to you? Real estate investment trusts, infrastructure investment trusts, alternate investment funds. Note, a venture capital fund registered with SEBI is not a investment vehicle. Okay, next, conversion of debt instruments. Equity obtained by non-residents through conversion of debt is also counted as FDI. Madam, initially I did not procure equity capital. Okay, good. Then what did you do? I have purchased few convertible debentures, madam. Then later on, that convertible debentures have been converted into equity capital. That is more than 10% of equity capital on fully diluted basis. Now will I be called as person making foreign direct investment? Yes. Okay, so equity obtained by non-residents through conversion of debt is counted under the applicable sectoral cap. Let's understand that later. No need to worry about that. Okay, now investment vehicle is done. Now let's basic meaning. Capital instruments. What are capital instruments, madam? What are those? Daily we come across these terms: shares, equity shares, preference shares, debentures, share warrants. What are share warrants, madam? We have seen this somewhere in accounts, CA Foundation, CMA Foundation, but we don't know till now the actual meaning, madam. Share warrants are simply rights, right to buy a share. So if you have availed that right, you will become an equity shareholder. If you have give up that right, simple, that share warrant is expired. That's all. That is the meaning of share warrant, right to acquire the share. Okay, so capital instrument basic meaning involves equity shares, debentures, preference shares and share warrants. So if foreign direct investment is made by a non-resident in the capital instruments of an Indian company, few regulations which are issued under FDI should be followed. Of course we will follow, madam. That is what it is again specifying us. If you are making investment by purchasing capital instruments of an Indian company or capital instruments, simple, then you have to follow the regulations. Who will issue the regulation? FDI policy issues regulatory compliances on managing capital instruments. Very simple. If a non-resident is investing in a capital instruments of an Indian company, regulations will be given to both that Indian company as well as the non-residents, and that shall be complied, that shall be followed before making the foreign direct investment. That shall also be part of the agreement also. Okay, now What are these regulatory compliances, madam? You said there will be few restrictions, not restrictions, procedures and conditions to be followed. Now, do we have all the conditions and procedures? Of course not. There is a there is an example for this regulatory compliances. For example, see, a non-resident is purchasing a partly paid up shares in an Indian company. What do you mean by partly paid up shares, madam? Very simple. You will not pay the full value, that is the total face value. Simply you will just pay around 2 rupees out of 10 or 5 rupees out of the 10 rupees of the face value. That is called partly paid up shares. If an Indian company is issuing partly paid up shares to a non-resident, then two conditions to be satisfied. Number one, minimum 25% of that value shall be paid initially. Okay, let's understand this with an example. Now in this case, Indian company is issuing 10,000 shares at the rate rupees 10 face value. Paid up is equals to rupees 2. Okay, fine. Now, if it is issuing like that, what is the condition it has to satisfy? Condition number 1, minimum 25% should be initially paid. That means out of this rupees 10 into 10,000, 1 lakh into 20% is equals to 20,000. That means if the investment is made via purchasing partly paid up shares, the initial investment should be at least 25%. Clear? So in this case, it should be at least 20,000 is equal to 20,000 or more than 20,000. If that concerned person is just paying around 1 rupee per share, that is only 10,000 rupees is paid, is he complying with the regulatory compliances issued by the FDI policy? No. He is violating the regulatory compliances. Of course, enforcement directorate will come and enforcement directorate will be like, you have to follow few procedures, my dear. FEMA is stating it, FDI policy is stating it. Penalties may be levied in that case. Very simple. This is one of a kind of regulatory compliance which is issued by the FDI policy in regards to capital instruments purchased by the non-residents. Okay, it is one of the example. Second condition is, initially you have to pay 25%. The remaining 75% it has to be paid within the next 12 months. That is one of the regulatory compliances which are issued by the FDI policy. Okay, simple. What is this consent provision is stating us? Capital instruments are there. Okay, and regulatory compliances, rules, conditions. If a non-resident is making investment in an Indian company or in India by purchasing capital instruments, then you have to follow this regulatory compliances. One such regulatory compliance example is given in your textbook, that is, if in case Indian company is issuing partly paid up shares to a non-resident, then that non-resident should pay minimum of 25% initially and the remaining 75% shall be paid within the next 12 months. If he does not comply with this, that means he is violating the regulatory compliances as per the FDI policy. Okay, done. Now let's move on to one of the important questions or one of the important answers in your Foreign Exchange Management Act 1999. What are these, madam? Prohibited sectors. This has been asked in your let's say, I forgot the attempt, June 2023 new syllabus. I will show you. June 2023 new syllabus, corporate and economic laws. The question has been asked for the first attempt of new syllabus from this concerned part. Write a short notes on prohibited sectors or persons for foreign direct investment in India. So what answer should you write here? Very simple. This prohibited sectors should be written. Now let's see what are the prohibited sectors. Prohibited sectors. So let's just understand each and every one with a very simple meaning, and it is really important for examination point of view. So try to remember it for sure. This is one of the important questions you have to study before going to the examination. So it will top the ABC list, ABC analysis of the Foreign Exchange Management Act 1999. So the first prohibited sector. What do you mean by prohibited sector, madam? The foreign direct investment that we're talking about, investment which is made by non-resident in India, that concerned sector in which that foreign direct investment is. This list, it is prohibited. That means the list of sectors which are there under this concerned topic, foreign direct investment is not allowed. Very simple. Okay, so what is the first prohibited sector? Lottery business. So be it private lottery business or the lottery business which is run by the government also. Both sectors, what is this? Foreign direct investment is prohibited. That means in lottery business, ticket and winning lotteries, receiving the amount, making investment to encourage lottery, all these are prohibited for foreign direct investment. Very simple. So the first one is lottery business, be it private, online or government. Online lottery also, it cannot receive foreign direct investment. And the next one, gambling and betting plus casinos. So gambling games, betting and all these activities, what is it? Foreign direct investment is prohibited. Very simple meaning. First thing is lottery business, be it private lottery business, government lottery business, online lottery business. Second one is gambling as well as betting, including casinos. Okay, so casinos is like, I think most of you are familiar with. Yes, playing games based on luck. Okay, so in that concerned activities or sectors, foreign direct investment is not allowed. Rather, it is prohibited under the FDI policy. Okay, so and the third one, chit funds. So chit funds, foreign direct investment is not allowed, but there's an exception. What is the exception? NRI and OCI. We know NRI, madam, non-resident Indian. Who is OCI? Overseas citizen of India. So overseas citizenship of India. Overseas citizen of India is like a separate citizenship certificate which is given to few people. Who are those, madam? Very simple, to person of Indian origin. In chapter number 1, we have discussed this definition regarding person of Indian origin. So, who will be given the status of person of Indian origin? Any citizen of any country. Number 1, who has held Indian passport before. Number 2, who has parents or grandparents who used to be Indian citizens. Number 3, whose spouse is an Indian citizen or a person of Indian origin. These 3 category of people will get the status of person of Indian origin, and this persons will be given an overseas citizenship certificate. Okay, so persons who are given the status of overseas citizen of India as well as non-resident Indian will be given an exception to invest, rather to make foreign direct investment in this chit funds sector. But another condition is there, on non-repatriation basis. What do you mean by non-repatriation basis? This one also we have come across in the definitions part of unit number 1. That is why we are learning definitions in the unit number 1, even though they seem unimportant in that chapter. In upcoming chapters like this unit and 3rd unit and 4th unit, you will come across these terminologies. So that is why it is important to understand the basic meanings of these words. So okay, non-repatriation basis. What do you mean by non-repatriation basis? Very simple. So if NRI is investing in a company, like making a foreign direct investment, the income that is generated from that investment cannot be taken out of the country. That means this income shall be used for expenses in India, or else shall be used for making further investments in India. But you cannot take a single rupee that you have earned in India to your home country. That is called investment on non-repatriation basis. That is what here we are talking about. Chit fund sector is prohibited, but NRI or OCI can invest in the form of foreign direct investment in chit fund sector, but it should be done on non-repatriation basis. So the income or the money that you receive from the chit funds cannot be taken back to your home country or else outside India. Okay, so that is what the third prohibited sector is. First one we are talking about lottery business, private, government, online. Second one, gambling and betting, including casinos. Third one, chit funds, except for NRIs and OCIs on non-repatriation basis. Okay, now moving on to fourth one, needy companies. What are needy companies, madam? So those have already done the Companies Act 2013, you might be familiar with. But if not, very simple, needy companies are like a non-banking financial companies whose main motive is developing saving habits in their members. So there will be a certain group of members who will deposit their money in the needy companies, and that money will also be used to lend to the same members. So that is the meaning of needy companies. So foreign direct investment in needy companies is also prohibited. So what do you say? Needy means treasure. So a non-resident cannot become a member of needy companies. That is what we are learning here. Very simple. And the fifth prohibition, real estate business and construction of farmhouses. Madam, just give us clarity. What do you mean by real estate business? Is it simply purchasing houses? No. Investing in real estate business is simple. You are acting as an investor in that project. That means you are not purchasing the asset, but you are part of that concerned project from the beginning. That means you are investing for construction. Okay. A non-resident can purchase constructed houses. That is different. Here, investment in real estate business and construction of farmhouses is prohibited. That is the fifth prohibition. First one, once again, lottery business, private, government, online. Second one, gambling, betting, casinos. Third one, chit funds, exception, NRI, OCI on non-repatriation basis. Fourth one, needy companies. Fifth one is real estate business plus construction of farmhouses. These are the first 5 prohibited sectors for foreign direct investment. Clear? Okay. Moving on. Seventh one, trading in transferable development rights. So what is the meaning of transferable development rights? Very simple. Imagine a city like Kolkata. So some areas there will be houses or places which will depict the historic culture of the city. So what happens is, previously, let's imagine in 1990s, where that cultural or beautiful houses based depicting the Indian culture or historic monuments used to be there. What happens is, they used to construct around 2 floors houses or 3 floor houses maximum. But still, they used to have development rights. What do you mean by development rights? They will still have the right to reconstruct or build more floors. That is called development right. They are holding development rights. Now, let's say now, still in 2024, they still did not use that development rights. That means they did not build, or else they did not increase the number of floors, or they did not reconstruct whatsoever it is. So they are still did not use the development rights. Now what happened is, in 2024, the government, let's say the municipal corporation, declared that we want to preserve the culture in this concerned area. So we are cancelling construction or reconstruction of buildings in this concerned area. Now what they will do here, the persons who have development rights cannot utilize, Because government has put prohibition that you should not construct, or rather you should not change the cultural, rather you should preserve the culture. Now what happened? That person who are previously residing there have development rights, but they can't utilize it. Now what they will do, government has declared that city outskirt we are trying to build an urban city, so there they will have development rights. They can build around 10 to 15 floors, they can reconstruct buildings in a modern way rather than preserving culture. Now what happens, people living in that urban city wants development rights to construct, for the purpose of construction. Now what happens, the person who is holding development rights from 1990s and now he is unable to use the development rights will transfer it to that person who needs development rights for construction of buildings in that urban city. That is the concept of transferable development rights. So as a non-resident, you purchasing or transferring, that means trading in transferable development rights, is prohibited. That is what FDI policy is saying. Foreign direct investment in trading in TDRs is prohibited. That's all. Not much to brag about. Development rights with one person will be transferred to another person. So in that concerned scenario, a non-resident should not be involved. He should not be part of this trading of TDRs. That is the sixth prohibition of FDI, prohibition of FDI in this concerned sector. Next, seventh one, very simple, manufacturing of cigars, cigarettes and tobacco substitutes. So person who has an Indian company who has like a manufacturing unit dedicated for manufacturing of cigars or tobacco substitute, can he accept foreign direct investment? No, because it is prohibited. Can a non-resident establish a manufacturing unit in India for the purpose of manufacturing of cigars, cigarettes or tobacco? No, it is prohibited. So investment, foreign direct investment in manufacturing of cigars and cigarettes or tobacco substitutes is prohibited under the FDI policy. That is the seventh prohibition. Now coming to eighth one, activities or sectors not open to private sector investment. Here in this concerned sectors, a private citizen rather than government, a private citizen of India only, person resident in India being a private citizen, I mean not part of the government association, is not allowed to, what do you say, start a business in this concerned sectors. Then how can they allow a non-resident? So that is why for activities where private investment is only not allowed, how can you allow foreign direct investment? So those in that sectors also foreign direct investment is prohibited. One of the two sectors in India where private investment is not allowed is number one, atomic energy, number two, railway operations. So in atomic energy sector as well as railway sector, what is it? Foreign direct investment is prohibited. Clear? So these are the first 8 prohibitions. First 8 prohibitions are prohibited sectors. Next to 9th and 10th are prohibited persons. So if you see June 2023 paper, it has asked, write a short note on prohibited sectors / persons for foreign direct investment in India. So the first 8 we are talking about prohibited sectors. The last 2 we are talking about prohibited persons who are not allowed to make foreign direct investment. Okay, so we are done with prohibited sectors. Just let's give a quick recap. Number 1, lottery business, private, government, online. Number 2, gambling and betting. What is it? Inclusive of casinos. Number 3, chit funds, exception for NRI and OCI is available on non-repatriation basis. And number 4, Nidhi companies. Number 5, real estate business and construction of farmhouses. Number 6, trading in transferable development rights. Number 7, manufacturing of cigars, cigarettes, tobacco substitutes, etc. And the last prohibited sector is activities / sectors not open for private sector investment. That is atomic energy and railway operations. Now moving on to prohibited persons. So in the handwritten notes as well as my concept book, I did not divide it into prohibited sectors and persons. Rather, I've just given combinedly in the 10 points. You can even write like that also. Okay, fine. Now, ninth one is the prohibited persons who are not allowed to make foreign direct investment. Let's see who. Investments by citizens or entities. Individuals as well as entities, that is the company, HUF, partnership firms, LLPs, sole proprietorship firms, all these persons. Investments from which country? Bangladesh and Pakistan. But there is a twist. You can do it with prior government approval. Without taking the approval of government, you cannot make investment. What is it? Foreign direct investment. Who? Investments made by citizens or entities of Pakistan and Bangladesh. So these citizens and entities of Bangladesh and Pakistan can make foreign direct investment, but only with the prior approval of the government, central government. Okay, that's all. And the 10th, that is the last prohibited person who is not allowed to make foreign direct investment. Here also they didn't say totally not allowed, they need permission. Prior approval of government is required, but in few sectors you cannot ask for government approval also. What are those? Let's see. Citizens or entities from Pakistan. This is especially from the country of Pakistan, this prohibited person. Here in the ninth point, we're talking about both citizens and entities of both Bangladesh as well as Pakistan. Here, citizens and entities from Pakistan can invest in defense, space, atomic energy or prohibited sectors. Never. Even with the prior approval of the central government, they cannot invest in these concerned sectors. What are those? Defense, space, atomic energy and prohibited sectors. But other sectors, not including these four, they can do it, but with the prior government approval. So very simple. Citizens and entities from Pakistan can invest in sectors other than defense, space, atomic energy and prohibited sectors. Other sectors also you need prior government approval. So this is the last point regarding prohibited persons. So the ninth point is talking about citizens and entities of Pakistan and Bangladesh are allowed to make foreign direct investment only with prior government approval. 10th point is talking about citizens and entities of Pakistan can invest in sectors other than defense, space, atomic energy, prohibited sectors only with prior government approval. For other sectors, you need prior government approval. For these sectors, you cannot make it even if you have prior government approval. Okay? That's all. These are the 10 prohibited sectors as well as prohibited persons. This is one of the most important question and one of the easiest to write also. So do not skip this, and of course you have to do a revision before going to the examination. So that's all with the prohibited sectors. Moving on to the next concept, which is entry routes. What do you mean by entry route, madam? You said foreign direct investment is allowed. So how can you enter? Every time you're making a foreign direct investment, is it necessary for me to take like hundreds of permissions from different government organizations and then RBI and then the going through authorized dealer? Should I do it? No. That's why they have given two routes. Automatic route, where you do not require government approval. Simply if a concerned business activity is listed under automatic route, you don't need the approval of government. Simply you can make investment through an authorized dealer. Of course, any money which is coming inside India and any money which is going outside India should be done through an authorized dealer, no matter what. That is what we have spoken in the section number 4 and section number 3 of the Foreign Exchange Management Act. Here we are talking about entry routes for foreign direct investment. So if a particular sector or a business activity is listed under automatic route, that means investment by a non-resident in that sector does not require approval of the government. That is what we are talking about. There are two routes, automatic route and government approval route. Under automatic route, foreign investors, that means non-resident investors, do not require approval of government or RBI but should comply with sectoral caps. We will see sectoral caps later. Let's understand what is government approval route. Very simple. In the name only they are saying that you need the approval of government. That's all. So investments under this route. So if a sector or a business activity is listed under government approval route, you need the approval of government. And which central government we have to take, like from which concerned department we have to take. Very simple. If we see in the FDI policy, the BEAR policy which has been released by the Department for Promotion of Industry and Internal Trade, we will get to know how these automatic routes and how these, government approval routes will be listed in this file. If you check this, very simple. So I've already told you, you need government approval. So government approval means from where we have to procure the approval. Very simple. If you are trying to invest in mining sectors, then you have to go to Ministry of Mines. Take an approval from that concerned department. If you are trying to invest in defense, then you have to take approval from the Department of Defense Production, Ministry of Defense. Very simple. Now, if you are trying to invest in broadcasting sector, then you need approval from Ministry of Information and Broadcasting. So that in detail is specified in the FDI policy. For which concerned sector, which concerned department of government, you have to go and take the approval. Okay. So now how will we know whether such concerned activity is under government approval or automatic approval? Go and check FDI policy. That's all, because it's not there in your syllabus. Simple, in your syllabus it's stating that automatic route, no approval. Government route, approval of government required. That's all. So thinking of which will come under automatic route, which will come under government route is not at all necessary for you. Okay. So now if we see the FDI policy, now see, in agriculture sector, in agriculture and animal husbandry sector, they have given, see, FDI cap is given. Now we are talking about sectoral caps. Let's understand sectoral caps and then come back to the FDI policy. Now, what do you mean by sectoral caps, madam? Caps, limits. So, limit which is given for each and every sector. Also known as maximum foreign investment allowed in that concerned sector or activity in India. Example. Let's understand with the direct FDI policy only. See here, the cap here is 100%. That means 100% of the capital can be owned by a non-resident through foreign direct investment. And given the entry route also here automatic. So no permission is required. And what is the cap given here? 100%. So let's see the next one. Here, plantation sector. Here also the cap is 100% and the route is automatic. What do you mean by cap, madam? For example, the capital of that concerned company in plantation sector is around 100 million. So the total 100 million, 100% of equity can be held by a non-resident. That is called cap, limit. Okay. So if we go further, we will find few other things. See here, petroleum and natural gas. Here they have given an activity, petroleum refining by public sector undertakings. Cap is 49%. That means foreign direct investment under automatic route is allowed only up to 49% of the capital. That is the example for, what do you say, automatic route as well as the sectoral cap. Okay. Now coming to another example, defense. See this, defense industry subject to industrial license. Here the foreign direct investment cap, generally it is given 100%. But here if you see entry routes, they have said automatic up to 74%. That means up to 74% you can invest under automatic route without any approval of the government. But the remaining 26% you need government approval. So this is also one kind of sectoral caps. Okay. That's all. Now coming to a few other examples. Uplinking of news and current affairs of TV channels. FDI is allowed up to 49% and the route is government approval route. So these are the examples for entry routes and sectoral caps. So entry routes, we have two routes: automatic route, where you do not require the approval of the government, and the next one is government approval route, where you must procure the approval of the government before you make the investment. Okay, and automatic route, you have to of course verify the sectoral gaps before you make the investment. Simply if it is listed in automatic, you can't, what do you say, invest, I mean, what do you say, make foreign direct investment up to 100% of the equity. You need to check the sectoral gaps. Is 100% FDI allowed in this concerned sector or not? Is only 49%, then you can make only 49% under automatic route. Okay. Next, sectoral gaps, you've already seen. These are limits for each and every sector for foreign direct investment. Maximum, just a moment, maximum foreign investment allowed in that sector or activity in India. That is the meaning of sectoral cap. The example that is given in your concerned study material is what I've given in my notes as well. See this: foreign investment in non-NBFC companies. What are non-NBFC companies? Very simple. These financial companies' main business is not accepting of deposits and lending money, but rather these are just like financial purposes, supporting their main main companies. Example: Reliance Finance Limited is just established for the purpose of making investment and getting money for supporting Reliance Industry Limited. So those kind of companies are called non-NBFC companies. And what the example is stating here is foreign investment in non-NBFC companies requires government approval. So if a non-resident is trying to make FDI in non-NBFC companies, it requires government approval. But if foreign investment is trying to be made in NBFCs which are registered as non-banking financial companies with RBIs, then 100% sectoral cap is given, automatic route, entry route is given. So this is the example listed in your study material. What is the example? FDI in non-NBFC companies requires government approval, whereas FDI in NBFC companies, NBFCs registered with RBI does not require government approval, rather it is 100% automatic route. I hope we are clear with the entry routes, sectoral gaps and prohibited sectors, or as well as prohibited persons. Okay. Moving on to the next concept. Before we move on to the next concept, which is permitted investment, let's just revise the topics that we have discussed in our concept book. Why am I doing this? Is very simple. After you refer the handwritten notes and then concept book, what will happen is few terminologies, maybe few sentences you will become little unfamiliar with, because that I have not discussed. So that is why I am trying to discuss both the concept book as well as the handwritten notes. Okay. So very quickly, we'll see what we have already read. Prohibited sectors. So lottery business, including government, private lottery and online lotteries, FDI is prohibited. Gambling and betting, including casinos, FDI is prohibited. Chit funds, except for investment by NRIs and OCIs on a non-repatriation basis, yes, allowed. And normal chit funds, prohibited. And next, Nidhi companies, prohibited. Trading in TDRs, prohibited. Real estate business and construction of farmhouse is prohibited. Manufacturing of cigars, cherries, cigarillos. I'm not familiar with this, so that is why I'm not familiar with the pronunciations also. Okay, and cigarettes, tobacco and tobacco substitutes, all these are prohibited for foreign direct investment. And the next, activities and sectors not open to private sector investment, like atomic energy and then railway operations. Last two, prohibited persons, investments by citizens or entities from Bangladesh or Pakistan require prior government approval. Last one, citizens or entities from Pakistan can invest in sectors slash activities other than defense, space, atomic energy and prohibited sectors only with prior government approval. Normal sectors, they can invest only with prior government approval. These sectors, they cannot invest at any cost. Okay, next, entry routes, very simple, automatic. Under this route, foreign investors do not require prior approval of the government or the RBI, can be made in sectors or activities specified under this route, provided they comply with sectoral caps. And next, government approval route. Investments under this route require prior government approval. Yes, this route is applicable for sectors or activities that are not covered under automatic route, and also where investment exceeds the specific sectoral limits. We have already seen in the FDI policy, up to 74% automatic. If investment exceeds 74%, it needs government approval. So that is what the sentence is trying to tell us. Next, sectoral caps, maximum foreign investment allowed in various sectors or activities in India. Okay, so 100% automatic route, not listed or not prohibited under regulation, foreign investment. So if any prohibition is not, not specified, or limit is not specified, then very simple, if it is specified, it's 100% automatic route, then freely foreign direct investment up to 100% of the equity is allowed. Okay, next, foreign investment in non-NBFC requires prior approval, registered as NBFCs fall under 100% automatic route. This example we have already discussed in our handwritten notes. And moving on to the next concept, which is permitted investments. Madam, okay, you told me prohibited. Then what about the sectors where FDI is allowed? This is what we are reading. Permitted investments. So these kind of investments in different forms and different organizations are allowed under the FDI policy. Here we will see around 10 permitted investments. So these are like different forms: capital instruments and listed company, LLP, and sole proprietorship, and few of the exceptions by NRIs and OCIs. All these are included in this. So in this format, in this 10 forms, and FDI made in this particular, what do you say, as per this 10 permitted investments is okay. But not only like simple, let's see the first one, permitted to make, purchase, sell, subscribe capital instruments of an Indian company. So can I purchase capital instruments of any Indian company? No. Permitted investments shall be read together with automatic route, government approval, that is the entry routes as well as the sectoral caps. You have to keep in mind the entry routes, sectoral cap, prohibited sectors, and then read this permitted investments. Clear, everyone? Okay. So the first permitted investment by a non-resident is permitted to invest. A non-resident is permitted to purchase, sell, subscribe capital instrument. Madam, purchase, okay, capital instruments I will purchase. Sell, okay, I will sell to someone. Then what is subscribe, madam? Very simple. During public issue, initial public issue, or during incorporation of the company, what will you do? You will become the subscriber to the capital. Yes or no? So even in that format, the investment is allowed. Usually after the issue is done, you are purchasing shares or selling shares, that is called purchase and sell. When they are issuing shares and you are subscribing to the capital, during the incorporation, if you are subscribing to the capital, you will become the subscriber of the memorandum of association. So in that form, that is called subscription to, what do you say, the capital instruments. So investment in Indian companies in the form of purchase, sell, or subscription of capital instruments is permitted. Okay. Second one, permitted investment by a non-resident. A non-resident is permitted to purchase, sale capital instruments of a listed Indian company. In the first permitted investment, they are not specifying if it is listed or unlisted. Simply they are telling that purchase, sale, subscription of capital instruments of an Indian company by a non-resident is a permitted investment. Here they are specifying details in second one. What is it? Purchase, sale of capital instruments of a listed Indian company by foreign portfolio investor. In the master directions, we have seen that in foreign direct investment by non-residents in unlisted Indian company, whatever the amount is it, if it is a small amount or a huge amount, it will still be called as foreign direct investment. But if they are making investment in a listed company, then they have to own at least 10% of the equity capital on diluted basis. But whereas if we observe in investment made by foreign portfolio investors, there they did not specify unlisted Indian company. That means if investment is made by a person in an unlisted Indian company, that will automatically be called as foreign direct investment. That will not be called as foreign portfolio investment. Clear? So that is why they are specifying details in the second permitted investment. So the second permitted investment says that non-resident, that is foreign portfolio investor, is permitted to purchase, sale capital instruments of a listed Indian company. The third permitted investment, the same thing, purchase, sale capital instruments of a listed Indian company by NRI and OCI on a repatriation basis. We have seen under prohibited sectors, NRI and OCI can make investment, but on non-repatriation basis. That is, income generated cannot be taken back to their home country. That is the country they are living in. Okay, but here under the third permitted investment, a non-resident Indian and an overseas citizen of India will be able to or is permitted to purchase, sale capital instruments of a listed Indian company on repatriation basis. That is the dividend which is generated or the interest that is generated or else the capital appreciation, all the sort of income generated on this concerned capital instruments can be taken back to their home country. So that is the third permitted investment. First, they did not say any particular, very simple, purchase, sale, subscribe capital instruments of an Indian company. Second one, purchase, sale capital instruments of a listed Indian company by foreign portfolio investor. Permitted. Third permitted investment is purchase, sale capital instruments of a listed Indian company by non-resident Indian or overseas citizen of India on repatriation basis. That means income generated can be taken back. Good. Now moving on to fourth permitted investment. Here the investment is not in the form of capital instruments of equity, because here we are not seeing company. Here we are making investment in different business organization, different form of business organization. What are those? LLP, partnership firms, sole proprietorship. These are not companies. So that is why there is no concept of capital instruments, right? So that is why a non-resident is permitted to purchase units of mutual funds, RITs, investment trusts, at the same time alternate investment funds, all these. See, this RIT is real estate investment funds, investment trusts, sorry, and then in they say INV, but actually it is infrastructure investment trusts, and then last one is alternate investment funds. So purchasing units of mutual funds and all these investment vehicles is permitted by non-resident. Next, capital contribution. Whenever I use this term non-resident, that is called person resident outside India. When I use NRI, it is non-resident Indian. OCI, overseas citizen of India. Okay, so a non-resident, that is a person resident outside India, is permitted to purchase units in for mutual funds as well as the investment vehicles. And the next, he is also permitted to make a capital contribution in proprietorship firms, partnership firms and LLP. That means he can act as a partner in both partnership firms as well as LLP firms, and also he can make capital contribution to proprietary concerns. Clear? Okay. Here we have specified that the investment here is permitted by NRI and OCI on non-repatriation basis. There is a twist involved here. What is it? You can make capital contribution. You can purchase the units as a non-resident Indian and as an overseas citizen of India, but on non-repatriation basis. That means that income that I generated from mutual funds in India, income that I generated from partnership business or sole proprietorship business, I can't take back to my home country. Yes, that is the concern condition laid down in FDI policy. So what you have to do, very simple, money that you have generated through these funds, you will invest in some other investments in India only, but you cannot take back to your home country. You can use that money for expenses in India. That's all. Next, I hope we're clear with the fourth permitted investment. NRI and OCI is permitted to purchase units of mutual funds and investment vehicles and make a capital contribution to partnership firms, sole proprietary concerns, LLPs, but there's a condition: on non-repatriation basis. Income generated cannot be taken back to your home country. That's all. Next, fifth, sixth, seventh, eighth permitted investments. What are those? Permitted, non-resident is permitted to purchase and sell securities other than capital instruments. So capital instruments means instruments like debt instruments or else instruments that showcase the ownership of the company. But any instrument which is like, let's say, treasury bills or some other instruments which are not capital instruments, so all these government securities, all these come under the category of securities other than capital instruments. So a non-resident is permitted to purchase, sell securities other than capital instruments. Okay, and the next one, sixth one, permitted to make investment in LLP. Of course, I've already told you, permitted to make capital contribution as well as investment in LLP. There we are specifically talking about NRI and OCI. Here we are talking in general. In general, a person resident outside India is permitted to invest in LLP. Next, he is also permitted to invest in investment vehicles. We have already come across this term in this concerned unit only, meaning of investment vehicle. Separate entity which is used by investors to invest their money in specific projects and specific assets. Example, real estate investment trusts, infrastructure investment trusts, alternate investment funds. These are the examples of investment vehicles. So as a person resident outside India, I can invest in investment vehicles. Also, as per sixth one, I can also invest in LLPs. As per fifth one, I can purchase, sell securities other than capital instruments. And the eighth one, so a person who is registered as foreign venture capital investor with the SEBI can make foreign venture capital investment in startups of Indian company. So that is also a permitted investment. Okay. And the last two, please pay attention because few new terminologies. These are, we are familiar with them, but we don't understand the logic behind them and we are rather confused. So before we start with the 9th and 10th one, let's just quickly recap the 8 permitted investments using our concept book. Okay, see, permitted investments by person residents outside India subject to entry rules, sectoral caps. I've already told you, simply if you read this and you can directly invest, no, you have to check entry routes and also sectoral caps. Okay, so the first one is capital instruments of an Indian company, be it subscription, purchase, sale. Okay, next, which is permitted. And next, listed Indian company. Capital instruments of a listed Indian company can be purchased, sold on a recognized stock exchange by foreign portfolio investors. This is the second point. Okay, that is a permitted investment by foreign portfolio investors. And same thing, NRIs and OCIs. NRIs and OCIs are permitted to make investment in the form of purchasing or selling the capital instruments on recognized stock exchange of a listed Indian company. Okay. Next, fourth one, capital instruments, units, contribution to LLP, firm, proprietorship concerned by NRIs and OCIs on non-repatriation basis. Purchasing and selling the capital instruments of a listed company is on repatriation basis. Capital contribution to LLPs, partnership firms, and proprietary concerns or purchasing units in mutual funds, this can be done by NRIs and OCIs on non-repatriation basis. Okay, and then we have seen purchasing securities other than capital instruments, and then investment in limited liability partnership firm permitted, and foreign venture capital investor, investment made by foreign venture capital investor in Indian startups or businesses in early stages is permitted as per the FDI policy. Moving on to the 9th one and the 10th one. The 9th one, let's see this. This here we are talking about permitted investments in the form of foreign direct investment. Now, in order to encourage foreign investment in Indian company, what happens is a non-resident directly purchasing an Indian company shares is not that easy. Permissions, different forms like coming from an authorized dealer, and conversion of currency, foreign exchange fluctuations, and again generating revenue, all these are a little complicated. Now, in order to avoid all these circumstances, there is a concept called depository. Now, this concept we'll understand with this flowchart. Very simple. Indian company, in order to encourage foreign investors to invest in Indian company, what will it do is, it will issue or else transfer its capital instruments, its eligible capital instruments to a foreign depository. Foreign depository located outside India. So what will Indian company do? Indian company will select a few eligible instruments which will be issued / transferred to a foreign depository. Now, what this foreign depository will do? This foreign depository will convert these shares which are issued by this Indian company into depository receipts. The underlying asset of this depository receipts are eligible instruments of an Indian company, but these are prima facie foreign depository receipts. That means these can easily be purchased by foreign investors in foreign stock exchanges. So that is why in this way easily foreign investment will be procured into Indian companies. So what is it? Indian company will first issue or transfer eligible instruments to foreign depository. Now this foreign depository will convert these into depository receipt. Example, this American depository receipts, global depository receipts, all these have underlying assets of Indian capital instruments. Now, this ADRs and GDRs can easily be purchased by foreign investors in foreign stock exchanges. Simply, what are we talking about here? Foreign direct investment is allowed by non-residents in the form of purchase of this ADRs and GDRs. Simple. Okay. Next, 10th one. Here 10th one, technically we are not talking about foreign direct investment because here Indian investors are investing in foreign company. So 10th one is not related to foreign direct investment, but it is a permitted investment by an Indian resident. Okay, let's understand this. Same way, now foreign company wants to attract Indian investors. Now what will it do? Of course, Indian investors should follow these all complicated procedures to purchase shares there. So that is why in order to avoid all this, it will also do the same thing. Here the foreign company will issue or transfer eligible instruments, that is capital instruments, to Indian depository. Now, this Indian depository will issue Indian depository receipts. What is the underlying asset for Indian depository receipts? The capital instruments of foreign company. That means indirectly, if I am a resident of India and I purchase Indian depository receipt, that means I am becoming a shareholder of a foreign company, because the underlying asset of my IDR is capital instrument of a foreign company. That's all. Same way here also. Foreign companies permitted to issue or transfer eligible instruments to Indian depository. Now, this Indian depository will convert these shares into deposit receipts and issue IDRs to Indian investor. These Indian investors can simply purchase these and also sell these in recognized stock exchanges. So the 10th point is talking about encouragement of investment by Indian investors. In the 9th one, we are talking about foreign direct investment in the forms of purchasing ADRs and GDRs. I hope now we are clear regarding the depository receipts concept. So whenever from now, if you see the word depository receipts, don't get scared. Very simple. The underlying asset is a capital instrument. But you have to ensure if it is ADR, GDR, the underlying asset is capital instrument of an Indian company. These will be purchased by foreign investors in foreign stock exchanges. IDRs, underlying asset is equity instrument or capital instruments of a foreign company. These will be purchased by Indian investors in Indian stock exchanges. That's all. Very simple. Okay. So these are the permitted investments as per the FDI policy. Just a quick recap using our concept book. First one, capital instruments of Indian company, that may be in the form of purchase, sale, subscription. Next, listed Indian company, purchase or sale of capital instruments of a listed Indian company by foreign portfolio investor is permitted. Next, purchase or sale of capital instruments by NRIs and OCIs, capital instruments of what? Of listed Indian company on repatriation basis. Next one, purchase of units or making contribution to LLP, partnership firms, sole proprietary concerns by NRIs and OCIs on non-repatriation basis is permitted. Next one, purchase of security, purchase/sale of securities other than capital instruments is permitted. Next, investment in LLP is permitted. Investment by foreign venture capital investor is permitted. And the next one, investment in investment vehicles. We have already seen the concept and also examples. That is also permitted. And the next, investment, that is issue or transfer of eligible instruments to foreign depository is permitted. That is what Indian companies will do. Okay. Next, issue, very simple, purchase or sale of IDRs issued by companies resident in India is also permitted. Very simple. So as an Indian investor, I can purchase or sell IDRs. That is the investment. That is the permission that has been given under FDI policy. Okay. Next we have few other miscellaneous concepts which are not that important, but we have to expect the worst, and this is regular class, so we will be discussing. Okay, we have pricing guidelines, that is what will be the price of capital instruments which are held by foreign investors. And then we have calculation of foreign investment. Pricing guidelines will specify what is the value of each and every capital instrument held by foreign investor. Calculation of foreign investment talks about the total value of foreign investment by that concerned person resident outside India in Indian companies. And then we have condition to exit. We have seen entry routes, simple, automatic, you will come and exit. You will come and give entry into the Indian business, yes, let's say Indian company. But are there any obligations or are there any conditions that you have to satisfy in order to exit? That one we will read under this concept. And last one, miscellaneous concepts, very simple. With this, we will finish our unit number 2. Pricing guidelines, calculation of foreign investment, conditions to exit, and the last one, miscellaneous concepts. Now moving on to the next concept, which is pricing guidelines. Pricing guidelines. So in this particular concept, we are going to learn what are the guidelines that we have to follow while pricing, rather putting a price for a capital instrument which is held by a person resident outside India. Okay, so first guidelines is for listed Indian company. So if you are trying to put a price for capital instruments held by a person resident outside India in a listed Indian company, then what you have to follow? Very simple. The price of that concerned capital instruments of that foreign investor shall not be less than. The price should not be less than normal listed company. Just imagine normal listed company. The price should not be less than what has been worked out as per the SEBI guidelines. So if as per the SEBI guidelines, the fair market value of an equity share is rupees 110. If you are pricing the value, or let's say if you're pricing the equity shares held by a foreign investor, that price should not fall below 120 per share. That is the guidelines which has been provided if it is for a normal listed company. Now, if that concerned company is going through delisting process, that means all the shares of that company are in the process of delisting. That means they are being removed from the stock exchange. That means all the the capital instruments are no longer listed instruments and no longer they can be traded in stock exchanges. So if you are trying to price the capital instruments of a foreign investor in a company which is going through delisting process, then that price should not be less than which is declared by SEBI Delisting Equity Shares Regulations 2009. This concerned regulations will put a price for the equity shares of the company which is going through delisting process. So that price will be our reference point to check the actual price of the foreign investor. Okay, let's understand with an example. Very simple. So let's say the fair market value of an equity share as per SEBI is rupees 120. Then if you are trying to find out the price of equity shares of a person resident outside India, it should be more than or equal to 120. It should not be less than 120. That's all. Here also, if this 120 is declared by SEBI Delisting Equity Shares Regulation 2009 for the company which is going through delisting procedure, then same thing, the price of the person resident outside India shall not be less than the price which is declared by SEBI. Now, what about unlisted Indian company? In unlisted Indian company, shares will not be listed in the stock exchanges. So SEBI will not be involved for the real valuation of that concerned share based on the market condition. Now what we have to do? Very simple. This under the unlisted Indian companies, the pricing will be done. That is, the valuation shall be done as per the internationally accepted pricing guidelines. So you have to follow internationally accepted pricing guidelines in order to conclude or in order to value the price of a share on arm's length basis. What do you mean by arm's length basis? Generally, what will be the price if that concerned investor is not a person resident outside India? Arm's length basis for commercial purposes will be saying no. For persons with business connections, you can involve in trading with that concerned person, but it should be done on arm's length basis. That means you are selling to your customers at rupees 120 for a product. Here, even with the person you have, like related parties also, you have to sell in rupees 120. That is on arm's length basis. The price that you offer for a person if he is not having that special status. Here also the same thing. The valuation of a concerned capital instrument of an unlisted Indian company shall be done based on internationally accepted pricing guidelines, that too on arm's length basis. Okay, next, that valuation report shall be certified by a qualified CMA or a qualified CA in practice, or it can also be done by SEBI recognized merchant banker. Very simple. In order to put a price for capital instruments held by a person resident outside India, listed company follow the guidelines given by SEBI. It should not be less than the price declared by SEBI. Now, coming to unlisted Indian company, what you have to do, you have to follow the procedure of valuation by following internationally accepted pricing guidelines, done on arm's length basis. Next, that valuation report shall be signed or certified by a CMA or CA in practice or SEBI recognized merchant banker. Okay, this is for listed Indian company, unlisted Indian company. Now, coming to convertible instruments. Very simple. Now, what will be the price? So, initially, a foreign investor have purchased, let's say, convertible debentures. After 5 years of maturity, he has the option of converting that amount into equity share capital, or else simply just redeeming that debentures principal amount and taking the interest accumulated. He has two options. Now, if he has availed the option of converting that amount into equity share capital, then we have to give him shares, right? So that shares, what will be the price of that shares? In that case, that is what this provision is telling. Very simple. The price or conversion formula shall be fixed at the time of issuance. What is it? Very simple. Let's understand this with an example. Here, let's say on August 1st, 2024, the company A Limited is issuing convertible debentures. So in this agreement, they have specified the details that it will be 5 years maturity. Okay. And after 5 years, you have the option to convert it into equity shares. Now, how will the equity shares will be converted? Of course, you have to put a conversion price. No, why conversion price, madam? Very simple. The total amount will be divided by that conversion price, and you will get the number of equity shares. Let's say in the same case, if convertible debentures are issued, around 10,000 convertible debentures are issued at rupees 100 face value. So, how much did he invest in our company? Let's say 10 lakhs. Yes, 10 lakhs value has been invested by that concerned, rupees 10 lakhs value has been invested by that concerned non-resident, or else you can say person resident outside India. This will be his foreign investment in the form of convertible debentures. It will not be called as equity investment. So, pricing guidelines need not be followed. But after 5 years of maturity, it will be converted. No. What will be the conversion price? You have to fix now only. On August 1st, the date when you are issuing the convertible debentures, that day only you have to fix the conversion price, or else at least fix the formula for the conversion price. Now let's say the conversion price is fixed to rupees 200 per share. Okay, very good. Now first condition is satisfied, no? That you have to fix the conversion price or the price conversion formula at the time of issuance. Done. Second condition is, what is it? At the time of conversion, at the time of conversion, the predetermined conversion price, that is the conversion price you determine at the issuance, or the conversion formula that you have determined at the time of issuance, and you have used that conversion formula to come to a conversion price, that will be called as predetermined conversion price. So that predetermined conversion price should not be less than fair value of the equity shares at the time of issuance. What is this, madam? On the same date, when he issued convertible debentures, the fair market value of equity share is rupees, let's say 225. Rupees 225. Okay. Now, as per the conditions which are given under the pricing guidelines, the conversion price that you are determining at the time of issuance shall not be less than the fair market value of the price at the time of issuance. So at the time of issuance, the market value of share is there, no? The conversion price should not be below that market value. Now in the same example, what is the conversion price fixed? 200 rupees. But what is the market value of the price at the time of issuance, that is on 1st August? 225. So is it complying the pricing guidelines? No, it is violating the pricing guidelines. So here what should happen? The conversion price should be greater than rupees 225 or equal to rupees 225. That is the fair market value of the share on the at the time of issuance. Okay. Then that's all. Very simple. Those are the two conditions. Why conversion price, madam? Let's say in the same example, the value is 10 lakhs. Now you will divide this by conversion price. That is, let's say 200. Now how many shares will be there for you? 5,000. So you will be holding equity shares of 5,000. Now what will be the price? Fair market value on the date of conversion. Okay. Now, the provisions for us are simply given up to determination of conversion price only. First things first, can a company issue convertible instruments to a foreign investor? Yes. Now, what will be the price of this convertible instruments after they get converted, or else let's say the convertible price, that shall be determined at the time of issuance only. So at the time of issuance only, you have to say that the value that you are giving us, around 10 lakhs, this will be converted into equity share based on this conversion price that I fixed right now. So that is what you have to specify in the agreement. But the condition that you have to comply is the conversion price that you have fixed at the time of issuance shall not be less than the fair market value at the time of issuance. Fair market value of what? Equity share. That's all. Okay, don't think too much. It's a very simple provision. First things first, conversion price shall be fixed at the time of issuance, and that conversion price shall not be less than the fair market value of the equity share at the time of issuance. That's all. Okay, done. We are done with the pricing guidelines. Before we get into the discussion of the next provisions, let's understand that with the concept book. Pricing guidelines of capital instruments of Indian companies. So listed Indian company, the price of capital market issued to a person resident outside India should not be less than the price determined according to SEBI guidelines. That's all. Next, unlisted Indian company. Now unlisted Indian company, we can't determine the price based on market conditions because they are not listed in stock exchanges. No. Now what we have to do, the price of capital instruments should be determined using internationally accepted pricing guidelines or methodologies for valuation on an arm's length basis. The valuation report must be certified by practicing CMA, practicing CA, SEBI registered merchant bank. That's all. Next, the last one, convertible capital instruments. What about these matter? The price or conversion formula for convertible instruments must be fixed at the time of issuance of what? Convertible instruments. The conversion price should not be lower than the fair value determined at the time of issuance. Okay, that's all. Moving on to the next concept, which is Calculation of foreign investment. Previously, we have seen pricing of capital instruments. Now we will see the calculation of total foreign investment. That is investment made by the person resident outside India. Okay. Now, first of all, very simple. If that concerned person resident outside India is making investment in the form of equity shares, like by issue of equity shares, that will be part of foreign investment generally. But coming to some other, what do you say, some other forms of investment, will they be part of foreign, will they be part of the calculation of foreign investment or not? Let's see with this. So first, here is equity holdings which have taken place due to debt conversion. Here in the same case, convertible instruments have been, the debt instruments have been converted into equity shares. So that is why that equity holdings will be also part of the foreign investment. Clear? So due to conversion of debt instruments, if that concerned foreign investor is holding equity shares, that value of equity shares will be part of foreign investment. That's very simple. See this, equity holdings due to debt conversion will be part of foreign investment. Madam, after conversion, they will be part of foreign investment. Before conversion, let's say on the date of issuance of convertible debentures, I know that my equity holding after 5 years. So will that be counted as my foreign investment right now before conversion? No. See here, FCCBs and depository receipt with the base instruments as debt instruments shall not be part of foreign investment. It will only be part of foreign investment after it gets converted into equity holdings. That's all. Next, see, methodology of calculation of foreign investment. It is applied at every stage of investment. Now, while calculating the value of foreign investment held by a person resident outside India in an Indian company, the method that you use, whatever it is, that shall be applied at every stage of investment. That is, whenever, see, there is 100 crores of equity held. Out of this 100 crores, 20 crores is held by a person resident outside India. Okay. Now, the value of, I'll explain this with fresh page only. On 1st March 2020, 100 crores is the equity capital. Rupees 100 crores is the equity capital. Okay. And out of this 100 crores, 20 crores, as per the valuation done, 20 crores is foreign investment. Okay. Now, what is the meaning of you have to apply or you have to calculate at every stage of investment? That means if suddenly the company is issuing new shares and the capital, what do you say? The equity capital has risen to 150 crores. Now what happens here? The foreign investment percentage is 20%. Now if it is 150 crores of equity capital and the foreign investment is still 20%, 20 crores, then the percentage of foreign investment will differ, no? So that is what is stated in that concerned provisions. What is it? Here, the methodology for calculation of foreign investment is applied at every stage of investment. That means even if that same foreign investor is procuring new funds, again newly you have to apply the methodology and you have to find out the value of foreign investment. That concerned Indian company is going for bonus issue. The concerned Indian company is going for right issue, or it is issuing employee stock options. In all these cases, equity capital will change. So whenever the equity capital changes, you should again revalue the calculate the foreign investment. Clear? Okay. Those are the three main points under calculation of foreign investment. The other 2 points, let's understand this with a flowchart. Very simple. Case number 1. Now, a non-resident, that is person resident outside India, is making a particular percentage of investment through equity capital in Indian company. Let's say 20%. Okay, so what is happening here? Person resident outside India is making an investment in the form of equity capital in an Indian company, and the value is 20%. Usually it's X percentage. Let's say in our example 20%. Now, done. Leave that part. Now, the Indian company is making a downstream investment. That means it is procuring a wholly owned subsidiary, or procurement, or establishing a wholly owned subsidiary. That will be called as downstream investment. Now, provision number 1 says that if the Indian company is making a downstream investment and having a wholly owned subsidiary in India, the foreign investment percentage in that wholly owned subsidiary should be the percentage of foreign investment in the main holding company. The maximum foreign investment that can be held in the hands of this wholly owned subsidiary company in India in the form of equity capital can be 20% in our example. So if that concerned parent Indian company has 30% of foreign investment, then the wholly owned subsidiary company of this parent company can have maximum 30% foreign investment only. It cannot increase its foreign investment. That's all. Obviously, it can have less than 30%, but maximum should be 30%. More than 30%, it cannot receive foreign investment as a wholly owned subsidiary of a parent company who has foreign investment of 30%. Clear? Specifically, the provision does not say 20% or 30%. It just says X percentage. Okay. This one we will read, we will understand with the sentences in our concept book. So under pricing guidelines, we have seen pricing of capital instruments for a listed Indian company as per SEBI regulations. For an unlisted Indian company, you have to follow internationally accepted pricing methodologies and you have to prepare a valuation report on arm's length basis. This is for unlisted Indian company capital instruments, and that valuation report shall be certified by practicing CMA, CA or SEBI recognized merchant banker. Now, what about convertible instruments, madam? For convertible instruments, the conversion price or the conversion price formula shall be fixed at the time of issuance of convertible instruments. And the second condition is the predetermined conversion price shall not be lower than the fair value at the time of issuance. That is all. Now coming to calculation of foreign investment, the total foreign investment held in the name of the person resident outside India, that in that concerned foreign investment, equity holdings due to debt conversion will be added. But FCCBs, the foreign currency convertible bonds, and depository receipts whose underlying assets are debt instruments, those will not be counted as part of foreign investment. Next, that foreign investment should be, that methodology or calculation shall be done at every stage of investment. That is, whenever new shares are issued, whenever bonus shares are issued, whenever there is a new another person resident outside India making investment in this concerned company, at every stage that foreign investment should be revalued. Because what happens, why are we doing this? We have to calculate the percentage in order to check if that concerned person is following sectoral caps or not. If suddenly due to this more procuring more funds in the form of foreign investment, if you don't calculate at the every stage and it increases the sectoral cap, that means it is not complying with the guidelines of FDI policy. So that is why at every stage you have to calculate the percentage of foreign investment in order to check if that concerned sector or if that concerned non-resident is following sectoral caps or not. That is the purpose. And coming to the fourth and fifth point, very simple. As a person resident outside India, if I make around X percentage of foreign investment in that concerned Indian company, and that Indian company is making downstream investment in the form of a wholly owned subsidiary company, that wholly owned subsidiary company can have a maximum foreign investment that is held by Indian company. So Indian company is having 20% foreign investment, then maximum that wholly owned subsidiary also can have 20% of foreign investment. Those are the conditions that you have to satisfy. Those are listed under the heading of calculation of foreign investment. So we are done with pricing guidelines and calculation of foreign investment. Let's go through these provisions in concept book. Calculation of foreign investment. Equity holdings from debt conversion will be counted as part of foreign investment. Next, FCCBs and depository receipts with underlying assets, or sorry, underlying instruments of debt, are debt instruments, then those will not be counted as foreign investment. Next, calculation methodology. So whatever the methodology that you are using for valuing your investment, that shall be applied at every stage of investment. Next, downstream investment. Very simple. Uses portfolio investment as of March 31st. This one I have not explained you. See this. Wholly owned subsidiaries. Their foreign investment is limited to that received by the parent company making downstream investment. Okay. I have not explained the D1. Sorry, the last one. So if, let's say, I've already told you, you have to value the foreign investment at every stage of investment. But there is no change in equity. That means, let's say at the starting of the year, 100 crores of equity share capital is there, and the valuation is done. And there is no changes, like new shares have not been issued, right shares have not been issued, bonus or else stock options, share warrants, nothing has been done. The equity share capital has not been disturbed. But even then, you have to value the foreign investment as on 31st March. Okay, so the value of foreign investment should be calculated on 31st March every year. Irrespective of any changes are made or not, you have to make the calculation of foreign investment on 31st March. Those are the 5 points that we have covered under the heading of calculation of foreign investment. First thing first, equity holdings due to debt conversion will be counted. FCCBs and DRs with debt instruments will not be counted. Methodology shall be applied at every stage. Next one, downstream investment. Maximum foreign investment that a wholly owned subsidiary can have is the foreign investment which is held by the parent company. Last one, the valuation of foreign investment shall be done on 31st March every year, irrespective of changes made. That's all. Okay, I hope I am clear with these provisions. Moving on to the next, last important part of this concerned chapter. Miscellaneous concepts are still there, but let's move on to the last concept, which is conditions to exit. There is no specific conditions that are needed to comply with. Very simple. So, case number 1. Let's say Maruti and Suzuki case only. Now, Maruti is like, I want to manufacture Wagonrs and Alto 800 and make cheap cars available to middle class families. But Suzuki is like, this is not the motive I came for joint venture to you. I want to expand into luxury cars. But your idea and my idea is conflicting. Okay, fine. I want to sell my investment. Now, is it possible? Yes, of course it is possible. See, if a person wants to exit a partner, let's say joint venture, they are partners. If a partner wants to exit from a joint venture, yes, he can do that. but his share shall be first given to or sold to Indian partner. See, exit from foreign joint venture shall first be given to that value of that partner who is leaving shall be sold to Indian partner. If Indian partner refuses to purchase that concerned share, then what happens? He can sell that to a third party. But of course, you have to follow pricing guidelines. Very simple. If a person wants to exit from a foreign joint venture, yes, he can do that. But first, he has to offer his share to his partner, that is the Indian partner. If that Indian partner refuses, then what happens? He can offer, the foreign partner can offer his share to a third party. And for all these procedures, you have to follow the pricing guidelines. Now, next condition for exit. Indian company. What is it? Indian company with foreign investment. Now, in this Indian company, foreign direct investment has been made. Let's say 60% of foreign direct investment has been made. How much? 60% of FDI has been made. Now, and also second condition, this Indian company is holding shares of another Indian company. What is it? This Indian company is holding shares of another Indian company. That means this Indian company has assets. Has assets in the form of shares of another Indian company. Okay, very good. Next, this Indian company is owned and controlled by person resident outside India. That means management is under which person? Management is under the person resident outside India. Okay, see this. Condition number 1, this Indian company has foreign investment. Condition number 2, it is holding the shares of Indian company. Condition number 3, it has been, what do you say? It has been owned and controlled by person resident outside India. 3 conditions. Now, why are we learning these conditions, madam? For this purpose. See, if it transferred the shares, if that shares which has been held by that Indian company has been or being transferred to, let's say, person resident in India, then pricing guidelines should be followed. Then person resident outside India, pricing guidelines will not apply, but report using FCTRS, that is foreign currency transfer of shares. What is the whole concept behind this, madam? Very simple. Now, I am an Indian company and most of my securities are held by a citizen outside India. Not a citizen, rather resident outside India. Now, the control, everything is like with the person outside India only. Mostly, it will be called as a foreign company only. Now, what happens is, I am an Indian company, of course. I have FDI. Now, what will happen is, I will think of scenario. I am scared that within 1 year, the company will incur a lot of losses and it will go into insolvency. Now, what will I do? I will try to sell the shares at a lesser price. What will I do? I will try to sell the shares at a lesser price so that I can attract Indian investors. Now, what happens? These Indian investors will come and invest in this company and they will suffer the loss. So that is why, in order to protect Indian investors, the condition is laid down in FDI policy that if an Indian company is owned and controlled by person resident outside India and it has a foreign direct investment, then if it is trying to sell shares or transfer shares to a person resident in India, then it should follow pricing guidelines, because they will be trying to sell the shares at a very low price to attract Indian investors. And these Indian investors don't know what's happening inside the company. They will go and purchase the shares at a lower price and they will bear the loss. So that is why what happens is, if that concerned Indian company controlled by person resident outside India is selling shares to person resident in India, it should comply with pricing guidelines. But if it is selling shares to a person resident outside India, there is no need to comply with pricing guidelines, but it has to do that through foreign currency transfer of shares. It has to report using FCTRS because transfer of shares is happening to person resident outside India. Clear? This is the condition. So these have not been asked in the past, so these are not that important, but this might be useful. In a very rare case, toughest question, then these will be asked. But the main important questions in this concerned chapter is prohibited sectors and prohibited persons, and then permitted investment. Permitted investment has been asked in December 2023. Or June 2023. I'm not that sure. Just a moment. These are the December 2023 suggested answers. See this. Under 8A, this question has been asked. Permitted investment by persons resident outside India. This has been questioned for around 7 marks. So, what are the two important questions of this concerned unit? Prohibited sectors and permitted investments. Okay. I hope I am clear with this. So under conditions to exit, let's revise this with the concept book. See. Right to do first refusal. Right of first refusal. When a foreign joint venture decides to sell its stake, the Indian partner has the first option to buy. If that Indian partner declines or refuses, the shares can be sold to a third party. Okay. In that example that I've given you, if Maruti and Suzuki is a joint venture. Now Suzuki is not willing to work with Maruti, which has like a very low grade ideas, and Suzuki wants to expand itself in luxury cars. Now what happens? Suzuki is like, I want to sell my foreign joint venture. Please purchase. It will request whom first? Maruti. If Maruti refuses, then the Suzuki will try to sell it to a third party. Okay. Now, next one, valuation challenges for unlisted companies. So, pricing shares in unlisted companies is challenging because their value isn't publicly known, of course. An independent valuation by reliable agencies is required, complying with RBI guidelines and income tax applications of capital gains. This one we already covered in pricing guidelines only. Okay, that is why it's not necessary. Now, transfer of capital instruments. If an Indian company holds shares of another Indian company with foreign investment, then shares can be transferred to a non-resident reported using FCTRS without strict pricing guidelines. But transfer of shares to Indian resident must comply pricing guidelines. Okay. I hope I'm clear. And then we are left out with miscellaneous concepts. These miscellaneous concepts are not important. That is why I have put them under miscellaneous concepts heading. Okay, so quickly we will try to understand this. These are very simple to understand. See, rights issue and bonus issue. Non-residents can invest in these provided the Indian company complies with applicable regulation. If Indian company follows the rules and regulations for issue of right shares and bonus shares to non-residents, then simply non-residents without any further procedural aspects can subscribe or can, let's say, invest in right shares and bonus shares. Okay. Next, employee stock options and sweat equity shares. Indian companies. So Indian company will have branch offices or subsidiary companies outside India. No. In that concerned branch offices and subsidiary companies, employees will be there, directors will be there. So can these shares, the employee stock options, be given to the employees or directors who are outside India? Yes, see this. Indian companies can issue employee stock options and sweat equity shares to their employees and directors residing outside India. or and employees and directors of their holding company or joint venture. That is their holding company, which is a foreign company, or else joint venture, which is a foreign company. To that concerned employees and directors also, it can issue sweat equity shares or employee stock options. And the next, employees and directors of their wholly owned overseas subsidiaries. So I, as an Indian company, is having a wholly owned subsidiary located outside India. So I can give employee stock options as well as sweat equity shares to the employees and directors who are working in that wholly owned subsidiary company outside India. So this is the, what you say, permitted selling of capital instruments. Okay, next. Now, issue of convertible notes by Indian startup. Now let's understand what is the meaning of convertible notes. So I'm talking about Indian startup. This is a startup company. Still, it did not evaluate its value in market. That's why what happens is they can't issue debentures or debt instruments, or even, of course, not equity shares, because they don't know how to evaluate the price of their share or price of their capital or price of investment in that company. Now what happens is, in that position, they will issue convertible notes. These are not debentures, these are not preference shares, these are not equity shares, but rather these are debt instruments. These debt instruments will, after few years of maturity, Indian startup will know its value. No, at that point of time, they will be converted into equity shares. So when the company is a startup company and it's unable to price its debt instruments like in the form of debentures or equity shares also, then it will issue convertible notes. Those are called convertible notes. So a person resident outside India is permitted to invest in convertible notes issued by Indian startup company for an amount of rupees 25 lakhs subject to compliance of other provisions. So if a person resident outside India is trying to purchase convertible notes of an Indian startup, then maximum amount that he can invest in the form of convertible notes in a startup company is rupees 25 lakhs. That is the condition which is specified in your miscellaneous concept. Okay, so, and the last two concepts. Subscription to Memorandum of Association. What is it? Subscription to Memorandum of Association. So, of course, if a company is trying to be incorporated under the Companies Act 2013 in India, it has to have subscribers to Memorandum of Association. So, can that subscriber be a person resident outside India? Yes. So, what will be the value of his share? Face value. Very simple, because at the time of subscription to Memorandum of Association, the remaining shareholders' price will be at the value of face value. Here also, he will be making investment by subscription to memorandum with face value only. See this. When shares are issued to a person resident outside India as part of subscription to Memorandum of Association under the Companies Act, the investment should be made at face value. For example, the face value of the share is rupees 10. Then he has invested around 1 lakh rupees. Then how many shares he will be holding? 10,000. Very simple. Okay. So that is the concerned provision. And the last one is investment in LLPs. Of course, investment in LLPs is permitted. We have seen in permitted investments now. So investment in LLPs, whether through capital contribution or transfer or acquisition of profits, should not be less than the fair value determined using internationally accepted valuation norms and market practices. See this. Now, if let's say company, it's okay, we will evaluate the capital in the form of shares. Now, how shall we price the capital of a LLP? By following internationally accepted pricing methodologies. Very simple. Why are we doing this? Because how much percentage of profit we should give to a foreign investor? If we don't know the price of the capital, how can we give his share? How can we find out his percentage? So that is why what is this provision telling us? Investment in LLPs, whether directly through capital contribution, that means he is coming into the firm as a new partner, or he is coming into the firm by purchasing the share of an existing partner, and this partner is exiting from the partnership firm, and he is coming in the place of that old partner. It can be both ways. Investment can be done by a person resident outside India. Both ways also, in order to calculate the percentage of capital contribution and percentage of profits that has to be given to this person resident outside India, you have to value the price of that concerned share. See this. Investment in LLBs, whether to capital contribution or transfer or acquisition of profit shares, should not be less than the fair price determined using the internationally accepted valuation norms. So that valuation report shall be certified by practicing CMA, CA, SEBI registered merchant banker. Same is applicable to, unlisted Indian companies, capital instruments, pricing guidelines we have seen already. Okay. So with this, we have completed unit number 2, which is foreign direct investment. So once again, very simple, what we have learned in the miscellaneous provisions. So can a non-resident purchase, right issue, be involved in right issue or bonus issue? Yes, if Indian company follows regulations. Next, if a person resident outside India is subscribing to the memorandum of association, then his shares shall be, his investment shall be made at what value? At face value. Very good. Now, coming to investment in LLPs. So, investment in LLPs can be done through capital contribution or acquisition or transfer of profit. Both ways, you have to determine fair price based on the internationally accepted valuation norms, and that report shall be certified by a practicing CMA, CA or SEBI registered merchant banker. And other two provisions that we have seen is Indian startup company has an option to issue convertible bonds in order to procure capital. Okay, that is still debt. That is still be counted as debt only. But then that will be later on converted into equity. Now, can a person resident outside India purchase this convertible notes? Yes. What is the maximum value that he can invest? Rupees 25 lakhs. Okay, very good. Can employee stock options, sweat equity shares be issued to employees or directors who are residing outside India? Yes. By an Indian company. Case number 1, employees, directors residing outside India. Simply they have gone for a certain project. That's all. You can issue to them. Next, employees or directors who are part of their holding company, which is a foreign company, or else a joint venture, which is a foreign company. Next, employees or directors of their wholly owned overseas subsidiaries. For all these employees and directors, you can, give the employee stock options, issue sweat equity shares. Okay. So, with this, we have completed the second unit, which is the foreign direct investment. The question bank will be discussed at the end of the session. But what I'm trying to do is, the past papers I'm trying to discuss in between the session only, because you will understand which questions are important and which topics are not that important. Okay. So here in this concerned chapter, we have seen two important questions which have been tested in the past question papers. One is prohibited sectors, the other one is permitted investment. Both have been tested for around 7 marks. Okay. So moving on, our chapter number 3, actually as per study material, is external commercial borrowings and trade credits framework master directions. But what will I be teaching and what my order will be is, after FDI I will be teaching Liberalized Remittance Scheme, because that is much more easier for you to understand and link with the first two chapters. So that is why after FDI is done, that is now we will be starting with Liberalized Remittance Scheme Master Directions released by RBI. At the end, the Unit 3 will be discussed. Unit 3, that is external commercial borrowings, will be discussed after Liberalized Remittance Scheme. Okay. So if you fail to understand any concept in foreign direct investment, what you have to do, go back to the video, listen to that concept once again. If not, if you didn't understand even then twice, thrice, you will understand after listening n number of times. Okay, that's it. We will move on to the next unit, which is Liberalized Remittance Scheme. So let's start with the next unit, which is Liberalized Remittance Scheme. The order as per the ICMAI study material is salient features of FEMA, and then we will be dealing with the foreign direct investment, and then ECB, and then LRS. But as per the order of my concept book, the order has changed a little bit. Salient features, FDI, LRS, and then ECB. Okay, so that is the order of my handwritten notes as well as the concept book as well. Okay, so moving on to the next unit, which is Liberalized Remittance Scheme. So this is, in my opinion, is one of the easiest chapters to discuss in the whole 4 units. Out of the whole 4 units, this is the easiest to understand and also attempt, because it has very simple provisions, very simple prohibited remittances and permitted remittances. So if you pay attention, that will be much more easier for you to understand. And one of the advantage in my opinion is, till now in the past 3 new syllabus attempts that has been given from the FEMA, they did not touch Liberalized Remittance Scheme. So maybe there's a high chance this time the question may come from this unit, Liberalized Remittance Scheme, because 7-mark questions, there are 2 7-mark questions which can easily be framed from this question, from this concerned unit. So don't ignore this, because it has not been asked in the past, but there's a high chance they will question in the next attempt, because it's easy and also, what do you say, easy to attempt. Now, let's understand the meaning of LRS first of all. So, Liberalized Remittance Scheme. What do you mean by liberalized, madam? Freely. The concerned scheme is giving a freedom for individuals to freely remit. Remit means spend or send. Remittances include spending money, expenditures, sending money, payments, all these come under remittances. What do you mean by inward remittance, madam? Inward remittance means the receipt of money from outside India by a person resident in India. Usual remittance means sending a money or making expenditure or making payments by a person resident outside, person resident in India to a person resident outside India. That's all. Remittance means we are sending money outside India. That's all. Okay, so here what are we talking about? Very simple. This scheme, keep it in your mind, this scheme is available exclusively for individuals. That means the scheme is not oriented for companies, HUFs, firms, LLPs. Rather, it is just available for individuals, that is the natural persons. Okay. What is the meaning, madam? All resident individuals, including minors, small babies, yes, and minors below 18 years old, they will also have this concerned liberalized remittance scheme available for them for remitting money outside India. So yeah, so all resident individuals, including minors, can remit up to US dollars 2,50,000. Here the amount limit has been given in US dollars. So please be careful while writing the concerned meaning. In a hurry burry, don't write rupees, use US dollars for LRS. Okay. So what is the scheme? All resident individuals, including minors, can remit up to 2,50,000 US dollars in a financial year for permissible current and capital account transactions. So for all the current account transactions and capital account transactions permitted as per the Foreign Exchange Management Act 1999, section number 5 and section number 6, an individual including minor can spend around US dollars 2,50,000 per financial year. That is the simple meaning of the scheme. That's all. Nothing much to brag about. So as a basic individual who is not involved in business, of course, few others like, madam, we don't have money to spend in India only. Where will we get dollars, madam, to spend somewhere outside India? That will take time. But not for you guys. But there are few people who wants to spend their money outside. Okay, don't get offended. So there are few people who wants to spend their money outside India. So for them, RBI through these master directions has opened this new scheme where they can freely remit, freely spend, freely use around US dollars 2,50,000 per financial year, that is per individual. Okay, so this is the meaning of this liberalized remittance scheme. Once again, let's read out the actual definition. See this: all resident individuals including minors can remit, that is spend, up to US dollars 2,50,000 per financial year for any permissible capital as well as current account transactions. Yes, as per the section number 5, current account transaction, which schedule talks about permissible current account transaction. Schedule 1 talks about prohibited expenditure, so prohibited current account transaction. Section 2, which is permissible with the approval of government. Yes, and next schedule 3, permissible freely, but there is a limit. Where did we deal this, madam? Can you say it's? How can you forget it? We have dealt this in the first part, definitions. Now definitions, sections. Excuse me. See this. Schedule 1, completely prohibited current account transactions. Schedule 2, required approval of the RBI. Please don't get confused like me. I just spoke too soon and I said approval of government, but actually you need approval of RBI. Okay, so for current account transactions under schedule 2, you need the approval of RBI, and somewhere else government approval will come. Under government approval route, you need the approval of government, and under prohibited sectors, the last 2 part is there, no, prohibited persons from Pakistan and Bangladesh, there they need the approval of government. Okay, here under schedule 2, we are talking about approval from the RBI. So this schedule 2 transactions and schedule 3 transactions where it is permissible, and also if you have the approval of RBI, you can use your money for spending on these current account transactions, and also capital account transactions, which is permissible as per the Foreign Exchange Management Act 1999. Okay. So we have finished the basic meaning of the liberalized remittance scheme. Now, of course, it is stating that it is available for individuals. That is why it is not available for corporates, firms, HUFs and trusts, etc. That's all. That is the basic thing. And this scheme has first been introduced in the year 2004, February 4. Okay, so it has been introduced on 4th February 2004 with USD 25,000. At that point of time, 25,000 is a huge amount. Dollars. Okay, now expenditures have increased, inflation has taken place, market conditions have differed, wants and desires became more. So that is why they've increased the LRS limit to $250,000. Previously on February 4th, 2004, what used to be the limit? US dollars 25,000. Okay, this is what we have to learn about the introduction. Now let's move on to the next important topic. What are the prohibited remittances? What do you mean by prohibited remittances, madam? In unit number 2, we have seen prohibited sectors for foreign direct investment in India. Now here we are talking about prohibited remittances that can be made by individuals out of this LRS limit. So what is this, madam? Very simple. For these list of activities which are given here, I can't use my US dollars 2,50,000. These are prohibited. That means any amount from an individual cannot go outside India for spending on these activities. Those are called prohibited remittances or prohibited items for which LRS limit cannot be utilized. Okay. So let's understand what are these. Just a moment. Yeah. Let's understand the prohibited remittances. We don't have 10 prohibited sectors like FDI here. It's very simple. We only have 6 to remember. So the first prohibited remittance, rather prohibited purpose or prohibited item or activity is remittances for the purpose of prohibited Schedule 1 under Foreign Exchange Management Act Current Account Transactions 2000 and restricted under Schedule 2. I've already told you where Schedule 1 prohibited, you should not spend your money. Schedule 2, of course, you can't spend the money because you need approval. If you get approval, you can use the money. That is a different thing. Okay. But freely can you do it with, freely can you spend for Schedule 2 transactions? No. That is what we're talking about. Liberalized, no need of permission. Freely you can spend. So that is not applicable for items listed under Schedule 1 and Schedule 2 of the current account transactions. Okay, see this. Remittance, spending of money for activities which are prohibited under Schedule 1 of Foreign Exchange Management Current Account Transactions Rules 2000 and restricted under Schedule 2 under Foreign Exchange Management Current Account Transactions Rules 2000. So all the current account transactions which are prohibited under Schedule 1 and restricted under Schedule 2, you cannot utilize this. You cannot remit the money for those activities. That's all. Very simple. Now the next prohibited remittance. Remittance for the purpose of margins or margin calls to overseas exchanges and parties. If you are familiar with the chapter of derivatives or Forex in strategic financial management subject that you have in your Group 3 CMA Final, or anyone who are familiar with future contracts, forward contracts, what will we basically do? We will enter into a future contract in order to mitigate the foreign exchange reserve. Yes. So in this purpose, you will deposit a security deposit like a margin amount. You can also say like a security deposit. So that security deposit is called margin amount under futures contract. So as an individual who's not a business entity, you are rather prohibited to remit the amount for the purpose of entering into future contracts. Very simple. Future contracts, businessmen will do it just for the purpose of mitigating foreign exchange fluctuations. Now, example, I am an importer of goods in India. I have imported goods from, let's say, Germany. Now, what happened is, on the date of importing goods, the rate, let's say the foreign exchange rate is 1 euro is equals to 100 rupees. Now, that German supplier gave me a credit period. That means it's okay. You have received a bulk order. No, you pay me after 3 months. Now, I am an Indian importer and I'm scared that after 3 months, maybe the euro value will increase and maybe the rate will become 1 euro is equals to 120 rupees. Then after 3 months, I have to pay extra 20 rupees for each euro, no? So that is why what will I do? I will enter into a forward contract or a futures contract where I will trade. What will I do? I will enter into a futures contract by purchasing. What do you say? I will enter into an agreement that on this concerned date, after 3 months, I will definitely pay you with this certain foreign exchange amount. So that is simply mitigating the foreign exchange risk. I'm not going into deep discussions of future contracts and forward contracts because that's not my subject. It's strategic financial management. Simply one thing you have to remember is as an individual, you don't need to enter into future contracts because you're not purchasing huge amount of goods, and you will not be exposed to foreign exchange currency fluctuations. So that is why it is prohibited to spend your money in entering in future contracts. Madam, here it did not specify future contracts. No, simple, my dear. Margin amounts and margin calls are deposited for future contracts only. So that is why remittances for the purpose of margins, that is depositing security, making a security deposit for the future contracts, and margin calls to overseas exchanges and overseas parties is prohibited. That's all. Very simple. Nothing. Don't go much into detail because again it will be like we are starting SFM. Okay. So simple and simply understand remittances for the purpose of margins or margin calls, basically for future contracts to overseas exchanges and overseas parties, that is entities, is prohibited. Because mainly you will say, madam, if you are telling me it's prohibited to enter into future contracts, then how can I mitigate my foreign exchange risk? Arey, you are an individual. Why do you need to enter into future contracts? Because you don't have like a bulk of goods being imported from outside nation and a credit period where you will be exposed to foreign exchange currency fluctuations. No, you are an individual. Basic, your work is simple. Purchase some items for your like bags, necessary assets, or somewhat or the other. For you, foreign exchange risk will not be there. So that is why you are prohibited for remitting your money. LRS limit for margins or margin calls. Okay, that's all. Very simple. Next, moving on to third one. Purchasing foreign currency convertible bonds issued by Indian company in overseas secondary market. What is this, madam? We have already seen the definition of foreign currency convertible bonds. What do you mean by foreign currency convertible bonds? The underlying asset of the foreign currency convertible bond is a debt instrument. Okay. Now, Indian company will issue foreign currency convertible bonds to a foreign company. To a citizens, to non-residents. Okay. Now, what happens here is the non-residents will be able to easily purchase FCCBs because they are not shares in the recognized stock exchange. Okay. So that is why. Now, why is this given in this remittance matter? It is freely, we can purchase. No. We are telling that Indian company, I'll explain this here only. See this. Foreign currency convertible bonds are bonds, that is debt instruments issued by Indian company in foreign currency so that easily non-residents will purchase them. Now, the prohibition that we are talking is, these are especially framed for non-residents. Yes. And after maturity period, later on they could be converted to equity shares. Now, indirectly, these non-residents who are purchasing FCCBs will become equity shareholders. Yes or no? Now, the prohibition here is, I am a resident. I am a person resident in India, and I can easily purchase equity shares or easily purchase bonds. Then why am I purchasing FCCBs in US market? It is prohibited. Because one thing was, I am a person resident in India. I can easily purchase shares of an Indian company. But what am I doing? FCCBs are much more cheaper in foreign exchanges, foreign stock exchanges. Now I will go and purchase that FCCBs in foreign stock exchanges, and after 5 years or 3 years of maturity, I will become equity shareholders with a lesser price or lesser investment. So that is why it is prohibited. Now, if a person resident in India can easily access financial markets, that is recognized stock exchanges in India, or purchase shares slash securities of Indian company at which price? At fair market value as per SEBI. Now, this person resident in India will use his, intellectual brain. And what he will do, I have to spend around fair market value, let's say around 5,000 rupees to purchase one single share. But in foreign stock exchange, FCCBs, that is underlying asset is debt instrument, but after some period it will be converted into equity shares. These are available at a price of just minimal 100 rupees per bond. Not 100 rupees, that will be in dollars, right? It is expressed in foreign currency. Let's say $10. Very simple. $10 amount only, for a very minimal amount. If I purchase FCCBs for $10, after 5 years, it will be converted into equity shares of the same market value. Now, am I allowed to do that as a person resident in India? That is what prohibition is given for you under LRS scheme. Okay? Nothing much. Just a moment, I'll just delete this page. Yeah. So, first one, very simple. You are spending money for the purpose of prohibited or restricted current account transactions, and then you are spending money for the purpose of margins or margin calls to overseas exchanges and parties is prohibited remittance under LRS scheme. And the next, purchasing foreign currency convertible bonds issued by Indian companies in overseas secondary market, that is foreign stock exchanges, is prohibited. As an Indian, as a person resident in India, you are not allowed, you are prohibited to purchase FCCBs issued by Indian company in overseas secondary market. Okay. Next, trading in foreign exchange abroad. This is also was prohibited. What do you mean by trading in foreign exchange, madam? Of course, day-to-day basis, if you see, before 2 years, the dollar value used to be around 75 rupees. Now it is around 80 rupees. Yes, I'm not telling the exact numbers. Now what happened is it has increased. Now, if I simply hold around US dollars for this 2 years and I send now, what happens? I will get the margin of that 6 rupees, no? So that is only called foreign exchange trading. Trading in foreign exchange abroad. Simply what you will do, you will purchase dollars, you will wait for 2 days, it will be increased by just 1 rupee or 2 rupees, then you will sell. You will get that, margin, no? So that is what. So, can you do that with that currency, with that money that is given under LRS remit? Not at all. So as an individual, you are prohibited to trade in foreign exchange currencies abroad. Okay, that's all. Very simple. Next, capital account remittances. That means spending money for the purpose of capital account transactions in countries like non-cooperative countries and territories issued by Financial Action Task Force. Okay, two new terminologies. What are these, madam? Financial Action Task Force. This is an intergovernmental body. That means it is not a body specifically oriented for a country, but rather it is like, let's say, United Nations, WHO, less World Health Organization. So likewise here also this is an intergovernmental body where all the countries will be members and they will come together and make decisions. This is basically oriented for the purpose of, what do you say, curbing or else trying to control money laundering activities between countries for the purpose of terrorism activities. So that is the main motive of this concerned intergovernmental body, which is called Financial Action Task Force. Now that, leave it aside, that is not needed for us. Now what is this prohibition telling us? Very simple. If you are making any capital account transactions, what are capital account transactions? Purchasing assets, making investment, procuring a loan from that concerned country which has been given a status of non-cooperative countries and territories by this intergovernmental body. See, the Financial Action Task Force will give a status that is non-cooperative countries and territories to few nations. So if with that few nations, you are prohibited to enter into capital account transactions. Very simple. Example, what is these countries, madam? There are two types of countries here: blacklist countries and grey list countries. Blacklist countries are this North Korea and Iran. North Korea and Iran. Why? Because of course Iran terrorism activities are quite quite popular, let's say, and North Korea, they are not easily opening their economy, like what's happening there, and they are not being transparent to other countries. So that is why that is also put in the blacklist. So entering, making capital account remittances, purchasing assets, taking loans, making investments in that particular countries is prohibited. Now what about grey list countries, madam? Very simple. Grey list countries include this: Philippines, Turkey, South Yemen, all these African countries, and some other countries where there is a high risk of this money laundering being taken place, or huge flows of money will be taking place for terrorism activities. And popular example can be Pakistan, Syria. So likewise, so these are all called grey list countries, and together blacklist countries and grey list countries are called non-cooperative countries and territories. The status is given by which government, intergovernmental body? Financial Action Task Force. Okay, so capital account remittances into these countries, that those are called non-cooperative countries and territories, issued by Financial Action Task Force, is prohibited under the LRS scheme. And the last prohibition, what is it? Remittances, spending money or sending money to individuals or entities, let's say individuals or corporate bodies or firms identified as posing significant terrorism risks, advised by RBI. RBI is like this concerned company or this concerned group of people from Myanmar are posing significant threats of terrorism risks. So you are prohibited to remit any amount. Fifth one, we're talking only about capital account remittances, and here we are talking about all the remittances, even sending a single rupee or a single foreign currency. It is prohibited. See, how will you know if that concerned person is posing significant terrorism risks? It will be advised by RBI. How will you know? Of course, you will not know. If you know, you will also be put in blacklist. Because how come you know that terrorism activity is going on? Did anyone call you? Are you involved in the group? All these, procedures will be going on. So that is why you don't know it. Simply, it will be advised by Reserve Bank of India. Okay. So the last remittance, once again, what is it? Remittances, that is sending money to individuals or entities identified as posing significant terrorism risks, which is advised by Reserve Bank of India. Okay, so Those are the 6 remittances which are prohibited under your liberalized remittance scheme. That's 2,50,000 US dollars cannot be utilized for these 6 purposes. What are those again? First one, remittances for the purpose of Schedule 1 prohibited current account transaction, Schedule 2 restricted current account transactions. Next one, remittances for margins or margin calls to overseas exchanges and parties. Next, third one, purchasing foreign currency convertible bonds issued by Indian company in overseas secondary market, that is restricted. Okay, prohibited. And then trading in foreign exchange abroad, trading in foreign exchange fluctuation, foreign exchange currency transactions and all that stuff, it's prohibited. Next, capital account remittances, the capital account remittances to countries which are been listed as non-cooperative countries or territories by Financial Action Task Force. And the last one, remittances to individuals and entities which are which have been identified as posing significant terrorism risks advised by the Reserve Bank of India. That's all. This is, let's say, one of a kind of important question that may be asked. Okay. Next, we have seen prohibited. Okay, madam, these are prohibited. Fine. Now, for what purposes we have to use this 2,50,000 limit? They've given you, see. First, what is it? Okay, what is the heading? First of all, we're talking about permissible uses for liberalized remittance schemes. So for these purposes, you can utilize or you can spend the US dollars 2,50,000 LRS limit. So first one, private visits to any countries, your tourism purposes. Madam, I want to go to Paris, London, US, Norway, Switzerland. So can I do that by utilizing this $2,50,000? Yes, you can do it because it is a permissible, permissible remittance under LRS scheme. First one, private visits to countries except Nepal and Bhutan. Okay, next, this Nepal and Bhutan is not given under the permissible uses. And the next, studies abroad. For the purpose of studies abroad, using all your engineer friends will be like, after the BTech, I will be going to US for doing MS. Of course, they need money, no? From where will they utilize that money? $2,50,000 LRS limit. That's all. Okay. So first thing, private visits to any country except Nepal and Bhutan. Okay. And next, studies abroad. And third, uses gifts or donations. If you want to gift someone or make a donation to a person distant outside India or to an entity which is person distant outside India, you can do it. Okay. And the next, expenses for medical treatment abroad. So if you are going under surgery or a medical treatment or a cosmetic surgery or whatsoever it is, so spending money for that purpose, medical treatment, you can do it. Next, going abroad for employment. Of course, if you're going abroad for employment, you need money. Why, madam? There only I will receive money. No, they won't give you immediately. No, only after 1 month or 1 month of your work, they'll give you. But that money is also not sufficient. You have to take some of the money from here in order to survive. So that is why you are using that US dollars 2,50,000 for going abroad for employment. Yes, it is permissible use of LRS. And the next is immigration. What do you mean by immigration? Completely going out of India and settling in another nation. That is what few of the software employees, families will do. No, H1B visas, they'll apply and they'll go and settle there. So that is what we're talking about, immigration. Going to live in a country outside India. Of course, you need few expenses. So that is what you can use it from this LRS limit. And the next, maintenance of close relatives abroad. Some relatives will be there. Not relatives, our sons. What do you say? Let's say our parents, grandparents. Okay, we have to send them money. Now, these people, they'll be like, oh, I finished my BTech. Now I'm going to MS. So they'll show us as if they are settled. But even then, what happens is they'll call their mummy, Daddy, please send some money. I can't survive in this country with my own money. So for these people, they have to send money. No, So that is why that LRS limit 2,50,000 you can utilize for sending money to relatives abroad. So this relatives word will contain all the relations which are specified under the Foreign Exchange Management Act. Close relative. Okay, so now, and the next seventh permissible use is travel for business. So specifically for the purpose of finishing a project with a client, or for the purpose of attending a conference, or for the purpose of attending some training programs, or medical expenses. What's the difference between medical treatment and medical expense? First things first, definitely you have to go perform surgery. There, if you want to perform surgery or not, for taking some diagnostics, like that, it's called medical expenses. Purchasing some medicines or whatsoever it is, pharmacy expenses, all will come under medical expenses. Medical treatment is you're taking a surgery. Okay, so those two are different, but both are permitted. Okay, not much to think about. And the next, attendant to patient going abroad. So any expenses that attendant who is there, the person who is like acting as a nurse, or a person who is acting as a support to the person who is receiving medical treatment. So there's an old age person of age around 70 years, and he is receiving treatment for some chronic disease, and he can't do all these activities by himself. So of course he needs some help, and his wife died. Now someone has to be there to help now. So that is why his very lovely sons and daughters will appoint him a attendant who will assist him regarding this treatment, and for survival, cooking, cleaning, everything. So this person also you can spend around 2,50,000. This person who is there, attendant, that person, he or she, he can also spend around $2,50,000 in order to survive in that outside country. Okay, those are the provisions. Those are the permissible uses for liberalized remittance scheme. And the last permissible use is any other current account transaction not defined under FEMA. We have already seen under the section number 5, current account transaction. So if any current account transaction which is not listed in the above Schedule 1, Schedule 2, Schedule 3, is it prohibited or permitted, madam? It is freely permitted, and no limit is also specified. Under the Schedule 3, they said there is a limit specified for transactions, but you can freely do that up to the limit. But if there is any activity or a transaction which is not listed in the Schedule 1, Schedule 2 and Schedule 3, that is freely permitted. So using your LRS limit for entering into transactions which are not listed, not listed or not defined under Foreign Exchange Management Act, yes, it is permitted. Once again, quickly we will revise what are the permissible uses of the LRS. So what is the first one? Private visits to any country except Nepal and Bhutan. Second is studies abroad. Third is gifts or donations. And fourth is expenses for medical treatment abroad. Fifth, going abroad for employment. Sixth, emigration. Seventh, travel for business, conference, training, medical expenses, attendant to patient going abroad, and maintenance of close relative abroad is the eighth one. Last one is any other current account transaction not defined under Foreign Exchange Management Act 1999. That's all. So this is these two, prohibited remittances and permissible remittances, are one of the important questions of this concerned unit. So once again, we will see if we have covered everything in our concept book. Yes, private visits, gifts, donations, employment, immigration, maintenance of close relatives, business, conference, specialized training, medical expenses, attendant, expenses for medical treatment, studies abroad, all these are covered. This also we have covered. Schedule 1 transactions, Schedule 2 transactions, margins and margin calls, purchasing FCCBs in secondary market, trading in foreign exchanges, capital account remittances to countries identified as non-cooperative countries and territories, and last, remittances to individuals identified as posing significant terrorism risks. For your convenience, I have highlighted the important points in red. Here there is no important points. Simply you have to write complete sentences because the sentences are only very short. Here also you want important. Okay. So, moving on to the next concept, which is consolidation of remittances. What do you mean by consolidation? You do consolidation of financial accounts. Now, what you will do? You will consolidate the financial statements, the balance sheets, and the profit and loss statements of two companies. Here also, what we are talking here is consolidation of remittance. So, for each individual, as per the LRS scheme, 2,50,000 amount is the limit that concerned individual can spend for. Now, example, if a family wants to purchase, what do you say? Purchase an asset, let's say a villa in London that costs around, that's a very basic, just a moment. I'll explain you with an example. Whose name we'll take? Okay. Let's say Raha, Bollywood baby. Now, in this example, she's not baby, okay? Remember this. So, Raha and Alia and Ranbir. Yes, a family, no? Now, as per the LRS scheme, what is the limit of each and every person in this family? 2,50,000 US dollars, 2,50,000 US dollars, and 2,50,000 US dollars. Now, Ranbir, when he went to some shooting abroad, he came across some wonderful villa. Of course, the villa does not look like this. Please don't mock me. Wonderful villa. Now he's planning to purchase. He's planning to purchase this villa. But as an individual, he can only spend around $2,50,000 now. But this villa's down payment that has to be done in this concerned year, down payment. Down payment is only 7,50,000. What is it? $7,50,000. Okay, I said London now. Yes, you can do that one. I'll discuss later. Let's say US only. Okay. Down payment is only how much? $7,50,000. Now, for this purpose, can he utilize Alia's and Raha's LRS limit together and combine them and spend on this concerned capital account transaction? Because purchasing of a villa is a capital account transaction, no? Yes or no? There is a condition. Yes, you can do that, but there is a condition. Here, for this villa, there will be 3 joint owners. Who will be the 3 joint owners? Raha, Alia, and Ranbir. They will be holding the share of the ownership for around 33%, 33%, and 33%. Clear? So, the condition here which is specified is, see, you can consolidate or combine the remittances of your family members for the purpose of capital account transactions. Yes, actually generally no, but except unless if acting as co-owners or partners. If it is making an investment in a company, then you will be entering into a partnership. Now here, purchasing an asset, you will be joint owners or co-owners. So you can consolidate the remittances of your family members for the purpose of capital account remittances only if that concerned persons are acting as co-owners or partners. But generally, if you are not acting as co-owners or partners, in the same example, Ranbir is like, why will I give you co-ownership? Your kids, I can't give you. So can he combine the remittance? He cannot do it. Very simple. See this. Now, if he is not willing to give co-ownership to Alia and Raha and he wants to act as the sole owner of this villa, can he combine the limits and make the down payment of $750,000? No, he cannot. He can simply purchase that villa, but for one financial year, he can make only 250,000 payment. He can still purchase, and he can convince the owner that please accept 250,000 for now, no, and after 1 year I'll pay you the remaining. So there is a condition which is specifying regarding the consolidation of remittances of family member in case of capital account remittances. But for other current account remittances in the same case, all these three are trying to plan a trip, trying to plan a luxurious trip to Norway. Now, in order to survive, like purchase of luxury goods or hotel expenditures, next food expenditures and adventures, and of course travel expenses, for all these of course it will be more than $250,000. Yes or no? So that is why what happens is, for this purposes which are not capital account remittances, they can still consolidate together. That means now Ranbir, for this purpose of trip, he can combine the earnings, the remittance, the amount available for remittance, the LRS limit of Raha and Alia together, and he can spend together around $750,000 for this current account transactions. Okay, clear everyone? But for the purpose of capital account remittance, I've told you, for the purchase of an asset, for making investment, you can consolidate only if you are trying to become the co-owners or partners. But if you are not having an intention to acquire co-ownership or become the partners of that investment, you cannot consolidate the remittances for the purpose of capital account transactions. Okay, I hope I am clear. Okay, now let's read the provision which is given here. Consolidation of remittances of family members for the purpose of capital account remittances is prohibited, except unless if acting as co-owners or partners. But for the purpose of other remittances which are other than capital account transactions, yes, you can consolidate the remittances of your family members. Okay, see this. Just a moment. We will read this concept in our concept book. Family members. Remittances can be consolidated for close family members, but each family member must follow the scheme's rules. So each family member should again follow the scheme's rules. Let's say Ranbir has utilized the 250,000 of Raha and Alia. Now Alia is like, I want to purchase some luxury bag in Dubai. This is a new brand which is released. So can she utilize this 250,000 for this some other purchase? She cannot do that. So for individuals, it is all the rules are applicable, and combined together they can utilize for the purpose of transactions which are other than capital account transactions. Okay, next, capital account remittances. Family members cannot pool funds for capital account transactions like opening bank accounts, making investment, purchasing properties, unless they are co-owners or partnerships. Even in this case, if they are together opening a joint account in some other foreign bank, can they do it? Yes, they can do it if they are joint holders of the account. Okay, next, last one, gifting provision. What is it? Person resident in India, Indian resident only, is gifting foreign currency, let's say dollars, to a person resident in India only. Can he do that? He cannot. See, person resident in India cannot gift foreign currency to person resident in India, which will be credited to this person's foreign currency account. So let's say my dad is holding a foreign currency account, let's say resident foreign currency account, where the money will be in the form of dollars. So as a person resident in India, I want to transfer around 1 lakh US dollars as a gift. What? As a gift to my dad. in the form of US dollars only. In the form of US dollars only, I'm sending the money to my father. So can I do that? Of course not. If you want to gift a person resident in India, gift in Indian currency or gift in the form of some object or some other asset or something or the other. But you cannot gift to a resident in the form of foreign currency by depositing the foreign currency in his foreign currency account held outside India. So if my father previously used to spend around 5 years of his job in US, at that point of time he has opened a bank account in US, and now in 2024 I am trying to gift my dad my LRS limit में around 1 lakh US dollars to my dad. And now what is he doing? He is depositing that in his bank account of US. So can this happen as per the regulations under the Liberalised Remittance Scheme? No, not at all. So if you want to gift, very simple, gift in Indian currency or gift in the form of some objects. That's all. Okay, so gifting foreign currency to a person resident in India, and that foreign currency is being deposited in a bank account outside India is prohibited. Okay, so that's those are the provisions regarding this heading. That is what I've dealt in the concept book as well. See, residents cannot give foreign currency to other residents for depositing in their foreign currency accounts held outside India. Next, just we have few more provisions left out, which is bank procedures of LRS, do's and don'ts of authorized dealers, remittance by sole proprietorship, and facilities for entities outside India, and rupee loan. With this, we will be completing our LRS chapter. Now, moving on to the next concept, which is bank procedure. You say, madam, we can remit up to $250,000. So I can simply purchase the assets using my Google Pay or Phone Pay account? Not at all. You have to follow the procedures. That means every transaction should happen through an authorized dealer. That one in section 3 and section 4 only we have seen in unit number 1. Here also, what is the bank procedure that you have to follow is very simple. In order to spend the LRS amount, first things first is choose a branch of authorized dealer bank. So authorized dealers are simply banks. I might say authorized dealer. If I say authorized dealer, it will look like some other person, but very simple. ICICI Bank, Axis Bank, HDFC Bank, all these banks will have a separate wing which is registered as an authorized dealer with the RBI, and they are eligible to hold foreign currency and also deal in foreign exchange transactions. Okay. So first things first, I will choose an authorized dealer bank branch. After that, after that, I will open a bank account for the purpose of foreign exchange transactions. Now what happens is, for capital account transactions, now after opening the bank account, I want to spend my US dollars 250,000 for the purpose of purchasing an asset or making an investment in a foreign company, or some other purchase of securities outside India. These are all called capital account remittances. So can I do it immediately after opening a bank account with the authorized dealer bank? No. So if you are spending for capital account transactions, the account that you created must be maintained with the bank for at least 1 year. So you should open a bank account with an authorized dealer, deposit your US dollars 250,000, wait and maintain that bank account for at least 1 year, and then only you can make capital account transaction. But for the purpose of current account transaction, simply for making any purchases, for expenses, for this day-to-day expenditures, should I wait for 1 year, madam? Not at all. For other remittances, you can remit immediately using your bank account. Okay, that's all. So all these transactions can be made in any freely convertible currency. So you might be in a perception that, ma'am, can we only spend dollars? Because I want to purchase few goods, or I want to go to Europe where euros are there. So these LRS scheme is giving me only dollars. Not at all, my dear. This dollars are just a representation of value. So let's say, as per the rate here, see, $250,000 is equal to 2,26,500 euros. So if you want to spend the same limit in the form of euros, this will be the maximum amount that you can spend. This will be the maximum amount that you can spend. So it's not like you are only allowed to spend US dollars. You can spend anywhere. For example, here only you are trying to let's say you're trying to spend in Hong Kong. What you can do, you can spend around 19,47,535 Hong Kong dollar in that concern. Let's say you're trying to spend your money in Japan. What is it saying? See, you can spend around 3 crore 67 lakh 67 125 Japanese yen. Okay, so this $250,000 is just a base amount. You can use this dollars, convert it into any foreign currency, and you can spend it. Okay, so that is what it is specifying here. What is it? Account. See, it can be made the LRS transaction. That may be for capital account transaction or current account transaction. It can be made freely in any freely convertible foreign currency. It's not like you're not obligated simply to purchase only, simply to make purchases only in US dollars. You can purchase in any freely convertible foreign currency, but the base limit is dollars. It's represented in dollars. Okay, done. Okay, so these are the bank procedures. Very simple. What is it? Open a bank account, choose a branch. Now if you're doing a capital account transaction, wait for 1 year. Not capital account transaction, other remittances, easily you can do. Is there any condition that you have to spend only in dollars? No, any freely convertible foreign currency you can spend your LRS limit. Now, on behalf of an authorized dealer, okay, you are a person, you are an individual, you will be using your money for making expenditures, for purchasing assets, making investments outside India. But all these are happening through an authorized dealer. No, RBI is not involved, or any other department is not involved to monitor. Like, for which purpose are you? Okay, as a normal citizen, what we will be using these US dollars for? Very simple. Purchasing some luxury goods, or tourists, for the purpose of tours, and for the purpose of medical expenses, for the purpose of studies abroad. This is the general thing. But few people will try to utilize this scheme for some illegal activities. Let's say prohibited sectors only. Let's say gambling activities, or else funding to terrorist groups, or else purchasing some illegal weapons outside India, because easily you can purchase weapons in outside India, let's say Africa, or else Iran or Syria, likewise. So what happens is, in the duty of an authorized dealer bank is to verify the source of funds. First thing first. If I am trying to spend $250,000, it's not like government is giving me $250,000 for spending. No. Very simple, my dear. Government is not giving me $250,000. It's just a limit. So in order to spend $250,000, let's say here, $250,000 in Indian rupees. How much? 2 crores. 2 crores 9,82,625. Now suddenly you will go to an authorized dealer and say that I want to utilize my LRS limit of 2,50,000. See, here is 2 crores. I'm throwing on your face. Give me LRS limit. Give me $250,000. Will authorized dealer simply without any verification give you? First he will verify. First he will verify the source of fund. From where did you get this 2 crores? Suddenly, I didn't get you, because your Indian bank accounts did not show this much amount, and as per your income tax statements and everything, you should not possess this much funds. No, from where did you get this 2 crore funds? Now you will mention the source. You will say that I have sold the property, I have sold this concerned property, and now after paying tax, this is the capital gain that I have received. So this I want to utilize for the purpose of purchasing an asset or making remittances outside India under this LRS scheme. So that is what the first duty of authorized dealer is: verify the source of fund. From where did this Indian resident get these sources in order to spend outside India? Okay, next, ensure due diligence in capital account remittances. For example, what are capital account remittances? Purchasing of assets, making investment. Now, authorized dealer. Now, this concerned person will come. I want to purchase securities of Afghanistan, some company in Afghanistan. Now you will say, which company, sir? This, I'm an authorized dealer. Some person is coming to me and saying, sir, I want to purchase a few shares of an Afghanistan company. I've heard in a YouTube video that they are making a huge profit, that I will receive a lot of money. And now as an authorized dealer say, sir, which company, sir, in Afghanistan? Madam, I don't know, madam. It is like some different name, which is Al Arab. Al Arab. Okay. Can you show me the details regarding the investment, sir? He will show some documents which are fabricated. Now, what are you doing here? Investment in Afghanistan is not prohibited. Usually, as per the guidelines of the RBI or master direction, investment in Afghanistan is not prohibited. But as an authorized dealer, it is your duty to check due diligence of the capital account remittance. That means easy rationally making the investment, or simply is making because he don't have enough information about that about that concerned capital account remittance. So what will I do in this case? I will say, sir, there is no such company in Afghanistan like that. You have been that YouTube video is fake, sir. If you spend 2,50,000 to that concerned person, he is some terrorist group, sir. You will be put in jail. Now this will be communicated by the authorized dealer. Now he has to check due diligence in capital account transaction. Same person will come and say, I want to invest in I want to purchase a villa in London. Now what you will do, you will check the address of that villa, and you will also verify with the owner of that villa. So is he willing to sell that concerned property, yes or no? So is the transaction actually happening or not? Of course you will verify. It's not like he has to seek your permission, but he has to verify the sources. If all the sources are clear and transparent, then you will say, yes, you can do that, sir. You're given, now you can remit the amount. You can utilize your LRS limit. So the due diligence, that is proper care of for what purpose this capital account remittances are being done by this resident individual, is the duty of the authorized dealer. First thing, he has to verify the source of funds. Next thing, ensure due diligence in capital account remittances. And next, ensure the genuineness of the transactions. What is genuineness? Simply, I've already told you. Now he will say that I'm trying to purchase a villa in London, but he has taken the transactions and has diverted the funds to somewhere, some terrorist groups. Now he has to verify, as an authorized dealer, I have to verify where all this concerned amount is traveling to. Is this concerned track genuine or not? Is the owner there genuine or not? Verify the concerned agreements and documents and contracts and everything, and ensure there is a genuinity in the transaction which is happening. Okay, so that is what are the do's, that is the duties of an authorized dealer. Then what are the don'ts as an authorized dealer? Very simple. As an authorized dealer, he cannot extend, here he means bank, okay, the authorized dealer cannot extend fund or non-fund based facilities for capital account remittances. What is fund or non-fund based facilities? Very simple. Now a person will come, sir, I want to utilize my LRS limit, $250,000. I have some amazing investment came across to my mind and I want to purchase that, but right now I don't have funds. Right now I don't have funds, but I really want to purchase this beautiful villa, sir, because that person is giving me only for $1 lakh. That's very beautiful, lot of facilities available, sir. You will check. Of course it is of course that owner is willing to sell for $1 lakh. Okay, now that concerned Indian resident is coming to authorized dealer and telling that please extend me the loan in the form of US dollars. Now I'll pay you back with interest. So can an authorized dealer extend fund-based facilities? That means giving loans, or non-fund-based facilities. That means giving guarantees to that concerned person making capital account remittances? Of course not. That is a prohibition which is laid down for the authorized dealer. Very simple. So authorized dealers cannot extend fund or non-fund based facilities for capital account remittances. So for current account transactions, can you extend loan? Yes, you can do it. Because for current account transactions, the authorized dealer will extend short period loans, like 3 months, 6 months loans. Simply they will be paying back. But for capital account remittances, authorized dealers is not allowed to extend fund-based or non-fund-based. Fund-based directly giving loan, non-fund-based extending guarantees or giving letter of credits. Okay. So this is the first don't. Next, cannot conduct transactions prohibited or restricted by RBI's approval. So if a person is coming to an authorized dealer and asking for money or asking for transactions to be performed which are prohibited or restricted to RBI's approval, as an authorized dealer, you cannot conduct those transactions. Of course, as a resident, you can't spend the money for the transactions. But if that resident is coming to the authorized dealer, even authorized dealer also cannot conduct the transactions which are prohibited or restricted by RBI's approval. Those are the do's and don'ts of an authorized dealer. So please, for God's sake, don't write as do's and don'ts of authorized dealer as an example in exam. Simply for better understanding, I have laid down in this format, but as follow your concept book for writing in your examination. So consolidation is done. This theory I did not include in your handwritten notes. Just simply we will revise in the concept book. What does it matter? Very simple. What is frequency? So is there any restriction that I have to utilize this $250,000 only in 3 installments? Only 3 times you can utilize this $250,000. You can't utilize it every single day. There is no such restriction. There is no limit on the frequency of how frequently you will spend this $250,000. Okay, simply you can, madam, can I spend every day 1 lakh? Every day I will be sending $100 to my family members. Can I do that? Yes, you can do that. There is no limit on the frequency of transactions under the LRS limit. Next, annual limit. Of course, for a year, the annual limit of LRS is US dollars 250,000. See, that is what. Frequency, there are no limits on how often you can make remittances under LRS. And next, annual limit, the total amount remitted from all sources of India during a financial year cannot exceed US dollars 250,000. Okay. So is it like from ICICI authorized dealer, they are spending 250,000. From HDFC authorized dealer, you're spending 250,000. From Axis Bank authorized dealer, you're spending 250,000. Can you do that? No. From all sources in India, in total, annually, you can spend around US dollars 250,000 only per head. Okay. Next, further remittances. What happened if 250,000 is over, but still you want to purchase something? Can government, or can you just go to government or RBI, get an approval and increase your limit? Not at all. See, further remittances. Once the US dollars 250,000 limit is reached in a financial year, no additional remittances can be made under LRS, even if invested funds are brought back to India. So initially, year starting, let's say 1st April, you have invested 1 lakh US dollars out of your LRS limit in some investment outside India. Okay. Now, after 6 months, you have brought back that 1 lakh investment and also some interest which is generated around 20,000 US dollars. Now what happened is, initially I have spent $1 lakh out of this $250,000. No, now after 6 months in the same financial year I have brought back $1 lakh. No, now can I use this $1 lakh? Not at all. Not at all. Sorry, serious look I've given. Okay, not at all. Once you have spent $250,000 in a financial year, even if you bring back the $250,000, you cannot utilize more than that. Very simple. Okay, that is the limit mentioned here. Next, last one, earnings remittances. Now, I am a foreign citizen. So I am a citizen. I'm born and brought up in Europe, and now for some employment purpose and for some project purpose, I came to India. Now all the earnings that I make in India as a foreign citizen, I am sending that to my family in my home country. And as an individual, here also, of course, because I'll stay for more than 1 year, no, as a foreign citizen here, I will come under the category of LRS. So I will be given the option of LRS. Now all my earnings have sum up to $250,000 and I've sent it to my family member. Here also, this foreign citizen can send this money as an individual under LRS scheme. But here he is a foreign citizen, no. If extra earnings if he has from other sources of income, let's say freelancing or some other investment he made in India, he has earned more than $250,000. So, but he wants to send back that income to his home country, because what he will do with that income in India? So that, for that temporary reason, is there any option? Yes. For residents not permanently living in India who have remitted all their earnings and wish to send additional other income, they can apply with the RBI through authorized dealer. Through authorized dealer, they can go apply with the RBI that I am a temporary resident. I have sent $250,000 to my family members in home country, but I have more earnings which are left. But I don't want to utilize this money in India. I want to send back to my home country. Please give me permission. This can be done for residents who are temporarily living in India. Okay, not permanently living or temporarily living. Fine. Okay, so these are the limits. Bank procedures, we have already seen. What is it? You have to choose a designated branch first. Choose a branch of authorized dealer for making all capital account remittances and current account remittances. The account must be maintained with the bank at least 1 year before making a remittance. For capital account remittances, for current account remittances, there is no obligation for maintaining the bank account for 1 year. Next, due diligence. ADs must verify the source of funds and ensure due diligence for the capital account remittances. Next, currency. Remittances can be made in any freely convertible currency. Next, authorized dealer banks can conduct remittance transactions without RBI's permission if all current account transactions are not prohibited and not restricted. So if a current account transaction is not restricted, not prohibited, so do authorized dealer need permission of RBI? No. Next, authorized dealer banks must ensure the genuineness of the transaction. Next, LRS does not allow AD banks to extend fund or non-fund based facilities to resident individuals for capital account transactions under LRS. However, AD banks can provide such facilities for current account remittances under the scheme. Next, LRS does not have specific ratings or guidelines for investments up to US dollars $250,000. Investors should read. I've already told you, due diligence should be verified by authorized dealer. Authorized dealer should check if that person who is making investment has rationally put in an idea for making that investment or not. But you know credit rating, right? So for giving for a bank, in order to give loan, first it will go check your credit rating. So what is this credit rating? Credit rating is giving you a rating as a person. CIBIL is giving you a rating regarding how well you can repay the loan, how well you can repay the EMIs. So likewise, ratings will also be given to investments. So will this investment procure enough profit, will this investment make profits, will this investment achieve good capital appreciation or not. That ratings will be given to investment. But here what it is specifying under LRS scheme is ratings will not be given to investments up to $250,000. Okay, clear? So if you're coming to an authorized dealer and you're telling that I want to invest around 2 lakh US dollars in some investment, please mention me the ratings. No, ratings will not be specified. See, LRS does not have specific ratings or guidelines for investments up to $250,000. Okay, that's all regarding this. Now moving on to the next concept, we have around 1, 2 and 3 concepts left in this chapter. Okay, very simple concept. What is it? Remittance by sole proprietorship. So under sole proprietorship organization that we have seen in CMA Foundation, is there any feature owner is separate from the business here? No. Here owner is having an unlimited liability and he does not have a separate legal entity. What is it? The sole proprietorship concern does not have a separate legal entity. Now, the sole proprietorship organization wants to utilize the, wants to spend US dollars outside India. Now, what happens? For sole proprietorship organization, you say, Madam, LRS is only available for individuals, not for corporates. No. LRS is available for sole proprietorship concern because sole proprietorship concern simply the LRS individual will only be the owner of it. So it is representing the individual only. Okay. So that is why here, since for sole proprietorship concern, there is no legal separation by the owner and that concerned sole proprietorship concern, the limit of US dollars is shared between business purposes as well as the personal purposes. For example, Mr. A has a sole proprietorship concern which is named as A only. Now, this concerned sole proprietorship organization want to purchase an equipment from outside India, which will cost around 1 lakh US dollars. Now the owner is like, will go to the authorized dealer and will say, it's a separate entity, no? So will it have any, this is my sole proprietorship for, this transaction is for the purpose of sole proprietorship concern, no? Will my limit be exceeded and be given 2,50,000 for my sole proprietorship concern and 2,50,000 for Mia? No. That 2,50,000, which is the limit available for that individual owner, that only shall be utilized for both business purposes as well as personal purposes. Let's say if the owner remits, that is spends around US dollars $2,50,000 for his personal expenses. Now, can he remit any amount outside India for business purposes? No. This is the special provision that we are learning about. Usually, generally what we have seen, this scheme is only available for individuals, but this scheme is applicable to sole proprietorship concern also. As the sole proprietorship organization, that owner is having the 2,50,000 limit both for business purposes as well as personal purposes. That's all regarding this. Okay, and now we are left out with two more topics, which is facilities for entities other than individuals. Till now, LRS scheme that we have seen, it's only applicable to individuals. Now, what about facilities for other people, madam? As a business entity, of course, I need to spend. Now, what is the facility available to me? So, these are the facilities available to entities other than, other than individuals. Okay, and the last concept is extending of rupee loans. Okay. Let's move on to the next concept, which is facilities for entities other than individuals. So LRS scheme is available only for individuals. Then what about entities or corporates which are not individuals, and are they not allowed to remit any amount? Is there any separate scheme available for them? Let's see in the facilities. Okay. So these are exclusively facilities available only to entities other than individuals. Let's see the first facility, which we're talking about, donations. What do you mean by donation? Very simple. For charity purposes, you will give some money. outside India. Here everywhere we are talking about remitting the amount outside India. So here also the donations are made by entities other than individuals to outside India. So what is the amount of donation that we can make, madam? Or for what purposes we can make donation for? For every purpose, will it be counted, or is the facility available for making donation to any other purpose? Let's see with this concerned provision. Okay, so number one, donations. So first, let's see the maximum amount of donation that can be made. First thing, 1% of foreign exchange earnings in the previous 3 financial years. What is it? 1% of the foreign exchange earnings in the previous 3 financial years. So are we talking about the average of the 3 financial years? No. Let's understand this limit of amount by using a very simple example. Let's say ABC Limited is a company which has 2020, in the year 2020, around 5 million US dollars, around 5 million US dollars of foreign exchange earnings. What is this? Foreign exchange earnings. Okay, and in the year 2021, around 15 million of foreign exchange earnings, and in the year 2022, around $30 million of foreign exchange earnings. Now, in the year 2023, if the company is willing to make a donation to outside India, then what is the maximum amount available to make donation here, or the limit, maximum limit of amount? Let's see. Now, should we calculate the average, madam? Did you see the word average in the provision? No. So that is why we have to total all the previous 3 financial years foreign exchange earnings and then calculate 1% on that total amount. In this example, $5 million plus $15 million plus $30 million is equals to $50 million. Now, the amount here is 1% of $50 million, which is $0.5 million, or else let's say, in order to understand much more easily, it will be 5 lakhs million dollars. Sorry, not million, 5 lakhs dollars. Okay. Or what is the next limit that is given here? US dollars of 50 lakhs. Don't get confused here. I'm talking here about, if it is given like this, it is million. Okay, this is an internationally numeric system of putting commas. So that I've used because that is what it is used in your textbook only. So here we are talking about 5 million. And as per our example, what did we get? Around 5 lakhs dollars. That is, this is 0.5 million. Okay. Now, let's understand this very simply. So what is the maximum amount of donation that a company can make? That is, in our example, 5 lakh dollars or 50 lakh dollars, whichever is less. So what is whichever is less? The 5 lakh dollars. So in that current financial year, that is in the year 2023, this concerned company ABC Limited can make maximum donation up to 5 lakh dollars to outside India. Okay, that is the example that we have to understand for understanding this concerned facility available to entities other than individuals. Okay, now, so we have seen, I think I've given a clarity regarding the amount which is maximum available for making donation. That is 1% of foreign exchange earnings in the previous 3 financial years combined together, or US dollars around $5 million, or else 50 lakhs dollars, whichever is lower. Whichever is lower will be the maximum amount of donation that can be made by this entities. Okay, now for what purpose you can make this donation? Only 3 purposes. See, creation of chairs in reputed educational institutions. So are we talking about manufacture of chairs, madam? Absolutely not. We are not talking about manufacturing of chairs. We are talking about creation of chairs in reputed educational institutions. Let's imagine an example. Now, Infosys Limited, it's a software company, right? So Infosys Incorporation, Infosys Limited is the Indian company. Now, this Indian company is trying to make a donation in the form of creation of chairs. Now, what will it make? A very simple. It will come into an agreement with Harvard University. I'm not telling it has happened. It's just an example. It will come into an agreement with Harvard University stating that Infosys company will make a donation in the form of creating a chair. What is creating chair? Very simple. In the same example, let's say Infosys Limited is giving donation in the form of I guess you understood. Creation of a chair is simple. That concerned company is making a donation by bearing the expenses of a particular person or a particular faculty or a particular executive which will be part of that concerned educational institution. Let's say in our example, if Infosys is sponsoring or bearing the expenditure exclusively for that concerned person who is dedicated or who is sponsored by this concerned Infosys company in Harvard University to teach for artificial intelligence and machine learning. Now, this is called a donation and this is an allowed donation as per the LRS scheme. Okay, so that is what we are talking about. That is nothing but creation of chair. Not only the position of a faculty, maybe position of a principal, position of a president of that university, or position of some other renowned board member. So very simple, that concerned entity will bear the expenses like salaries, bonus, or giving them any amount or paying them some extra amount to bring to that university. Everything will be done by that concerned person who is making donation to that chair. Okay, so very simple, that position expenses will be bared by that person. That is called making a donation for creation of chairs in reputed educational institutions. Okay, same way if in All India Medical Center AIMS, so in that concerned medical college, if let's say some famous pharmaceutical company, what you say, Cipla Limited is sponsoring a dean position in AIMS Delhi. Now, what happens? The salary, the expenses of that dean will be bared by which entity? Cipla Limited. This is called making a donation to an educational institution by creating a chair there. You create the position, you bear the expenses of that position. That is called one of the type of donation which is allowed as per this provision. Okay. I hope I am clear. Next type of donation which is allowed is contribution to funds promoted by educational institutions. Now, educational institutions, let's say schools or colleges or universities, will maintain funds. Let's say this fund is for research and development. Let's say this fund is for physics department. Let's say this fund is for arts department. So if as an entity, if I make a donation into the fund which is promoted by the educational institutions, that is also a form of donation. If anyone, I know this is a very rare example, if anyone have come across this Big Bang Theory, this is an American TV series, or Young Sheldon, this is also an American TV series. This person, Sheldon, he is a very intellectual person. He's, has a doctorate in the field of physics. Now, what happens is, he's working for a university called Caltech University. It's a very famous university. So this Caltech University's president is taking this person who Sheldon, because he's intelligent now. Now this person and showcasing him to investors or to companies. And now what happens? Companies will come and say, okay, this person is very intelligent, so if my entity is making donation in science fund of this, so because of my donation, this concerned university will get a new reputation, or get a very innovative, what do you say, award or something or the other. So that is what they make a science donation. They are promoting the concerned donations. Okay, promoting funds. So likewise, very simple, even if you don't understand that example, leave it off. If educational institutions are promoting that please make fund in our concerned educational system, let's say research and development fund, arts department funds, or funds for sciences, funds for physics. So if as an entity you are allowed to contribute to the funds promoted by this educational institutions. Okay, that is what I'm talking about. First one is creation of chairs. Here is contribution to funds promoted by educational institutions. Okay, and the last one is contribution to technical institute or body in donors field. What is technical institute? Very simple. That institute is mainly focused in advancement or research and development in technology. Okay, let's say example. Now there's an automobile company. There's an automobile company, and now this company is trying to make a donation. Now this company is allowed to make a donation in the technical institute. Let's say Spares Limited is a technical institute. Just a moment. Technical institute whose main job is research and development of new technological parts for automobile industry. For which industry? Automobile industry. Now what happens is, this automobile company which is there is permitted or allowed to make donation in a technical institute in donors field. So this is the donors field is also automobile industry only, yes or no? So this technical institute's main job is also research and development of new technological automobile products. So that is what is allowed as per this concerned provision. So facility, one of the facility available to entities other than individuals is donations. What is the amount? Very simple. One is the 1% of foreign exchange earnings in the previous 3 financial years, or US dollars around $5 million, whichever is lower amount. We got clarity. Then for what purposes this donation can be made? Number 1, creation of chairs in reputed educational institution. Number 2, contributing to funds promoted by educational institutions. Number 3 is contribution to technical institutions or technical bodies in donors field. So if as a software company I am trying to make donation to a technical institute, that technical institute should be in the same line of my concerned product, my product line, or else my service line. For example, if I am providing software services, if this technical institute is doing research and development in analyzing or coming up new technologies related to the software development, then I can make donation. But this company is making research on some animals or some rocks. Can I make donation? No, because it is not in my field. That's all. I hope I'm clear with the first facility. Then moving on to the second facility, which is available to entities other than individuals. Now, a resident entity, that is a resident company, is trying to, this resident company's main job is selling flats. What is it? Commercial properties and residential flats in India. Now, what happened is, this resident entity wants to attract buyers from foreign countries also. That means it is trying to sell its goods. What are the goods here? Because it's his main job is selling flats. Goods in this case are flats only. Okay, so this resident entity is appointing an agent. this agent is a person resident outside India only. He will come into an agreement with this person resident outside India and he will make him an agent. This agent's main duty is selling these residential flats and commercial plots in India to non-residents. Okay, so this non-residents will purchase these residential flats and commercial plots through an agent in India. Through an agent. Where will the agent reside? Agent will be outside India only. But what is the agent selling? Agent is selling residential flats or commercial plots in India. And who appointed the agent? Indian company. Okay, now this is possible. Now what happens? As soon as the agent will proceed with the sale, he will receive the sale amount. Of course, the sale amount should be sent to the Indian company. Now, as an agent, I am selling your flats here. So of course I should receive a commission. No. Now the facility here is providing commission to the agent who is located outside India. The limit of that concerned commission is given here in this concerned provision. What is this? If there is a sale happening, then this resident entity will be getting inward remittance. Inward remittance is receipt of money. Here we will receive the amount of that concerned amount which has been procured by selling the residential flats and commercial plots. Now this amount will be given to the resident entity. Now this resident entity can pay a commission of around 5% on the inward remittance or US dollars 25,000 per transaction. So for selling each and every concerned flat or a plot, that will be called as a transaction. So as soon as the agent located outside India will sell the concerned property, he will receive the money from that person who is a non-resident. So that amount will be inward remitted to the resident Indian. So during that remittance, the resident entity can pay 5% of the inward remittance or US dollars 25,000, whichever is less, per transaction. Same way. Just a moment. Let's understand this with an example. Okay, very simple. See, here if this agent is selling each residential flat to a non-resident for around US dollars 30 lakhs. What is it? 30 lakhs. That is 3 million US dollars. Residential flat is sold in India to person outside India. Who is selling that? Agent located outside India. Okay. Now this 3 lakh remittance, which is 3 lakh amount that is received by the agent, will be remitted to resident entity. Will be remitted to resident entity. This resident entity is obligated to provide him commission. To provide him commission of around 5% of the inward remittance, that is the amount which is received by the agent and the amount that is sent to the resident entity by the agent, that or else US dollars 25,000, whichever is less. Now let's calculate this. Very simple. I am a little confused with the number of zeros, that is why I am calculating in my phone. Okay, don't judge me. Into 5%, which is $1,50,000. As per the percentage, if I calculate, I am getting around $1,50,000. Or else, as per the amount, it is 25,000. So whichever is low, that is the commission that the agent will receive who is located outside India is $25,000. That's all. I hope I am clear with this facility. And moving on to the next concept, which is another facility which is available to entities other than individuals. That is the remittances for consultancy services. What is it? What is consultancy services? Very simple. They will provide us ideas regarding how to construct or how to build or how to manage or how to overcome this concerned problem or how to utilize the funds in a proper way to make investment in profit generating funds. All these are consultancy services. They won't help us. Simply they will come and give advice. Okay. See here, remittances amount that will be utilized by entities other than individuals up to US dollars of 1 crore. Up to US dollars 1 crore, that is 1 till up to 1 crore US dollars can be utilized for the purpose of remittance, for the purpose of consultancy services related to infrastructure projects. Now, L&T Limited is planning to construct Hyderabad Metro project. Now what happens is, now L&T Limited wants to procure consultancy services from outside India. Consultancy services from a person who is a non-resident. That concerned non-resident has a lot of experience in this field. He can design it he can design it as per the Hyderabad city requirements and as per the new technology and all that. So what they have did, they have hired a person who will provide consultancy services for this Hyderabad Metro infrastructure project. Okay, now as per this concerned provision, this non-resident who is providing consultancy services to an Indian company can receive a fees for that project up to $1 crore. Up to $1 crore. Clear everyone? So very simple. If a Indian company is procuring consultancy services from outside India for infrastructure projects, then the maximum amount of remittance or consultancy services fees that can be given to that non-resident is up to 1 crore US dollars per project. Per project. Clear? So that is what I'm telling you. Remittances up to US dollars 1 crore per project for consultancy services related to infrastructure projects procured from outside India. Now, the same way, other than infrastructure projects, for some other projects, let's say real estate projects or else some very simple commercial plots or some other services other than infrastructure projects, you are procuring consultancy services. Okay, financial consultancy services or tax consultancy services. These are all other than infrastructure projects. Now, if you are procuring consultancy services from outside India, not for infrastructure projects, then the maximum amount of remittance or fees that you can pay for that consultancy services to a non-resident is up to $10 lakhs. That is $1 million. Okay, clear everyone? That is also per project. Per project. This is the maximum amount that can be remitted by an entity other than individual for the purpose of consultancy services. Infrastructure projects, 1 crore. US dollars. Other than infrastructure projects, consultancy services up to 10 lakhs US dollars. All these services should be procured from outside India. Okay. Next, the other set of remittances that are allowed by entities other than individuals. Very simple. Indian company is receiving an investment from a non-resident. Now this is called foreign direct investment, let's say. So if a non-resident is making an investment in an Indian company. Okay. Now, after after the investment has been received, the company started incorporation procedures, the registration procedure, all the legal fees, all the registration fees, incorporation charges, everything. Those are called preliminary expenses or pre-incorporation expenses. All these have been incurred and the company has started its operation. The certificate of commencement has been received. Now, the investment is made by non-resident at the starting, before commencement only. Okay, before commencement only he has received. Now, what happens is, before commencement he has received investment. Of course, in order for our company to grow and expand or and generate profits, it will be a lot of time. It will take a lot of time. So we are scared as an Indian company. We are scared that we might lose. We might lose. What do you say? A good foreign investor. So that is why what facility this LRS or else the FEMA or the master directions are provided here. Very simple. You can remit amount in the form of reimbursement of pre-incorporation charges. So the pre-incorporation charges that has been expended by the company after receiving the investment can be reimbursed to the non-resident. Why, madam? Actually, after incurring the incorporation charges or preliminary expenses, we will not receive them back. Very simple. But these are not for the purpose of doing the business now. How can we calculate that in the form? How can we calculate that? That is why, very simple, that will be written off. So that is why we see the provision preliminary expenses written off in our accounts. Here there is a facility which will be a little attractive to the foreign investor. Very simple. Let's imagine I am a non-resident. Now I have invested in a startup company, let's say $10 million. Now, this startup company, in order to generate profits or come into break even, it will take 3 years. Now, this will be an unattractive investment for me. I will, okay, even if I am, even if I made initially a $10 million, afterwards, even if the concerned Indian company is trying to procure more investment from me, I will not be interested because it is not generating funds, no. So that is why, in order to attract foreign investors, immediately after commencement is done, they will reimburse some amount of pre-incorporation expenses. Now, what happens as soon as the investment is made, within few months, I am receiving some amount from that Indian company. So will that be a little beneficial for me, or little attractive for me as a non-resident investor? So that is why this facility is available to residents, that's resident entities in India. Okay. Now, what is the amount of reimbursement of pre-incorporation charges that can be given to a non-resident? 5% of the investment which is made by the non-resident, or US dollars up to 1 lakh, whichever is less. Okay. Let's say this non-resident has invested around 50 lakh US dollars. Now, he is allowed, or this Indian company is allowed to pay him in the form of reimbursement of pre-incorporation charges up to an amount of 5% of 50 lakhs or US dollars around 1 lakh. Yes? What is 5% of 50 lakhs? Very simple. 2,50,000. I'm a little too confused with the zeros. Please ignore that. Okay, 2,50,000 US dollars, whichever is less. So what will be the amount of reinvestment charges in this case? US dollars 1 lakh. Okay. I hope I am clear with this example. This is the facility which is available to an Indian company. So Indian company, in order to attract non-resident investors, simply as soon as the investment is received for a startup company or a company which is in the state of incorporation, now what happens in order to attract them, instead of giving return to them after the profit is received, simply you can give it in the form of reimbursement of pre-incorporation expenses. Okay, that amount limit is 5% of investment received by the non-resident or $1 lakh, whichever is less. Now, last facility, the concerned entities other than individuals are allowed to remit up to US dollars 2,50,000 dollars for all the transactions which are listed in Schedule 3 of current account transactions. What are the transactions listed in Schedule 3? The transactions which have an upper limit but are freely permitted. Okay. Now, so for all these Schedule 3 transactions, entities other than individuals can remit up to, what is the limit? US dollars 2,50,000 per financial year. Okay. So those are the facilities which are available for entities other than individuals. Very simple. Don't think much. Repeat the sentences again while you're preparing from my handwritten notes. Read out the sentences aloud. That is the best way to study law, in my opinion. The best and the most underrated way to study law is reading out the sentences loudly. That is when you will be able to retain that in your brain. If you simply, even if I made a very wonderful, colorful handwritten notes and I'm just simply see like this and study, what happens? Okay, understood this. Fine. You will understand for that moment, but you have to remember in order to write it in your examination. You have to read it out loud. How will you read it? Very simple. Let's learn how to read aloud now. Okay, I'm reading facilities. So what are the facilities for entities other than individuals? So the first one is donation. So donation is one of the facility which is available. Fine, very good. Okay, ma'am gave amount first. So what is the amount? 1% of foreign exchange earnings in the previous 3 financial years, or US dollars around 5 million, whichever is low. So this is the amount, that this is the limit of amount which can be made in the form of donation. Okay, done. Very good. For the following, what is the for the following purposes? Number one, creation of chairs in reputed educational institutions. What is it? Creation of chairs in reputed educational institutions. Now, second one, contribution to funds promoted by educational institutions. Contribution of funds promoted by educational institutions. Next, contribution to technical institute or body in donors field. So once again, you have to revise yourself. What is it? The 3 purposes for which this donation can be used. Number one, just of course you can't remember immediately. Again, see and read. Creation of chairs in reputed education institutions. Number 2, contribution to funds promoted by educational institutions. Number 3, contribution to technical institutions or bodies in donors field. Very simple. This is how you have to revise. This is how you have to read law. If you just like, okay, tax 1%, done. 5%, 25,000, done. 1 lakh, okay, done. If you revise like this, what happens? Never you will be able to remember law. Okay, so please read out loud for my sake. That will be very, very, very helpful for you in your law preparation. So many people will be coming and saying, Madam, how to prepare law? Please share some examination tips. I will just say one thing. Read out loud. Read out loud. That is the only way you can gain more marks in law. That's all. That's all. Okay. So we have seen the facilities. Now let's move on to the last concept of the LRS. Last concept of the LRS scheme. So what is it? Here we are talking about rupee loan. Till now in this chapter and previous 2 units also, everywhere we are talking about sending money, receiving money in India or sending money outside India in any other form, investments, expenses, interest, everywhere it is in the form of foreign currency. How is it? In the form of foreign currency. Now in this concerned provision, we are talking about a person extending rupee loan to another person. Now let's understand. Madam, one person extending rupee loan to another person. Why FEMA will come, ma'am? This is the twist here. Rupee loan is extended to a person resident outside India. Let's understand with this provision. See, a resident person, that is a person resident in India, is extending a rupee loan. That is, loan is given in the form of Indian currency, INR. Okay, to whom? NRI, that is non-resident Indian or person of Indian origin, okay, who is a close relative. So let's say one of my cousins is an NRI, or else one of my aunt is a person of Indian origin who is residing in Canada. Now, if I am extending rupee loan to their Indian bank account, this is the provision which is attracted. Let's see how. See, so as a resident, can I extend rupee loan to these NRI and person of Indian origin who is my close relative? Yes, I can do that. In which format I can do? Crossed check. That is a crossed check. That means only that person's name who is mentioned in the check, he can only receive it. And then electronic transfer. What is the form that this rupee loan can be extended to an NRI or a person of Indian origin to? Crossed check, electronic transfer. Okay, done. Now, there are few more conditions that you have to satisfy. If you don't satisfy these conditions, again FEMA provisions will be attracted and this will not be legally possible. Okay, let's see what are the conditions. First thing, this rupee loan should be interest free. You are extending loan to your close relative, you will charge interest free. You brutal fellow. That is what this concerned body say. FEMA provisions are telling us you should not charge interest, okay, because you are a close relative and you're not doing this for business purpose. You are an individual. Okay, next, minimum maturity 1 year. That means this rupee loan that you are extending should have a minimum maturity of 1 year. That means simply for 15 days, 30 days, if you're giving a loan, that will not be counted in this provision. For the purpose of small, for 15 days, all these conditions, provisions, attraction of legal provisions, why these all are needed. So that is why a minimum of 1 year, should be there of maturity. What do you mean by maturity, madam? The period after which the loan will be repaid. So that should be minimum 1 year. That means maximum it can be how much, whatever the period is, but minimum it should be 1 year. So this loan cannot be extended for 15 days, 30 days, 6 months or 3 months. It should be extended minimum for 1 year. Okay. Next. First, it should be interest free. The second, it should be minimum maturity of 1 year. The third one, within the overall LRS limit. So, even if your LRS limit is in the form of foreign currency, if you are extending a rupee loan, to an NRI or a person of Indian origin, that will still be counted in your LRS limit utilization. Very simple. CEO or LRS limit is US dollars 2,50,000. Out of this, around 2 lakhs dollars you have spent for tours, education of your children, and medical expenses, everything in one financial year. Now, the remaining $50,000 which is there in rupees, let's say it is around 4 lakhs rupees. Let's say it is around 4 lakh rupees. Now, if this rupees amount, let's say if you are extending around 4 lakh rupees, just forget this. Let's say this concerned individual who is there, let's say A, let's say Raj. Now, Mr. Raj has used his LRS limit for the purpose of around 2 lakhs dollars for the purpose of towards education and medical expenses. So what is the limit which is available for further expenditure? $50. Now, Mr. Raj has extended a rupee loan to one of his close relatives, Mrs. Banerjee, who is a person of Indian origin residing in Canada. Now, this rupee loan has been credited to Mr. Banerjee's Indian bank account. Clear? See, this, or else simply you can say this as non-resident ordinary account. Non-resident ordinary account where this Mrs. Banerjee will store INR. So the rupee loan that is extended by Mr. Raj to whom a person of Indian origin who is a close relative will also be counted as his LRS remittance. Will also be counted as his LRS limit. Will also be deducted from his LRS limit. So let's say this 4 lakhs converted into US dollars is US dollars 50,000. Now, combinedly, how much he spent in that year 2,50,000 as per this provisions. Now he will come to authorized dealer and say, what? I don't have more $50,000 limit. Why? I have extended in rupees. No, how can you count that here? No, sir, we will still count it because you're extending this loan to a person of Indian origin who is located outside India. Sorry, who is resident outside India, or a non-resident Indian who is resident outside India. That will still be counted in your LRS limit, sir. You don't have $50,000 left out for expenditure for another purpose. That's all. Khel khatam, dukan band. That is what our Hyderabadis say. Okay. So this is the example. Okay. Now, what are the conditions? Basically, it should be interest free and minimum maturity should be 1 year and within the overall LRS limit. That means the amount that he is giving as a rupee loan will also be part of his LRS limit. And the next thing, loan amount shall not be remitted outside India. What is it? Loan amount shall not be remitted outside India. Just a moment. It's technical glitch. So the first condition that we have seen is it should be interest free. It should have a minimum maturity period of 1 year, and then it should also be part of the within overall LRS limit. And the next thing is loan amount shall not be remitted outside India. So even if the amount is in the bank account, that is the non-resident ordinary bank account of the person of Indian origin or NRI, he cannot use that funds or he cannot transfer that funds to his foreign currency account, or else he cannot utilize that funds outside India. Very simple, this funds cannot go outside India. That's all. Okay, not much to think about. And the loan must be credited to non-resident ordinary account, that is the Indian bank account of that concerned NRI, or else the person of Indian origin. So what are the conditions again? Very simple. Let's recall. Interest free, minimum maturity 1 year, part of the LRS limit. Loan amount cannot be remitted outside India. Last one, the loan amount should be credited to non-resident ordinary account. Now, it should be given in rupee. By whom? Resident. To whom? Person of Indian origin or NRI, who is a close relative of the resident. And also we have seen the conditions. Now, for what purpose this loan can be utilized for? Very simple. See, users of this loan money, number one, personal purposes in India. This close relative can utilize this rupees, that is the rupee loan, for his personal purposes. Maybe purchasing or giving to his family members or whatsoever, or else business purposes. Maybe he has a business in India. For that business, he can use this loan. And next, activities in which foreign investment is prohibited. No. Yes, he can utilize this rupee loan for the purpose of personal purposes in India. Yes, you can utilize this loan amount, that is a rupee loan, for business purpose in India. No, you cannot utilize this rupee loan for making investment in activities or in sectors where foreign investment is prohibited. Let's say the prohibited sectors: gambling, chit funds, manufacturing of cigars, and transfer of TDRs, and all these are there. No. So can this person, that NRI or else person of Indian origin, can he make this, can he utilize this rupee loan for making investment in this? Absolutely not. It will still be coming under the prohibited sector. Clear? Even then, if he's not making from outside India or in the form of foreign currency, he still cannot use this rupee loan to make investment in sectors or activities where foreign investment is prohibited. Okay, so for what purposes can he use this money? For his personal purposes in India, for his business purposes in India. But business is also where that concerned business activity or sector is prohibited for foreign investment, he cannot utilize the fund, the rupee loan. Okay, and the last provision of this chapter talks about gift. What does it matter? Very simple, rupee gift. So this gift is in the form of rupees, not in the form of foreign currency. Previously, we have seen that person resident in India is giving a gift to person resident in India only. That too in foreign currency. That is prohibited. But rupee gift, that is gift by a resident in the form of an INR to a non-resident Indian or a person of Indian origin within the overall LRS limit is permitted. Here also that gift is in the form of rupees, to whom it is given, to NRI and to person of Indian origin. That rupees also will be counted in your LRS limit utilization. That is permitted. That's all regarding the chapter of Liberalized Remittance Scheme. So let's give a quick recap of the concepts that we have seen in our concept book. See, facilities for entities other than individuals, donations up to 1% of foreign exchange earnings over the past 3 years, US dollars around 50 lakhs, whichever is less. Next, for which purpose, madam? For creating educational chairs, contributing to funds by educational institutions, or supporting technical institutions or association in donors field. Remember this. Okay, next, commission payments. Of course, the agent can receive commissions from the Indian company. And what is the amount of commission? Up to 25,000 US dollars or 5% of the inward remittance per transaction. Okay, and for what purposes is the commission? Agents abroad involved in selling residential or commercial property in India. Property is located in India, from whom that person is selling. For the non-resident, who is selling? Agent who is located outside India. Okay. Next, yes, of course, an Indian company can procure consultancy services from outside India, but that consultancy services, the amount that can be remitted for the purpose of consultancy services for infrastructure projects is up to 1 crore US dollars. But other than infrastructure projects, up to 10 lakh US dollars per project. Okay, and of course, pre-incorporation charges can be reimbursed to the non-resident investor up to 5% of the investment brought into India, or up to 10 lakhs US dollars. Sorry, 1 lakh US dollars. Okay. Next, other remittances up to US dollars of around 2,50,000 can be remitted for the Schedule 3 current account transactions. Okay, done. Now, any remittance exceeding the specified limits requires approval from the RBI. For individuals who are availing the remittance under the LRS scheme, if they have expended or if they have utilized the 2,50,000 limit, they cannot go to RBI for approval for getting more amount. Not at all, they can't do it. But for entities other than individuals, if they have utilized the amounts that I have specified here, the limits that I have specified in the above, they can still remit more amount, but with the permission of RBI. Okay. Next, rupee loan or rupee gift. Rupee loan to NRI and person of Indian origin who is a close relative by resident by way of crossed check or electronic transfer is subject to following conditions. Interest free, minimum maturity 1 year, shall be part of the annual LRS limit US dollars 20,000. The loan can be used for personal and business purposes in India, and but not for the activities in which foreign investment is prohibited. Next, where will the amount be credited to the non-resident ordinary account of that NRI or person of Indian origin. Okay, next, remittance restrictions. The loan shall not be remitted outside India. That means any amount, any single penny of that loan cannot be taken outside India. Okay, next, repayment. The repayment should be made through normal banking channels or as inward remittances. Of course, the money is here only, in the form of the rupee loan in the non-resident ordinary account. So the repayment can be done through inward remittances through normal banking channels. Okay, last one, rupee gift. The gift must be within the overall LRS limit, that is US dollars 2,50,000 per financial year. The donor must ensure that the total remittances, including the gift, does not exceed LRS limit of the concerned individual per year. So these are the provisions that are given in your study material under the unit Liberalized Remittance Scheme. Simple. I hope you have understood all the provisions regarding this. If you did not understand, or a little confusion is there for let's say a single point or somewhere or the other, very minute thing you did not understand, go back to the video, listen to it again. That's all. Okay, so the questions here which are important is permissible uses under LRS and prohibited remittances, and also facilities for entities other than individuals. If ICMAI wants to test you or wants to torture you, which question will they give? This one, because limits, percentages, uses, entities, all are there now in this question. So that is why. Okay. So maybe an MCQ may be questioned, but it is not there in your backside of the study material. Okay. But of course you have to revise. So, but the main important two questions here is permissible uses and prohibited remittances. That's it. So the next chapter that we will be discussing is the external commercial borrowings. Last chapter. The chapter is divided into two parts: external commercial borrowings and trade credits. Okay, after this we will be discussing the MCQs which are given in the textbook backside. Just a moment. And then the question bank. Okay, I will not be discussing all the questions in detail again. Very simple. I will tell you what are the questions and how will the answers be, how should you write down the answers. That's all. Okay. Moving on to the next unit. Moving on to the next unit, that is the last unit of the Foreign Exchange Management Act, which is external commercial borrowings and trade credit. First, let's see the provisions regarding the external commercial borrowings, and then we will move on to the trade credits. So, external commercial borrowings, where shall we learn from, madam? We are learning it from the master directions released by the Reserve Bank of India. So, this is also not present in the primary act of Foreign Exchange Management Act 1999. Rather, it is released by the RBI master directions. Okay, now let's basically understand the meaning of ECB. External commercial borrowings. If you cleanly observe the heading, they have clearly laid down the meaning in the heading only. They say it's external. That means you're procuring from outside India. And the second word, which is commercial, that means here we are talking about business activity purpose. So borrowings, of course, loans which are procured for business activities from outside India. Very simple. See, till now in foreign direct investment chapter, we are talking about investment which is made by non-resident in India. Here investment means purchasing of capital instruments, they are becoming the owners or having a significant influence in the company. Yes or no? Here we are talking about external commercial borrowings. That means Indian company, Indian entities are procuring loan from outside India for their business activities. So personal loans, home loans, or loans procured by individuals, all these concepts will not be covered under ECB. Just remove those all from your mind. Very simple. Okay. So the meaning, very simply, I've written here: loans taken for commercial purposes from outside India. What are commercial purposes? Business related activities, for the purpose of import of goods, for the purpose of equipment, for the purpose of expansion of business, or for all these activities. If you're procuring loan from outside India, that can be categorized as external commercial borrowings. Of course, some other parameters and conditions have to be satisfied in order to call a particular loan as external commercial borrowing. Okay, so let's understand the definition with a very simple chart. What is it? Residents, that is the person resident in India, will be the borrower, and he will be taking foreign loan from a recognized non-resident, recognized lenders. You're not just like go to Pakistan because they are promoting terrorism activities. They will be giving fund to you, yes, for a very low percentage, let's say 0.5% interest. So can you take it, can you procure the loan from that agencies, because the interest rate is less, it is for my business activities, and it is from outside India. External commercial borrowings. Satisfied? No. Can you do that? Of course not. The loan should be procured from recognized non-resident. Madam, who are these recognized non-resident lenders? Very simple. That will be given in your framework down below. Okay. So basically meaning loans taken for commercial purposes from outside India. Another side of the meaning, person resident in India is procuring foreign loan from recognized non-resident lenders. So that foreign loan can be procured in which format? In the form of debt, in the form of bonds, in the form of foreign currency convertible bonds. Clear? Okay, good. By issuing foreign currency convertible bonds, you procure the debt. That will also be called as external commercial borrowing. By issuing bonds to a non-resident, you are procuring debt. Yes, that is also called as external commercial borrowings. By simply taking a debt, taking a loan, that will also be called as external commercial borrowings. But of course, there are few parameters that has to be satisfied, that conditions have to be complied with in order to call a borrowing as an external commercial borrowing as per the master directions released by the Reserve Bank of India. Simply, if it is from external commercial purpose borrowing, it will not be called as ECB, my dear. You need to satisfy few conditions. Those conditions are laid down in the form of parameters in ECB framework. That is what we will be dealing next. But simple meaning though, you have understood what do you mean by external commercial borrowings. But what is the definition given under the master directions? Let's understand that. Not understanding meaning is same, but these sentences should be kept, they should be put in our answer sheet. Okay. So what is this, madam? External commercial borrowings are commercial loans raised, that means loans for business activities raised by resident entities. Resident entities. Why we are not talking about individuals? For business activities, why can individuals procure the loans? Remove that from your mind, my dear. All commercial loans raised by resident entities, that is the corporates, HUS, firms, LLPs and other organizations, from recognized non-resident entities, from recognized lenders. Who are these recognized lenders? That will be provided in your ECB framework. Okay, and of course that is the main heading, but should conform to parameters, should conform to other conditions such as minimum maturity. The minimum maturity that we have seen in the last concept of liberalized remittance scheme, what we have seen, rupee loan extended by a resident to an NRI or a person of Indian origin should satisfy with condition 1. Condition 2, what is it? Minimum maturity of 1 year should be there. Here also some condition, minimum maturity will be given, let's say 5 years or 3 years. So simply if you are procuring loan for 1 year or 6 months, that will not be called as ECB. It should comply with some minimum maturity period given as per the ECB framework. Okay, and some other parameters is permitted or non-permitted end users. You procure the loan from recognized non-lenders. Is it your wish to use that loan for any other purpose? No, it can be used only for permitted end users and it cannot be used for non-permitted end users. And the third parameter is all-in cost ceiling. What is the meaning of all-in cost ceiling? Very simple. I'll just give a clear picture right now because we will discuss that in detail in ECB framework. All-in cost. So the cost that is incurred by the borrower for the purpose of procuring that loan, let's say interest cost, upfront fees, processing fees, legal fees, all these together will be called all-in cost. So that all-in cost maximum all-in cost will be there. Let's say you are procuring loan from a recognized financial institution from UK. And as per the ECB framework, the all-in cost is around 6%. That means the interest fee, the processing fee, the legal fees all together cannot exceed 6% of the borrowing as per the ECB framework. That's all. Very simple. Now, that's all. Madam, I got a doubt. Why should we procure loans from outside India? Very simple. Lesser cost. Here in India, we can procure a business loan, let's say for 12%. Maybe in some other financial institution located outside India, they are providing for 4% or 3% or 5%. Less cost is incurred, right? So that is why business entities will show more interest towards procuring loan from outside India. Okay. And as the government of India, master directions released by the RBI, they are encouraging you to procure external commercial borrowings. Okay. That will of course increase the foreign exchange reserve. Okay. Done. Now, basic meaning of the external commercial borrowings is done as per the master directions. Let's see what I have given in your book. What is it? Commercial loans taken by residents from recognized non-resident entities. Residents, that is person resident in India, is procuring commercial loans from recognized non-residents. Those loans can be loans or funds raised for business related activities, and recognized non-residents are simply person resident outside India permitted to lend loans to resident entities under ECB framework. Okay. Few other parameters should also be complied. That parameters I did not include in your main concept, rather I directly included in your ECB framework. Clear? Okay, moving on to the framework of the external, just a moment, external commercial borrowings. Okay. So, what is framework, madam? List of conditions that has to be satisfied, that must be satisfied in order to call a borrowing as an external commercial borrowing. Okay, so external commercial borrowings, if all these conditions are satisfied, simply a business entity can go to an authorized dealer and give him the details that I am procuring loan from this recognized non-resident entity, and he can procure loan. But if that concerned business entity is not following the conditions given under ECB framework, he can still procure loan, but he has to take the approval of the government. That's all. Okay. Then why this ECB, madam? No need for approval, na? Approval will take a lot of procedures, lot of time, compliances, and all that. Here, simple. If you comply all these, or if you satisfy all these conditions, simply show the agreement and show the certificate that I've complied with all these concerned parameters. So I am procuring loan from this recognized non-resident entity. The authorized dealer will transfer the funds to you. That's all. Very simple. Okay. Now ECB framework. Now ECB, that is the borrowings, can be procured in foreign currency. That is, the loan can be taken in foreign currency. That may be in US dollars, that may be in Great Britain pound, that may be in Swiss franc, or whatsoever it is. So procuring loan in the form of a foreign currency, that is one kind of ECB. Procuring loan in Indian currency, that means you are procuring a loan from a foreign resident only, but he is sending the money or else lending the money in the form of INR. Here, the lending will be done in the form of FCY, that is foreign currency. INR, here you are directly receiving the form of rupees. So that can be two kinds of external commercial borrowings. Okay, that is the first difference that I want to tell you. What is it? FCY denominated ECB, amount borrowed in the form of foreign currency. INR denominated ECB, amount borrowed in the form of Indian currency. Okay, now let's start into the parameters. First thing, mode or else form. Like, how can I procure the loan, madam? First things first, of course, loan. What is loan, madam? Some certain amount will be taken that will be repaid after a maturity period. Of course, interest has to be paid every month as per the rate given or as per the agreement which is entered by the foreign lender. That's all. That is one. That is the first mode of procuring ECB. What is it? Loans or else bank loans. Here we are talking about FCY denominated ECB. Don't forget this. First, we're talking about foreign currency denominated external commercial borrowing. What is it? Amount borrowed in the form of foreign currency. The first form is loans from financial institutions outside India or loans from banks outside India. Okay. Next thing, next. Floating or fixed rate notes, bonds, debentures. What are debentures? Debt instruments which will receive interest. Bonds are also debt instruments. And what about notes, madam? Notes are issued by Indian startup companies where they do not have like a clarity regarding how to value my capital instruments, how to value the shares. So simply they will first issue notes. So notes also will be one of the kind of debt instruments. So notes, debentures, bonds. All these also are the forms of procuring ECB. How can you procure ECB by issuing bonds, madam? Think logically, my dear. If you issue bonds, that non-resident lender, recognized non-resident lender, will give money to you and purchase the bonds. That means indirectly is giving you loan, no. But here, what happens? You're not giving any security, rather you're giving notes, bonds, debentures. Loans and bank loans, you will give security. Let's say immobile property or mortgage or whatsoever it is. But here in floating rate and fixed rate notes, bonds and debentures, if that concerned person is giving us or lending us the loan or giving us debt in the form of notes, bonds, debentures. Okay. That can be done using the floating rates or fixed rates. What are floating rates? Very simple. There will be an underlying rate, let's say LIBOR or MIBOR, London interbank offer rate, Mumbai interbank offer rate. So based on this, it will fluctuate. The interest payments, that will be fluctuating. Let's say LIBOR is 1%. The floating rate given as per the agreement is LIBOR plus 550 base points. What is 550 base points, madam? 5.50%. So let's say LIBOR at that point of time is 1%. What will be the interest rate? 1 plus 5.5%. 6.50% will be the interest rate. That will be called as floating rate. The floating rate can be in the can be applicable to notes, bonds, debentures. Okay. Fixed rate is, of course, as usually, 6% bonds, 6% debentures, 12% debentures, all these are called fixed rate debt instruments. Floating rate debt instruments, there will be an underlying rate, which is like LIBOR and MIBOR, that will be keeping on changing. So that is why it's called floating rate. Okay. So that is the second form of procuring external commercial borrowing. And the third one is trade credit beyond 3 years. Now here only I'll explain the basic meaning of trade credit. This trade credit and the trade credit that we will discuss ECB, both are same. Okay, what is trade credit, madam? I am an importer of goods located in India. So I am a person resident in India. Now I am procuring, let's say, capital equipment from a person resident outside India, let's say Japan supplier. Now he is like, I am purchasing that equipment from that person. That's a huge equipment. Of course, I am not in a position to pay immediately the whole amount. Now, what will the Japan supplier do? He will give me a credit period. That means you can repay your amount after 3 months or after 6 months or after 1 year. So that is a facility, the credit facility that is extended by the supplier to an importer in India. That is called trade credit. So if that credit period is beyond 3 years, that will be also called as external commercial borrowings. Very simple. Okay. So first form, loans and bank loans. Second form is notes, bonds, debentures. The rates can be floating rates or fixed rates. And the third one is trade credit extended beyond 3 years. And the fourth one is FCCBs and FCEBs. FCCBs, okay, madam, we have seen in the first chapter under definitions. Foreign currency convertible bonds are issued by Indian company to non-residents. Okay, fine. Very good. They are expressed in foreign currency and the return is also given in foreign currency. Very good. Then what is this FCEBs, madam? Foreign currency exchangeable bonds. Exchangeable bonds. Okay. So what is the key difference between foreign currency convertible bonds and foreign currency exchangeable bonds? Okay. Let's say Reliance Limited is issuing FCCBs to non-residents. Now, after maturity period, let's say 5 years. This FCCBs will be converted into equity shares of Reliance Limited. Okay, so here this non-resident has the option number 1. You can convert the FCCBs into equity of Reliance Limited, or else you can simply take the principal amount plus the interest accrued. Okay, that is called redemption of the foreign currency convertible bonds. He has 2 options. Now, coming to FCCBs, here the same company, Reliance Limited, is issuing foreign currency exchangeable bonds to a non-resident. And
in the FCEB's agreement, Reliance Limited has mentioned that after the maturity period, the bonds will be converted into shares of my subsidiary company. Let's say Reliance Digital or Trends or Reliance Finance.
So, madam, do we have the option to convert these shares into any subsidiary company?
No. It will be mentioned in the agreement only. Let's say in the agreement of this FCEBs, they say that after maturity, your bonds will be converted into equity shares of Reliance Digital. So this non-resident, if he has availed the option of converting FCEBs into equity shares, he will become the equity shareholder of Reliance Digital. So that is the main difference between FCCBs and FCEBs. FCCBs, whichever the Indian company is issuing FCCBs, after maturity period, that non-resident will become part of the equity capital of that Indian company only. But when coming to FCEBs, whichever, like the Indian company which is issuing FCEBs, then to that non-resident, he will not become he will not be part of the equity capital of that Indian company. Rather, he will be getting the equity shares of the subsidiary company, whichever the company is mentioned in the agreement. That's all. It's not like you have the option to select any subsidiary you want. It is given in the agreement only. Okay, that is the main reason. So that's the difference between FCCBs and FCEBs. So this is a form of procuring ECB from a non-resident. How, madam? Bonds, no. Indian company issuing to non-resident, no. Non-resident will subscribe this by paying some amount, no. That amount is called ECB only. That's all. Okay, don't think much. Next, financial lease. What is financial lease? You have come across this in your strategic financial management. There is financial lease and operating lease. Financial lease is like most of the let's say life of the asset is held in the hands of lessee only. Yes, and he will finally, after the lease period, he will only become the owner most of the cases. So that is called finance lease. Very simple. Simply, he is taking the asset for a lease for the whole life period of the asset. Okay, that's all. So if a foreign non-resident entity or a non-resident is giving an asset or an equipment or a machinery in financial lease, for a financial lease to an Indian company, that will also be called as ECB. So if I have procured any machinery or equipment, let's say from a Japan supplier for financial lease, then also that Japan supplier is giving me ECB. What ECB, madam? What will be the amount of ECB here? The amount that you pay throughout the lease period for that financial lease. For the financial lease, that will be the amount of ECB. Okay, that's all. These are the forms of acquiring foreign currency denominated ECB. Now coming to INR denominated ECB, everything is there except foreign currency convertible bonds and foreign currency exchangeable bond, because these two bonds are represented in foreign currency. So that is why this will not be qualified under INR denominated ECB. Loans can be given in rupees. Notes, bonds, debentures can be issued in rupees. Trade credit can be extended in rupees. Financial lease can be extended in rupees. But FCCBs or FCEBs, the main definition is only stating that they are represented in foreign currency. So that is why FCEBs and FCCBs will not be a form of procuring INR denominated ECBs. Okay, so main difference between foreign currency denominated ECB and Indian currency denominated ECB is FCCBs and FCEBs. Okay, don't get confused. Once again, if you give a reading through my handwritten notes, you will get a clarity. Okay, so this is the first parameter that has to be complied with by the resident entity who is trying to procure external commercial borrowing. Okay. Now, the next parameter is, can anyone procure external commercial borrowings, madam? No. Again, there's a parameter, eligible borrower. You should come under the category of eligible borrower in order to procure ECB. So, how will I be called eligible borrower, madam? What is the condition that I have to satisfy? Very simple. So, if you are eligible to receive foreign direct investment, then you can also procure external commercial borrowings. So I am eligible to receive FDI, then by default I am eligible to receive ECB also. That's all. Then how do I check if I am eligible to receive FDI or not? I've already taught you in unit number 2. Check sectoral caps, check entry routes, check prohibited sectors, check permitted investment. If you are satisfying all these 4 parameters, then you are eligible for FDI. That by default you are eligible for ECB. That's all. Now, this is the condition for foreign currency denominated ECB. Then, how will I become eligible borrower for INR denominated ECB, madam? Very simple. If you are eligible borrower for foreign currency denominated ECB, then you will become eligible borrower for INR denominated ECB. See here, eligible borrower for foreign currency denominated ECB is all entities eligible to receive FDI. Now, eligible borrower for INR denominated ECB is all entities eligible to raise FCY ECB. Okay, clear. And also few other 2 special cases is given, that is microfinance companies and non-profit organizations are the 2 special companies which are eligible to procure what? INR denominated ECB. Okay. So microfinance companies are companies which extend loans for a lesser amount of loans for a lesser maturity period. Okay, so microfinance companies and non-profit organizations can also procure, are eligible borrowers for INR denominated ECBs. Okay, so first one we have seen forms, that is modes of procuring ECB. Second one we have seen eligible borrowers. Now let's see the recognized non-resident entities. So in order to call it as external commercial borrowings, you have to borrow the fund from a recognized non-resident. So who is that recognized non-resident? Number 1 is resident of Financial Action Task Force compliant country or International Organization of Securities Commission compliant country. So Financial Action Task Force and International Organization of Securities Commission, both these are intergovernmental bodies. So countries will be the members of this association, and this association will decide and make a list of countries which will be called as recognized lenders for ECB. So if we are procuring loans from that list of countries which are called compliant countries as per these 2 organizations, then by default that ECB will be satisfying the condition of recognized lenders. Okay, so first recognized lender is Financial Action Task Force compliant country. This intergovernmental body will issue a list of countries that if you procure loans from this country, yes, it is eligible. These are recognized lenders. So if you are getting foreign currency denominated ECB, if somewhere or the other, if I get confused and take the word FCB instead of ECB, don't get confused. FCB, I'm only talking where? Here in the forms. And the rest of the times, I'm talking about ECB, external commercial borrowings, okay? Sometimes in the flow, I tend to, forget. I'm not only forgetting, my subconscious mind is speaking. My subconscious mind is telling make mistakes, not my actual brain. Okay, so first recognized lender is the resident of Financial Action Task Force compliant country. So company which is eligible as per what is recognized as per Financial Action Task Force organization. And the next thing, International Organization of Securities Commission. Madam, Financial Action Task Force, the use it. Main thing is the eradicating money laundering. Yes. And what about International Organization of Securities Commission? These will be regulating international financial markets. That's all. Okay, so IOSC compliant countries, this organization, this commission also will prepare a list of countries which will be called as recognized lenders. So if as a resident Indian, if we are procuring loan from the compliant countries issued by these two organizations, yes, it will be called as external commercial borrowings. That's all. Okay, now just a moment. What is it? Multiverse, second one, second recognized lender, multiverse or regional financial institutions where India is a members. So multiverse, that means multi countries will be members of a financial institution. So from this multiverse financial institution, any country member, any country resident can come and procure loans. Okay, so that financial institution is also coming under the category of recognized lenders. And regional financial institutions, so multiverse financial institutions, regional financial institutions are like this Asia Development Bank, Africa Development Bank, European banks. These are all like for one continent, for one region, there will be a separate financial institution. Yes or no? So if in that financial institution India is a member country, then as a resident Indian I can procure loan from that recognized lender. Okay, so first lender we have seen is compliant country as per these two organizations. Second lender is multiverse, multinational companies, we say, no, like with multinational financial institutions or regional financial institutions where India is the member in that financial institution. So from that financial institution you can procure loan. That multiverse and regional financial institutions will be recognized lenders only if India is a member. Okay, next, foreign branches or subsidiaries of Indian banks. So Indian bank only, let's say ICICI Bank or HDFC Bank, but these are having foreign branches in outside India or subsidiaries outside India. So as a resident entity you can procure external commercial borrowings only in the form of foreign currency denominated ECB from our Indian bank, foreign branches and subsidiaries. Okay, and the last condition for the last third, third recognized lender is not FCB and FCEBs. Who will issue FCCBs and FCEBs? Indian companies. Yes or no? So that is why foreign branches or subsidiaries of Indian company from these. So what Indian banks only know. So we can't issue FCCBs or FCEBs to Indian banks. So Indian banks can directly purchase the shares of our Indian company. So that is why issuing FCCBs and FCEBs to foreign branches or subsidiaries of Indian bank is not allowed. So only thing you can do is you can procure foreign currency denominated ECB from foreign branches and subsidiaries of Indian banks. From these other two lenders you can procure any kind of loans, like foreign currency denominated ECB, Indian currency denominated ECB, any other form, FCCBs, FCEBs, financial lease, everything. Okay, that's all. I hope I am clear with this. Now, moving on to the next parameter. What is the next parameter, madam? Minimum average maturity period. Minimum average maturity period. Madam, you told minimum maturity period. That one we understood. What is this minimum average maturity period? So, the average maturity period of all the external commercial borrowings taken from all the sources should not exceed the limit given. So, as per the original master directions released by the ECB, let's say if I have this or not. Just a moment. Yeah,
This is the original master directions released by the RBI on external commercial borrowing. See this master directions number 18 dated Jan 1, 2016. So if you see the framework given under this PDF, which is released by the main RBI, external commercial borrowings framework. Okay? External commercial borrowings framework. So minimum average maturity period. Let's see the basic meaning. What is the basic meaning, madam? Meaning, madam, very simple. The minimum period should be there in order to call it ECB. Let's say 6 months, 3 months, 1 month. If you're procuring loan, that will not be called as ECB. You are complying these many conditions, these many parameters you're complying with, and you're procuring loan from a foreign financial institution. Why will they give for 1 month? They will say, shut up and take from your Indian institutions. Why are you coming for 1 month to our country? So that is why there is a parameter that you need to satisfy in order to call the loan as ECB. What is it? Minimum average maturity period. So let's understand this with an example first, and let's move on to that concern. See, minimum average maturity period. What is the average term? Replicate here. So let's say Indian company A has an ECB 1 worth $50 million. Maturity period is 5 years. Now, loan 2 worth $30 million. Maturity period is 8 years. Now, let's do the average. $50 million into 5 years plus $30 million into 8 years divided by 50 million plus 30 million. Now, if you calculate this, you will get around 6.75, 6.25 change. Now, this is called this. Let's say the value is. Let's say the value here is 6.25%. Sorry, years. Now this is called minimum average maturity period. Now, not this actually, wait. So if as per the ECB framework, if minimum average maturity period is 5 years, the limit, now you have 6.25 years, then you are satisfied the ECB framework condition. But if your calculation after doing the steps for both of your ECBs or more than one ECB, if you get around 4.5 years, then did you comply with the condition of minimum average maturity period? No. That means will your loan be qualified as external commercial borrowings? No. Okay, so that is the relevancy of, that is the basic example that I've given you for the purpose of understanding minimum average maturity period. We are not talking about minimum maturity period of a single ECB. Rather, we are talking about the combined minimum average maturity period of all the external commercial borrowings which have been procured by the Indian company from outside India. Okay. Now, let's understand this. So, as per your study material, under your ECB, minimum average maturity period is simply given like this. Minimum average maturity period is 5 years for both FCY denominated ECB and INR denominated ECB. So that is what I also did here in my concept book. Minimum average maturity period is 5 years. But as per the original master directions, minimum average maturity is not generally given for a generally for all the loans. Minimum average maturity period is 5 years. That is not given here. See, if ECB is raised by manufacturing companies up to 50 million US dollars, minimum average maturity period is 1 year. If ECB is raised from foreign equity holder, minimum average maturity is 5 years. ECB is raised for some working capital purposes for on-lending NBFCs 10 years. So, basically, thinking that minimum average maturity period for all the external commercial borrowings is 5 years is dumb. Okay, but as per your study material, they have given 5 years now. So, that is why we have to blindly follow our book. Okay, but of course we don't encourage mistakes. What we have done in the foreign direct investment chapter, the foreign direct investment policy is issued by Department for Promotion of Industry and Internal Trade. But in the book CMA study material, they have given international trade. which is not correct. So that mistakes you can correct. But if they are trying to reduce the matter and simply they're giving, see here, minimum average maturity period will be 3 years in general they have given here, okay, and column put options like all these. But of course for specific categories the MAAB will differ. That all they did not give. Combined together, a single minimum average maturity period has been given to you as 5 years, okay. So I hope you understood the meaning. Average time period over which the loan must be repaid. Over which the loan must be repaid. The average time period for repayment of these both loans together is 6.25. So, but MAAP should be 5 years, no? Did we comply with the parameter of ECB framework? Yes, because it is more than the MAMP suggested by the ECB framework. Okay, done. Now the next parameter, all-in cost ceiling. What is the meaning of all-in cost, madam? I've already told you the total cost incurred, the maximum cost that can be incurred on this external commercial borrowings. Very simple. See this, the meaning that I've given in your handwritten notes. Maximum allowable cost, maximum allowable cost for raising funds through ECB. For raising funds through ECB. See, maximum allowable cost. That means if you are raising loans in the form of ECB from a non-resident, you have to comply with the condition that the cost should not increase the limit given here. What does that include, madam? It includes interest cost, upfront fees like processing fees, other fees like legal fees, okay, and does not include default interest or penalty. So if you have defaulted payment of interest and they have levied some more interest, if you have defaulted payment of interest like for 4 to 6 months and they have levied any penalty, so will that also be counted in this all-in cost ceiling, madam? No. The maximum cost that you can incur for procuring ECB is called all-in cost ceiling. So that cost will include interest rates, your interest cost, your processing fees, upfront fees, other fees, legal fees, all these will be included. But default interest fees, penalty fees, all these won't be included because that's your mistake. Okay. But as RBI, I am giving you a limit that I'm trying to save your cost. So that is why I've given a limit that ECB should satisfy the condition of maximum allowable cost. That is all-in cost ceiling. Okay. I hope you're clear with this also. The all-in cost ceiling in your concerned study material is not at all given for you. But how will all-in cost ceiling be? But in your concept book, I've included, see, benchmark rate. Let's say the benchmark rate is LIBOR, or else the benchmark rate is MIBOR, or some other international bank rate or something or the other. So that benchmark rate plus 550 base points or 450 base point. What is base point, madam? This 550 base point will be converted as 5.50% of interest. 450, 4.50. Okay. As per the official master directions, all-in cost ceiling is benchmark rate plus 550 base points for foreign currency denominated. For Indian currency denominated, benchmark rate plus 450. So not at all necessary to remember this because it's not there in your ICMA study material. But in order to understand how will the all-in cost ceiling will be there, I have given you an example in your concept book. Okay. Now, coming to the last parameter, which is end users of external commercial borrowings. We have seen in the definition only, there will be three you have to follow with the following. External commercial borrowings are commercial loans, commercial borrowings taken from recognized non-resident recognized lenders, but they have to comply with few parameters. One of the parameters that I've told you is permitted and non-permitted uses. Permitted uses they did not give, but simply they have given non-permitted uses. That means the negative list for which purposes we should not use our external commercial borrowings. So those they have given. Number one, real estate activities. For the investment of real estate projects or for real estate activities, you cannot use your external commercial borrowings. Okay. Next, Now some brilliant minds will get a doubt. Madam, so if I take a loan from outside India for purchase of a house in India, will that okay, I cannot use for purchasing a house. Huh? First of all, you are an individual. That will not be called as ECB. Okay? And if a company, let's say an Indian company, is procuring a loan for, let's say, business activities only, of course, and it is utilizing for purchasing what is it, a house or a commercial property, okay, that's fine. If you are purchasing a commercial property, that is different. But if you are involving in real estate activities, that is investing in the projects for construction, that is different. You are purchasing commercial property which is already available, that is different. But you are investing in real estate business, that is not allowed. Okay, next. One of the negative end uses real estate activities, you can't use it for. And next, investment in capital market. You can't use external commercial borrowings for investment or trading in financial markets of Indian stock exchanges. Next, equity investment. You cannot make equity investment. Again, if you make equity investment, it will be called as, sorry, very simple. If external commercial borrowings loan has been procured and that loan you did not use for your business activities, rather you are trying to purchase equity shares of another Indian company or a foreign company, can you do that? No. Okay, next, repayment of rupee loan. You cannot utilize external commercial borrowings for repayment of Indian loans in the form of rupees. Okay, next, working capital purposes and general corporate purposes. For working capital purposes, the day-to-day business activities, or general corporate purposes, the management expenses or expansion expenses. What do you say? General corporate expenses. Let's say office works or all the other purposes, you can't use this concerned money for working capital purposes. Working capital, day to day, purchasing goods, selling goods. General corporate purposes, the payment of salaries and normal management expenses. For all these purposes, you cannot use this external commercial borrowings. Okay, madam, why are you becoming serious, madam? Did you lay down this negative list? Not at all. Okay, sorry. So let's get back to our fun mode. What are the negative list? First one, real estate activities. So if I procure loan from in the form of external commercial borrowings from a recognized foreign lender, I cannot use it for real estate activities. I cannot use it for investment in capital market, that is trading in financial markets. I cannot use for equity investment and in some other company. I cannot use it for repayment of my rupee loan or general corporate purposes or working capital purposes. And the last end uses, on lending to entities for above activities except in case of NBFC. This one, just pay a little more attention. You will not be confused. Very simple. First, let's divide this into three parts. First thing, on lending activities. Okay. Next, what is on lending? Very simple. Just a moment. First part, let's understand the first part. On lending means for the purpose of, you have taken external commercial borrowings and you are using it to extend loans to some other person. Can you do that? No. Generally, no. Next, to whom? To entities for above activities. So, category number 1, NBFC. Next, non-NBFC. So, ECB has been taken by both NBFC and non-NBFC. Okay. Now, this ECB is being utilized by both NBFC and non-NBFC for on lending. For what? On lending. So, as per the negative list, NBFC can use this fund for lending to any entities. Any entities for any activity. But non-NBFC utilizing this fund
utilizing ECB for lending purposes, it can lend, it can be involved in lending to any entity for activities other than the activities which are listed above. All these activities.
That is the general meaning. So, case number 1. On lending activities, can you use these funds? Yes. Case number 2. NBFCs, for any entity, for any activity, you can use ECB for lending. Next. But if you are a non-NBFC, or if you are a normal entity who is not registered as an NBFC, you are utilizing this ECB for lending activities. Yes, you can do that, but you can't lend loans for the above activities. You can't lend for loans for real estate activities, or investment in capital markets, or equity investment, capital, general corporate purposes, working capital purposes, repayment of loan. Clear? So, if ECB has been taken by an FCB, ECB has been taken by an NBFC, and this NBFC is utilizing the funds of ECB for lending loans. Yes, it can utilize for any purpose, any activity. NBFC can lend loans for real estate activities, investment in capital markets, and equity capital, equity investment, working capital, general corporate purposes, for any other activities. But if a non-NBFC is procuring ECB and this ECB is being utilized for the purpose of lending loans, yes, you can still use it for purpose of lending loans or lending finance, but it cannot be lended, or it cannot be extended for the purpose of this 6 activities. That's all. Okay. If you are still confused, very simple. Go back to 5 minutes, listen to the class again. Okay, good. Now, how do I erase this highlight? Oh my god. Maintaining the notes is one of the difficult tasks, because if I'm teaching, I tend to write, and okay, we're good to go. Okay, so this is the negative list which is given under ECB framework. Okay, but if you observe in your study material, while mentioning this while mentioning this negative list, they have given exceptions for working capital purposes, general corporate purposes, and repayment of rupee loans. What is this? Except in case of 5B, 5C, except in case of 5B, 5C, except in case of 5D, 5E. Did they give 5B, 5B cases first time? No. Then how can they give exceptions? Literally, I don't understand some of the points or some of the provisions which are given in an ICMA material. The main link won't be given. Directly it will be given. Like, why, dear? Why? Why ICMA? Why? I want a question. Exceptions are not given. So, from where are we getting this if you observe? So, here, under 5th parameter, C is ECB raised for working capital purposes and non-lending by FCBs. This is permitted. Okay. And D, ECB raised for repayment of rupee loans availed domestically for capital expenditure on lending by FCBs. If they comply with this minimum average maturity period, they can still procure ECB for these purposes. So that is the exception given for you. But this exception should first be given in that, given here, no. Minimum average maturity period, here they have to list all these 5 exemptions, and then here they can give. They directly give 5B, 5C, 5B, 5C, 5D, 5E. These are exception cases for this general corporate purposes. How will you mention? Why will you mention? So that is why, very simple, ignore these exceptions and simply write down what
Negative uses: real estate activities, investment in capital market, equity investment, working capital purposes, general corporate purposes, repayment of loans, and on lending activities for above activities, except in case of ECB raised by NBFCs. So here with this we have completed the framework. What is it? Framework of, just a moment, I'll erase this text. Framework of ECB is done. Okay, now moving on to few other provisions, which is limit and leverage. And we have one of the important, like not important, let's say past question, parking of ECBs. Okay, so if we finish this, we can move on to the trade credits. Just give a pause and take a water. Moving on to the next concept, which is the same under ECB, which we are talking about, limit and leverage. So we have seen the meaning of ECB and the definition of the external commercial borrowings. Now let's basically, after that framework, and then now a few other provisions are there regarding ECB. So one of the provision is, madam, so as a business entity, I can borrow how much ever amount of external commercial borrowings I want. So I'll go to all the countries in the globe where it is eligible, where these lenders are recognized, and I can procure loan of how much ever I want. No, there is a limit given here. See, limit and leverage. So what is the limit? The maximum amount of external commercial borrowings that can be raised by an eligible borrowers. That is what is specified in this concerned provision. What is it, madam? All eligible borrowers can raise ECB up to US dollars 750 million in a financial year. So in LRS, we have seen individuals can remit up to $250,000 per year. Here, eligible borrowers can raise ECB up to US dollars 750 million in a financial year under automatic route. See, under automatic route, that one you have to make sure. Under automatic route. Okay, so if, what is automatic route, madam? Very simple. Without any approval, you can raise external commercial borrowings. So if you are doing that thing, you can raise up to 750 million US dollars in a financial year. But if you want to raise more than 750 million dollars in a financial year, then you have to go through government approval route. That's all. Okay, so that is the limit that is specified in our provisions, which is, what is the limit of ECB that can be raised? All eligible borrowers can raise ECB up to 750 million US dollars under automatic route. Okay, so what does this mean? So if you are trying to borrow more than 750 million dollars, you have to go through a government approval route. That's all. One more petty provision which is given under this is very simple. If ECB has been procured from a foreign equity holder, that means in an Indian business company, already 20% of the stake is held by a non-resident. So that non-resident will be called as foreign equity holder. So if this Indian company is trying to procure debt from this foreign equity holder only, then they have to satisfy a condition. What is that condition, madam? The liability, that is the debt we are procuring from the foreign equity holder, is to the equity that is held in the name of that foreign equity holder cannot exceed the ratio of 7:1. For example, if that concerned foreign equity holder is holding around 100 million equity share, 100 million dollars worth equity. Okay, let's imagine that. Okay, already he made an investment of equity of around 100 million US dollars. Now, after he made an investment that is in the form of equity shares, then now if the same Indian company is trying to raise external commercial borrowing from the same foreign equity holder, they have to satisfy a condition. What is it? The liability to equity ratio cannot exceed 7:1. Okay, that means these people are obligated to raise only up to 700, only up to 700 million dollars. That ratio should be maintained if foreign currency denominated external commercial borrowings are being raised by Indian company from its foreign equity holder. That is the provision. Okay, so first provision regarding the limit, what we have seen, very simple. The limit is up to 750 million US dollars in a financial year of ECB can be raised under automatic route by eligible borrowers. What do you mean by leverage? Leverage means debt. So that debt to equity ratio, if foreign currency denominated ECB is being raised from foreign equity holder, should not exceed 7:1 ratio. That's all. Here also it's under automatic route. If they want to increase the ratio, then what they have to do, they have to procure government approval. Okay, so that one we can see with this. What is it? Procedure for raising ECB. The automatic route, if they meet all the parameters of ECB, then they can go through automatic route without any approval of the RBI. If any of the parameter is not met, that means minimum average maturity period, maximum all-in cost ceiling, or else not recognized lenders, or else some other provisions like end users negative list. If you are not following any of the conditions specified in ECB framework and still you want to raise ECB, then you have to take the approval of RBI. That is the approval route. So ECB can be raised through automatic route or approval route. Automatic route when if all the parameters of ECB framework have been met. If not, then require approval of the RBI. Okay. So under FDI, in entry routes, we have seen two routes, automatic route, government approval route. There they require government's approval. Here under ECB, if you don't follow parameters, then you have to obtain approval from the Reserve Bank of India. So don't get confused regarding writing the, what do you say, approval route. ECB approval route is required from RBI. Approval is required from RBI. When it comes to foreign direct investment, approval is required from the government. Okay, so I hope I'm clear with these two provisions. Limit and leverage is covered, and then procedure for raising ECB is covered. Now let's deal with one past question. This has been asked in June 2023, the first attempt of new syllabus. Write a short notes on provision of parking of ECB proceeds until its utilization for around 4 marks. Now this question is been asked from this concerned chapter, parking of ECB proceeds. What is parking, madam? Fun terms we are coming across. Sectoral caps, parking, repatriation. Repatriation is not fun, of course. Parking of ECB proceeds and all that stuff. So let's understand what is the meaning of parking of ECB proceeds. So as soon as, just in order to understand in a very better way, we have to write it down. So let's do that. Now, a resident entity, let's say A Limited, is procuring ECB. Okay, just a moment. I'll make it much more easier for you to understand. recognized non-resident lender here also the loan has been procured from a recognized non-resident lender. Okay. Now, this loan is foreign currency denominated. Foreign currency denominated. Okay. ECB. This is INR denominated. ECB. Okay. Here, another division. This amount which has been raised can be used for foreign expenditure, can be used for foreign expenditure or Indian expenditure. This, of course, if you are borrowing in INR denominated ECB, this will be oriented for which purpose? Of course, expenditure in India. Fine. Now, immediately after raising the external commercial borrowings, maybe you don't need it right now. Example, let's say all these are raised on 15th August. 15th August, 15th August, 24, 24, 24. This is the date of raising ECB. Date of raising ECB. Now, what happens is immediately, let's say this concerned A Limited has raised 3 different kinds of ECBs. Now, immediately they don't require the funds. Now, this first foreign currency purpose, let's write down the purpose also for better understanding. Purpose here is payment to Japan supplier. Japan supplier, and this has been raised in yen currency. Now, here payment to, let's say, some Indian supplier only. Okay, Indian supplier only, and this has been raised in foreign currency, that is US dollars. Okay, now here, of course, it has been raised in INR, and this is for the purpose of, again, payment, or example, let's say, payments for the purpose of expansion of business. Now, this Japan supplier did not send the equipment for us till now, and the equipment will be received on, let's say, 15th August, right? 14th November. 14th November. Now, what happens till 14th November? We are not able to utilize these funds, and we don't want the funds also. Now, there is an option. till the funds which are raised in the form of ECB have been utilized, and there is a time gap between raising of ECB and utilizing the ECB, you can park the funds somewhere. You can park the funds somewhere. Now, if the parking is like, if the money has been raised in for the purpose of foreign expenditure in the first case, here I have taken ECB from Japan supplier, sorry, from a recognized lender in Japan only. I have taken ECB in the forms of yen. Now, if I have to pay that yen to a Japan supplier in Japan only, then why will I bring the funds to India? So that is why what happens here is A Limited has raised Japanese yen from recognized lender in Japan only. Now this Japanese yen, instead of bringing into India, they can directly be paid to Japan supplier, no? Yes, but the loan has been raised on 15th August and the payment has to be done on 14th November. What will this person do? A Limited, it will be like November, right? 15th September, 15th October, and again 14th November. 3 months are there. So 3 months, why should I waste my funds? Simply, what will this A Limited think? I will park my funds somewhere in some investments where I can generate profits. Sorry, where I can generate some returns on that money for the 3 months period. That is only called parking. Here, what will A Limited do? It will invest in some treasury bills released by Japanese government or government securities, which are like liquid assets. What do you mean by liquid assets, ma'am? Simply, if you want to take the money, immediately you can sell them and you can take the money. That is called liquid assets. So the liquidity will be there. Easily that can be converted into money. Okay. So that is what the A Limited will do. It will park the ECB funds until 14th November, the date of utilization, in some liquid assets or else liquid investments. That is the case of parking the ECB proceeds abroad, that is outside India, because the purpose of ECB is only payment to outside India. So that is called parking of ECB proceeds. You will understand this. See, parking of ECB proceeds for foreign currency expenditure, they will be parked abroad and can be invested in specified liquid assets. What is it? Specified liquid assets. Why is the screen a little blurry? Okay. Yeah, now it's fine. Okay. I hope you understood. Parking means just simply putting these funds in some liquid assets for a shorter period of time so that they can generate a little return. And simply putting that ECB proceeds in bank account is a waste of, what do you say, a loss of interest. So that is why what happens, they will park the funds temporarily somewhere. Okay, so that is called ECB, that is temporary holding or placement of funds before they are utilized for their intended uses, intended purposes. My intended purpose is payment to Japan supplier on 14th November, but I have raised the loan in the form of ECB on 15th August. Now what will I do with the funds? I can't hold the funds in Japan account. No, you can do that. But that is also called parking only. You are not still utilizing. You are putting in your Japanese account. So that is why instead of just simply storing the funds in your account, you can invest them in some liquid assets or else liquid securities. Okay. So that is one case, which is parking of ECB proceeds abroad for foreign currency expenditure parked abroad can be invested in specified liquid assets. Okay. For example, government securities issued by, let's say, the Japanese government only. 90 days treasury bill will be released. No? After the 90 days, we can take back the amount. Okay. So, in that kind of assets, the investment can be done. Now, what about Indian currency? It's foreign currency loan only. But we are procuring the loan for the purpose of expenditure in India. Now, what happens? Immediately, you have to transfer the ECB funds into your Indian bank account. That is the bank account which is held with the AD category banks.
AD category 1 banks. So AD category 1 banks are the banks which facilitate this foreign currency transactions and which will allow us to create this foreign currency accounts to transfer our ECB proceeds or everything. ECB proceeds means loans. Okay, now the ECB proceeds that we have procured in the form of foreign currency, in our example US dollars, for which purpose? For payment to an Indian supplier in India. So that expenditure is where we are utilizing these funds in India. So immediately those funds have to be transferred to AD category 1 bank account. Why AD category 1 bank account? Because authorized dealer should be the medium for receiving funds or sending funds. So that is why in this case parking of proceeds should be done domestically for rupee expenditure, or should be repatriated, not or, should be repatriated. That means should be should be brought into India immediately into the rupee account maintained with the AD category 1 banks. Why rupee account, madam? Because you procured in foreign currency, convert it, because you need that for rupee expenditure only, no? So that is why you have to convert the dollars into rupees and you have to transfer the funds immediately to your rupee account, which is maintained by the AD category 1 bank. Okay, so the transfer is done. This is transfer, not parking. Now, where can be utilized? Where can we park these funds, or where can we temporarily place these funds? Simply with the AD category 1 banks only, they will provide term deposits to you. Term deposits are like fixed deposits. You will generate some fixed amount of profit, fixed amount of interest on these. So that funds which have been transferred to Indian rupee account with the AD category banks shall be deposited in term deposits with the AD category 1 banks only. But this money cannot be stored in term deposits more than 12 months. So the maximum period here is 12 months cumulatively. Okay. So I hope I am clear with this. So in this case, if we are making payment to the Indian supplier, or this case making payment, both the cases, the money should be immediately transferred to AD category 1 banks, and that can be deposited in the term deposits. Term deposits of AD category 1 banks. Okay. I'll just move this page to trash. Now, this is the concept for the procedure for raising ECB. Just remember the logic behind it, but simply what are the sentences that you're going to put? What is the meaning of parking of ECB proceeds? Temporary holding or placement of funds before they are being utilized for their intended purposes. Now, that can be done parking abroad if it is for foreign expenditure. If it is for Indian expenditure, that should be parked domestically. So what about parking abroad, madam? Simply that money will be parked abroad by investing in specific liquid assets. Okay, next, coming to parking of proceeds domestically, immediately the money should be repatriated to the rupee account, which is maintained with the AD category 1 banks, that is the authorized dealer. Next, now transfer is done. Where shall we park? Should you invest in some other assets in India? No, it can be invested only in the it can be deposited only in the form of term deposits maintained by AD category 1 banks. That to maximum period is 12 months cumulatively. Okay. That is the provision regarding the parking of ECB proceeds. And then we have seen the procedure for raising ECB. Automatic route, all the parameters are met. If not, approval route. Whose approval is required? Reserve Bank of India. Okay. Just a moment. Let's go to the concept book. So limit and leverage, eligible borrowers, ECB limit, all eligible borrowers can raise external commercial borrowings up to US dollars 750 million or equivalent per financial year. Here they have represented in US dollars. It's not like you have to borrow in US dollars only. Equivalent in any other freely convertible foreign currency.
Okay, and ECB liability to equity ratio for ECBs denominated in foreign currency and raised from direct foreign equity holder in our company, the ECB liability to equity ratio under automatic route cannot exceed 7:1. Parking of ECB proceeds. This is the matter that you have to write simply for that 4-mark answer. What is it? External commercial borrowings in proceeds intended for foreign currency expenditure can be parked abroad. These funds can be invested in specific liquid assets. Okay, next, parking domestically. ECB proceeds intended for domestic expenditure must be sent immediately to borrower's rupee account maintained with the AD category 1 banks in India. These proceeds can be parked in term deposits with AD category 1 banks for maximum period of 12 months. I hope I'm clear with this. What about parking of ECB proceeds, madam? Automatic route. All the ECB proceeds can be raised under the automatic route if they meet the prescribed parameters under this framework. Okay, next. Approval route for cases requiring approval. Borrowers may approach the Reserve Bank of India. I hope I'm clear with this. Now, let's move on to the next concept. This concept I did not add in my handwritten notes. I think I did. Okay. Few other miscellaneous concepts I did not add. So this one we will deal with our handwritten notes. Okay. So we are done with procedure, parking of ECB proceeds. Moving on to the next, reporting requirements. Moving on to the next concept, which is reporting requirements. Now, as a resident entity, I have procured loan from a recognized non-resident entity in the form of ECB. So, as a resident entity, I am obligated to submit few forms, that is monthly reporting requirements. That means I have to report it to the RBI through the authorized dealer. That means I'm not directly connected to RBI, but I have to report in certain forms in the RBI regarding the status of my ECB, like is the interest payments paid, like did you procure any new ECBs. So all these ECB transactions should be monthly reported to the authorized dealer banks. Okay, so that is what the reporting requirements says. As very simple. See, borrower is required to report ECB transactions on monthly basis, like your GST returns. Likewise, here also ECB forms shall be reported to the authorized dealers on monthly basis. Okay. See, the form number is form ECB2. Now, let's move on to the next concept, which is untraceable entity. Untraceable entity. So, in the name only, we are able to understand that the entity which is not been which we are not able to trace it. Like, in which aspect are we talking about, madam? Very simple. If a concerned entity who has procured loan from a recognized non-resident lender from outside India. Now, what is this entity doing? Very, very intelligently, it is trying to switch off the mobile of its directors, and switching off the mobiles, not coming into contact with anyone, not submitting any forms, not performing any audit in the concerned company. Simply the main motive, or else maybe the position might have become worst, so that they are unable to pay the external commercial borrowings. Now what happens? That entity will be termed as untraceable entity. Very simple, they are trying to default the loan. That's all. Okay, so Vijay Mallya is untraceable to Indian government. Yes or no? Here also untraceable entity means the entity which cannot be traced, or which is not reachable to the authorized dealer banks in order to know the details regarding ECBs or ask them to pay for ECBs. They are untraceable. Those entities are called untraceable entities. So let's understand the definition which is given under ECB framework. So what is an untraceable entity? Entity or auditors or its directors, its promoters are not reachable. That means they're unable to call them or email them. They're not responding. We don't know where they are located, and or responsive or non-responsive or reply. not responsive or replying negatively, that means no, we are not going to pay the debt, or else they say, who are you calling with, we are not that entity, we did not take any external commercial borrowings. So they are replying negatively, or else they are not responsive. We are able to reach their mobiles, but they are not responsible, not reachable. Not only we are not able to reach them only. So if an entity or its auditors or its directors or its promoters are not reachable, not responsive, or reply negatively over the emails or letters or phones for a period of not less than 2 quarters, that means for a period of more than 2 quarters, if the auditors or the entity or the directors or promoters are not being responsive, are not reachable over the email, phone, mobile, letters, everywhere, then that entity will be called as untraceable entity as per the ECB framework. Okay, so that the last point is with documented communication and reminders. Even if we send a documented legal notice, or even if we send a documented letter for repayment of ECB, or for at least report the ECB transactions, or we are keeping on reminding them through app notifications or through messages or emails, still they are not responsive or not reachable, then that entity will be called as untraceable entity as per the ECB framework. Once again, what is the definition of untraceable entity? Entity, auditors, directors, promoters are not reachable or not responsive or reply negatively over email, letters, phone for a period of not less than 2 quarters with documented communication and reminders. Even if we have sent them documented communication and reminders over the email and phone, they are not being responsive, that entity will be called as untraceable entity. This is the basic definition. But two other conditions should also be fulfilled to call that particular entity as untraceable entity. What are the conditions? See, not found to be operative at registered office. So the registered office address will be given, no? So if that authorized dealer, one of the person representing the authorized dealer bank, goes to the registered office, then he notices that no such business is going on here. There's no director, there's no office, there's no business. So the registered office is being non-operative. That means it's not going on. The business is shut down, or else it's temporarily closed. That in that case, and have not submitted the statutory auditor's certificate for the last 2 years or more. So what is statutory auditor for every company? The audit is called statutory audit because it's mandatory as per the Companies Act 2013. Yes or no? So if that auditor's certificate is not being submitted for the last 3 years to the ROC, then what happens? In that, if the two conditions will also be satisfied, that entity will be called as untraceable entity. Again, what is that? Untraceable entity. Basic definition we have understood. They are not reachable, not responsive, reply negatively. Now, what is the period? For more than 2 quarters. Another kind of saying is not less than 2 quarters. Okay, that period you have to keep in mind. And the next further two conditions should also be satisfied to call it as untraceable entity. What are the two conditions? Not found to be operative in the registered office. Number two, have not submitted the statutory auditor's certificate for the last 2 years. Okay. So that is the definition and also the conditions to be satisfied for untraceable entity. Now fine, ma'am, we got to know what is untraceable entity. Now why are we learning this? What happens if a concerned entity will become untraceable entity? It will have to bear repercussions. It will have to bear few consequences. So what are the consequences, madam? Number one, file revised ECB form. First things first. Monthly, the entity will have to, normal entity, monthly that entity has to file a form called ECB2 with the authorized dealer that these are the ECB transactions that took place in this concerned month. So these are the interest payments that I have made, and this is the, let's say if there is any loan repayment. So this is the status of my ECB as an entity. Now this has to be submitted every month to the authorized dealer. This will be going to the RBI through the authorized dealer.
Clear? So indirectly, who is receiving? RBI is receiving. Directly, who is receiving the form? Authorized dealer. Now what happens if it is untraceable? They are not submitting any forms, they are not making the payment of the loans, and they are not even being responsive regarding if they make the payment or not. That also is not being informed. Now what happens is, authorized dealer on behalf of the untraceable entity will file a revised ECB form stating that these are the ECB transactions for this entity, because we will receive the information from the lenders now. So that is the case. And at the last, that authorized dealer will also submit a last ECB 2 form. Why do you call this last ECB? Because we are in a perception, we have come to a conclusion that the untraceable entity will not be paying the external commercial borrowings anymore because they are not responsive at all. Now what happens? That concerned account will be closed. And the last ECB2 form regarding the status will be submitted by the authorized dealer to the Reserve Bank of India, stating untraceable entity on the top in bold letters in that ECB form. So simply as regular ECB form, they are not submitting. In that ECB form, they will be mentioning untraceable entity written in bold on the top of the form that will be submitted by the authorized dealer to the Reserve Bank of India. Okay. So, and the next consequence is whatever the outstanding amount that is payable, that's the loan repayment plus the interest which is payable by the concerned resident entity who has made a default, that will be written off from the external liability of the country. Because it's a commercial borrowing, that means loan has been taken by a resident entity. That means that will be the payable for government also, no? Like government's assets and liabilities will also be our assets and liabilities. So in the government documents, this person's external commercial borrowings is under the heading of payables, that will be written off. Because he is not paying, why should government pay? That's all. See, the outstanding amount will be written off from the external liability of the country. And the next repercussion, that is the consequences, no fresh ECB application is processed by the entity. Now, after this untraceable, after the entity has received the status of untraceable entity and the last ECB form has been submitted by the authorized dealer and the external liability has been written off from the ECB has been written off from the external liability of the country. Now, after 6 months or after 1 year, that entity will come and say, we want to receive another ECB, please give us now. Will they do it? No. You are not allowed to receive ECB. Previous one only you did not pay. Why will we give the permission to process a new ECB? That is what we are talking about here. Very simple. No fresh ECB application by the entity is processed by the authorized dealer anymore. Next, no inward remittance or debt service. He will be like, okay, if you don't give ECB, I'll not receive money. I'll go and I'll take a loan from some other lender outside India. Can he do that? No. He is not allowed to receive any debt service or inward remittance to that entity in any cost. So that entity cannot receive any sort of money from outside India in the form of debt services or else the normal inward remittance. And the last consequence, that's not a consequence but it's an obligation, that the authorized dealer should inform to the enforcement directorate that this concerned entity is been given a tag of untraceable entity. Okay, so what are the consequences? File the revised ECB form and the last ECB form with the untraceable entity words written on the top of that concerned form in bold letters, and outstanding amount that has to be payable by the resident entity will be written off from the external liability of the country, and no fresh ECB application by the entity shall be processed, and no inward remittance or debt service is also allowed for that concerned entity. Next, ED shall be informed regarding the untraceable entity status. Okay, so coming to the ECB chapter, remember one thing, there is a lot of unnecessary, unimportant text which is mentioned here. So that is why what I am doing personally is I'm not writing all the details regarding all the teeny tiny details in my handwritten notes for the chapter of ECB, because first things first, my handwritten notes will become long. It will become around 60 pages if I write all the things, if I mention all the details of that ECB chapter in my handwritten notes. So that is why what I have done is, for your convenience, all these are properly summarized and highlighted in my concept book. Provisions especially regarding trade credits. If you observe here, in the past, in the textbook backside questions are being asked from current account, capital account transactions, foreign direct investment, or regarding authorized dealer, foreign security versus Indian security, automatic route versus government route, parking of ECB proceeds, and remittances which are prohibited. Few important stipulation regarding LRS. Now, only one single question has been asked from trade credit. See, what is the vote of authorized dealer in case of trade credit? So, what is the role authorized dealers will play in case of trade credit? That's a very basic question. So, that is why I'm not going to waste a lot of time of yours by teaching, which is teaching a lot of theory regarding trade credits. So what I do is just this basic meaning of trade credits, and the base a few other important points will be there in my handwritten notes. Not all will be included, but of course listen to my regular class regarding all the concepts that I teach regarding trade credits. But before going to the examination, don't waste your time on this unimportant parts or else the topics. Okay, so that is why here also ECB only provisions regarding ECB, parking of ECB is only given. So that is why I'm not including everything. Whichever topic needs a elaborate explanation with the charts is only included in my notes. But for LRS, FDI, and salient features, these three are important chapters. So that is why I've included in my handwritten notes. Okay. So don't be in a perception that ma'am have not completed handwritten notes for the last chapter. No, I'm not giving you because it is not important. Don't waste your time. Okay, that's all. So we have understood the meaning regarding the consequences for untraceable entities. We have seen the consequences. We have seen the two other conditions to be satisfied with the definition. Now let's move on to the concept book for understanding few other concepts. See this. Regulations for amendment in ECB terms. Simply, initially, you enter, you procure, you raise as a resident entity, you raise an external commercial borrowing through authorized dealer. Let's say for that concerned external commercial borrowings, the minimum average maturity period is 3 years, and let's say the all-in cost is 6%, and all these are there, and the repayment interest or whatever the agreement is there. Now, after 1 year, that concerned resident entity wants to change the terms of the agreement, the terms of the ECB. Can they do that? Let's understand. See, the designated AD category 1 banks can approve any request from the borrowers for changes subject to ECB norms with the consent of lenders. So if a resident entity puts an application to the AD category 1 bank that please make changes for my ECB, like please change the interest rate or please extend the maturity period. So this will be requested to the authorized dealer. Yes, the authorized dealer should make changes, but one condition has to be satisfied. It has to get the consent of the lender. The lender also should approve from there that yes, okay, fine, you can increase your maturity. That is what very petty provisions which are not, that important for me to include in the handwritten notes. And the next concept, it requires handwritten notes. That is why I have included in this. So what is it? Refinancing of external commercial borrowings. Refinancing. That means very simple. You have taken
3rd August 2024, you have raised an ECB worth $500 million. Okay. After, with a maturity, minimum average maturity period of 5 years. Okay. Now, on 4th August 2027, let's say 2027, you are trying to refinance the ECB. What do you mean by refinancing, madam? Very simple. The name only suggests refinancing. You are trying to repay this ECB by procuring another ECB. What are you doing? You are repaying the original ECB by procuring another ECB. Very simple. Now, in the same example, let's say, okay, 4th August 2027 only, I am trying to, minimum average maturity period is 5 years, right? How many years did it expire till now? 2024, 25, 26, 27. 3 years are already expired. Yes, 3 years are already expired. So what is the outstanding maturity? What is the outstanding maturity? 2 years. Yes. Now, this concerned borrower, okay, this concerned borrower is now in a perception that I want to repay this $500 million with taking another ECB. I don't have the money, but I want to repay that concerned ECB, and that I want to do it by procuring another ECB. Can he do that? Yes, that is only called refinancing. But what is the condition for refinancing? Just a moment. Okay. Now, what is the condition? Refinancing is allowed. That means the borrower is trying to repay the original ECB by procuring a new ECB. That is the meaning. Okay. See, what are the conditions that you have to satisfy? First things first, outstanding maturity. What do you mean by outstanding maturity? For in this case, what I have explained you here, outstanding maturity is 2 years in this case. Now, refinancing should not reduce the outstanding maturity of original ECB. Now, why did I take ECB? To refinance this concerned original ECB. Now, if I am allowed to do that, if the ECB that I am raising right now for refinancing, that is 5 million euros, $5 million, this should have a minimum average maturity period of more than 2 years, but not less than 2 years. Less than 2 years, then that will not be qualified for refinancing of the ECB. Refinancing of the ECB, very simple, procuring a new ECB for payment of old ECB. That's all. Okay, but the condition that you have to satisfy is the new ECB's maturity period should not be less than the outstanding maturity period of the old ECB, original ECB. That is what it is stated here. Outstanding maturity. Refinancing should not reduce the outstanding maturity of the original ECB. Second one, all-in cost ceiling of new ECB should be less than weighted average. Main purpose, why are you trying to repay the old ECB, the original ECB with a new ECB? Maybe the chances the interest cost is more, yes, or else the maturity period is a little short and I am unable to make the payment within the short period, or else I can't bear that much interest cost. That is why what happens, you will go to a new lender.
where the interest cost will be less, or where the maturity period will be a long period, so that I can repay that with I'll have enough time for repayment. So that is why the two conditions are very basic common sense conditions. So the original ECB are unable to satisfy all the conditions because the maturity period is less and the all-in cost, that is the interest cost, is more. But if you are trying to refinance this original with a higher all-in cost with a lower outstanding maturity, it is not practical. This will make no sense. So that is why the condition here is, if you are procuring a new external commercial borrowing, that means a new loan is procured for paying the original loan, that new loan's maturity period should be more than the outstanding maturity period of the original loan, and also the new loan's all-in cost, that may be the interest plus upfront fee, should be less than the all-in cost of the previous original loan. That's all. The all-in cost of the new ECB should be less than the weighted average all-in cost of the existing ECB. Weighted average we have already seen in the concerned concept. What is it? Minimum average maturity period. We have seen how to calculate weighted average. Yes. What are we doing here? The loan amount into here period we are taking. Here we have to take all-in cost ceiling, and loan amount into all-in cost ceiling divided by the loan. Then you will get the weighted average all-in cost ceiling. So that weighted average all-in cost ceiling, the new ECB's all-in cost ceiling should be less than the weighted average all-in cost ceiling. Those are the two conditions for the refinancing. Okay, I hope you are clear with this. The basic meaning of refinancing is simple. You are trying to procure a new ECB for repayment of for closing of, or else the repayment of the original ECB. Okay. Now, let's understand this here with much more details. I have just simply laid down the concept in the handwritten notes. Now, conditions for refinancing. Outstanding maturity. The refinancing must not reduce the outstanding maturity of the original ECB. All-in cost. The all-in cost of the new ECB must be lower than the weighted average all-in cost of the existing ECB. And refinancing under previous framework. So let's imagine this is the framework that we have read. What is the framework? Recognized lenders, eligible borrowers, minimum average maturity 5 years, all-in cost ceiling benchmark plus 550 points. This is the original framework of ECB. Now, one of my external commercial borrowings I have procured long back, 10 years. At that point of time, there was a new framework. There was an old framework. Like, for example, maybe the recognized lender might have changed. Maybe the minimum average maturity period would be different. Maybe the all-in cost ceiling would be different. Yes or no? Now, that is called procuring ECB under earlier framework, earlier conditions. So, refinancing of ECBs raised under earlier framework is allowed provided the borrower meets the eligible criteria of the current framework. Now, original ECB is procured under the conditions of old framework. Now, if you are trying to procure a new ECB for refinancing the original ECB, then this new ECB should satisfy the conditions under new framework. Okay? ECB procured under old framework. Okay, now new ECB has been procured for refinancing. That means closing this and refinancing this. Okay, so this should follow the conditions laid down in the new framework. Okay, that's all. That is the simple meaning of this. Not much to worry about, not much to think about. Okay, and the two other things is partial refinancing is possible not. In our example, old ECB amount is $500 million. New ECB amount also I'm trying to repay the whole. With what? The whole amount. How much did I raise? $500 million. That is called complete refinancing. What is partial refinancing? You can take around $100 million of the loan and then refinance. That means here you are obligated to pay how much under old ECB? Only $400 million. Okay. So raising a new ECB to partially refinance an existing ECB is permitted under the same conditions. Okay. That's all. And these refinancing services generally are provided to entities again from outside lenders only. Okay, because ECB, right, the lender should be a non-resident and recognized. But for few companies, Indian banks will also provide refinancing facilities. That means Indian banks will provide loans for repayment or settling the ECBs that have been procured from recognized non-residents. For which kind of companies, madam? See, Indian banks participation. Indian banks can participate in refinancing only for highly rated corporates and Maharatna, Navratna public sector undertakings. This NCLT, Coal India Limited, and all these are called highly rated corporates and Maharatna, Navratna public sector units. So for this undertakings, for these entities, Indian banks can refinance the ECBs. Okay. I hope I am clear with this concept. We are done with refinancing of ECB and we are done with reporting requirements. And then we are left with two other concepts under ECB. After that, we can move on to what? Trade credits. Okay. So very simple, conversion of ECB to equity. Now, initially from that concerned non-resident, we have raised a loan. But now, instead of repayment of loan, we want to issue equity shares. That means we want to convert that loan amount into equity. Can we do that? You have to follow a few conditions. What are those? Now, first check if that Indian company is permitted to procure foreign direct investment, because foreign direct investment means equity. No. Now, I am converting ECB into equity. First thing you have to check is this company allowed? Is this company allowed to procure foreign direct investment or not? Under automatic route, then freely that ECB can be converted into equity. But under government approval route, of course, it needs government approval. See this, automatic route or government approval. The borrowings company's activities must be covered under the automatic route of FDI or receive government's approval for equity participation. Very simple. Now, initially, some ex-limited foreign entity is giving us external commercial borrowings. Now, we are raising a loan. Very good. Now, this person wants to convert this repayment of loan in the form of equity capital. Can he do that? First things first, he has to check this condition. This Indian business company, is it covered under automatic route of FDI or government route of FDI? Government approval route of FDI. Automatic route. Very good. Convert it. But coming to government route, take the government approval for conversion. If they give the permission, then you can convert it into concerned equity capital. Okay. That's all. But of course, you need the conversion should be done in the lender's consent. That lender consent should, that lender person, whoever the recognized lender is, he has to give his consent that yes, I am ready to convert my ECB into equity and should not involve additional cost. There should not be any agreement or obligation for that non-resident lender to pay extra amount for conversion of equity. That should not be involved. And the next things, it must not breach foreign equity caps under foreign direct investment policy. What is foreign equity caps? Sectoral caps, yes or no? That sectoral caps should be satisfied. That ECB is amounting to around 100% of the equity, but that concerned
in business entity is allowed only for 49% ECB. Sorry, 49% of equity. So can these people convert? No, because it is violating sectoral caps. No. So that is why what are the conditions that you have to satisfy in order to convert ECB into equity? What are we doing? Debt is being converted into equity by giving him equity shares. To whom? Non-resident. You have to do it first things first. You have to check if it is automatic route. Yes, you can do it, but you have to get lender's consent and you have to check sectoral gaps. If it is government approval route, you have to procure government's approval. That's all. Of course, pricing guidelines should be satisfied, and also the conversion can include matured but not unpaid ECBs. Okay, very simple. Now, this condition, just understand it. Now, ECB's maturity period is 5 years. So after maturity period is completed, you can convert this into equity with the following 3 steps. But between around 3 years, you did not complete. That is, it is an unpaid. That means it is an unpaid ECB. So can we convert this unpaid ECB into equity before maturity? No. Okay, so that is the condition that has been specified in the last part. So we have completed the concept of conversion of ECB into equity. So the next concept is security for raising external commercial borrowings. So of course, if you take a loan from a bank, we have to give them something as a security. Yes or no? So that, of course, they are not our relatives or they are not our fathers or mothers to trust us blindly by giving them money. They need something which will act as like a trust between the bank and the borrower, so that even if the borrower fails to repay that concerned loan, the bank or the lender will sell that concerned asset and take the money. So that is a security, normal, general, everybody knows that. So of course, for external commercial borrowing also, this is also a type of loans. That is why security must be provided. So who will do that work? Just a moment. Our authorized dealer category 1 bank has that obligation to allow, create as well as cancel charges on mobile assets and financial securities and issue of corporate and personal guarantees to secure external commercial borrowings. Who is between recognized lender and borrower? This authorized dealer. No, so authorized dealer should create a charge or cancel a charge. What do you mean by creation of charge, madam? What do you mean by cancellation of charge, madam? Very simple. See, now A Limited is the borrower. Previously, it has procured a loan worth, let's say, rupees 50 lakhs from an Indian bank. And this Indian bank has created a security or charge on a manufacturing unit. And it has given the loan of 50 lakhs. Now on this manufacturing unit, there has been a charge created. That is, it has been given as a security for a loan. Now, this A Limited now wants to procure ECB from a non-resident lender. Yes. Of course, this person has to be given security, no? Yes. Now, the authorized dealer bank will create a security, create a charge on this manufacturing unit for this non-resident lender. Madam, how can they create charge? Because they've already taken a loan on this manufacturing unit, no? Now what happens? This AD category bank only will cancel the charge
Why will they cancel, madam? Very simple. Now, let's say A Limited borrower is there. A Limited. Now, A Limited already has taken previously a loan worth 50 lakhs from an Indian bank. Now A Limited has only one asset, that is manufacturing unit, for the purpose of giving it as a security. Now what happens? A Limited will go to the AD category bank and say, I have come into an agreement with a non-resident lender for ECB, and please create a charge on this manufacturing unit and cancel the previous charge. Now what happens if cancellation is done? The repayment should also be done. Then A Limited will be like, yes, okay, authorized dealer, I will cancel my, I will repay the loan, previous loan of 50 lakhs, cancel the charge on manufacturing unit and create a new charge for this concerned non-resident lender. Okay, clear. So that is the obligation of authorized dealer. So creation of security, cancellation of charge of previous loans, providing personal guarantees, providing financial securities as what do you say, securities, all these are permitted. And who has to do those? Authorized dealers. Okay, very simple. So permitted actions, very simple. AD category 1 banks can allow the creation or cancellation of charges on immobile assets, mobile assets, financial securities, and issue corporate and personal guarantees. Okay, that's what we are talking about. So guarantee can be given by the AD category 1 bank by taking a security, or else guarantee can be given by any other business entity in India or any other person. That is what we're talking about, personal guarantees as well as corporate guarantees. Okay, so here what is the role of AD category 1 bank? It is just a medium. It will create the charges, it will create the certificate of guarantee. Okay, that's all. Now coming to another few concepts. Madam, as a company, I am going through a restructuring process. Corporate restructuring is going on, or else I am involved in this corporate resolution process. So can I borrow external commercial borrowings? Yes. Very simple. See, restructuring and insolvency. Entities under restructuring scheme, this internal reconstruction or external reconstruction or restructuring of the total debt profile, everything, or corporate insolvency resolution process can raise ECB only if specifically allowed in the resolution plan. So in that resolution plan, the liquidator who is doing that resolution plan, or that insolvency resolution professional who is there, he has to allow that yes, this concerned entity which is involved in the insolvency process can procure external commercial borrowings. I hope you know the meaning of insolvency process. The concerned entity is in a position where the liabilities cannot be repaid with the assets of the company, and the company is going through insolvency position, and that will be trying to be restructured by appointing a concerned resolution professional. Okay, at that stage of corporate insolvency resolution process, can that concerned entity procure external commercial borrowings? Yes. Okay, but that should be specifically allowed, permitted under resolution plan. Who will draw this resolution plan? The COC committee. If you already are familiar with the provisions of IBC, the COC committee of creditors will sit down and they will frame a resolution plan. Yes, so in that resolution plan, if external commercial borrowings is allowed, then they can procure the loan. Okay, next, if certain entities are going under investigation under FEMA, so that concerned entity has violated few regulations or violated few rules or prohibitions under the Foreign Exchange Management Act, and the ED is investigating the entity. So during that investigation, can I procure ECB? Let's read. Borrowing by entities under investigation. Entities under investigation or legal proceedings for violating FEMA regulation can raise ECB if they are otherwise eligible and comply with applicable norms. So of course, they are not telling us is it eligible directly or not.
It is eligible, but it has to follow few rules and regulations laid down under the Foreign Exchange Management Act, and few rules and regulations which are laid down by the Enforcement Directorate, that can this concerns entity which is going under the investigation process procure ECB or not. If all those norms are satisfied, that concerned entity which is going under the investigation process can procure external commercial borrowings. So these are very petty concepts, so that is why I'm not including in my handwritten notes. Even if I include these, again I have to write the same text, which is like a time waste for me, and also you, because you have to read both concept book as well as handwritten notes, and this petty concepts are not required for last day before the examination revision. Okay, so moving on to the next concept, which is trade credits, the last concept. Okay, and I hope you might feel a little you might be in opinion that madam is going a little fast with ECBs. No, ECBs and LRS, I already told you in the at the end of first unit only. These two will move on a little fast because you already are familiar with the terminologies. But of course, the first and second units will go a little slowly by in detail explanation and all that. Okay, so that is what my regular class will also look like. Okay, this is a regular class only. Okay, fine. Now, moving on to the next concept, what is it? Trade credits. Trade credit. What is the meaning of trade credit, madam? Very simple. Credit extended by the supplier for the purpose of import of goods. Very simple. Credit period has been given for an importer in India by a foreign supplier for payment for the goods. That's all. See this. Credit extended by overseas supplier, or banks have given me a credit period. That means banks paid off the supplier, but I have to pay to the banks later on. Or financial institution have given me a credit, or other permitted lenders have given me a credit. For what purpose, madam? For import of capital or non-capital goods under permissible foreign trade policy of Government of India. What is it? Very simple. As an importer, I want to purchase few goods, but I don't have money right now. I will be repaying afterwards. And now I don't want to take a loan for this purpose. Very simple. You can take trade credit. That credit will be given by the supplier himself who is supplying the goods, or is banks or financial institutions or other lenders. Okay, so these banks and financial institutions will give us a credit, trade credit, and the original supplier will be receiving the payment from the banks. Okay, so what is the meaning of trade credit? Credit extended by overseas supplier, banks, financial institutions and other permitted lenders for import of, for which purposes? If I import capital goods, if I import normal goods and services which are not capital in nature and under permissible foreign trade policy. This foreign trade policy, FTP, is there in your GST, your IDT paper, yes or no? So as per the foreign trade policy, if I am allowed to import this category of capital goods, that's okay. For this concerned capital goods, trade credit period will be extended by either the overseas supplier or banks or financial institutions. Okay. Now, let's get into the details of trade credits by watching the trade credit framework. What is trade credit framework? Likewise, we have seen in our external commercial borrowings, conditions to be satisfied in order to call that loan as ECB is given in the ECB framework. The same way, what are the conditions which have to be satisfied in order to make that concerned credit as eligible trade credit? That are the conditions that we are going to see here. Okay. Here also the trade credit will be of two types: foreign currency denominated trade credit, INR denominated trade credit. INR denominated trade credit means we are paying them in the form of INR and the credit is also extended in the form of INR. Okay, few foreign suppliers accept Indian rupees. They will convert that into their foreign currency. But few foreign suppliers won't accept Indian rupees. We have to pay them in foreign currency. So in that case, you will procure trade credit in the form of foreign currency denominated trade credit. Okay. So very simple. If I am importing capital goods or non-capital goods from outside India, few suppliers who are selling me the goods will accept Indian rupees. So at that point of time, if they're giving me trade credit, that is called INR denominated trade credit. Now, few suppliers will not accept Indian rupees, but they say we want foreign currency. Then if that concerned supplier is extending a credit to me, that will be called as foreign currency denominated TC. So likewise, if I am taking a loan in INR, it is called ECB. Like the same way, if I am making the payment by through the credit period in the form of INR, it is called INR denominated trade credit. Okay. So what are the forms? We have supplier's credit or else the buyer's credit. Madam, supplier is giving credit. Okay, fine. What is buyer credit? I will only give credit to myself. No. Buyer's credit means you are taking a trade credit, a loan or a short-term loan for just, that loan is just for the payment of import of goods. That is called trade credit that you take from banks or financial institutions. Okay, that is called buyer's credit. So this can be a supplier's credit, that is credit extended by supplier, or buyer's credit. Buyer's credit means the credit is given from the banks or the financial institutions. Okay. Now, coming to the next thing, eligible borrower. Who is eligible to borrow this trade credit? Very simple, person resident in India acting as an importer. So this concerned business entity is importing goods, capital goods or non-capital goods from outside India. This person is eligible to get trade credit. Okay. Next, moving on to the next concept, amount under automatic route. Of course, for procuring trade credit also, there is automatic route and approval route. Now, let's understand what is the limit of amount for which trade credit can be procured under automatic route. See, they have given two types. Up to $150 million or equivalent per import transaction, that is per a capital good or per a non-capital goods, per transaction, I am allowed to get US dollars 150 million of trade credit. For which purposes? For oil/gas refining or marketing of that oil and gas and airline and shipping companies. Okay, just to clarify the confusion. Yeah, oil and gas refining and marketing. Okay, sometimes a little confusion will be there even if I prepared the material only. See, this amount of trade credit that is allowed under automatic route, that means without any approval of RBI, without any approval of government, is up to $150 million US dollars. For which purposes? For oil and gas refining, marketing, our airline and shipping companies. Okay, just a small confusion. Oil and gas refining, marketing, airline, shipping countries. Okay, shipping companies. And for other purposes, madam, what is the limit? Up to 50 million US dollars or equivalent. Why are we talking about equivalent? It's not an obligation that we have to import every time from a US company, right? We have to pay in euros also. So that is why this dollars, how much ever it is represented in the form of euros, that will be the limit. Okay. Now, amount we have seen, what is the limit of amount for these purposes? 150 million US dollars. For other purposes, 50 million US dollars. Who is the eligible borrower? Person resident in India acting as an importer. Then what is the form? It may be a supplier credit or a buyer's credit. That means credit that we take from the bank, financial institutions or other permitted lenders. Okay, now let's understand who are the recognized lenders. This one only, we have already discussed this concept. For supplier's credit, the supplier of goods located outside India, the person who is selling me goods, he will only give me trade credit. Okay, now coming to buyer's credit, who will be giving me the trade credit? Banks or financial institutions or foreign equity holders located outside India and financial institutions in IFSCs, International Financial Service Centers located in India. See, first things first, banks. Okay. Next, financial institutions. Next, foreign equity holders located outside India. Okay. So, very simple. Just a moment. Technical glitch. Okay, coming back to this concept, recognized lenders. So, who are the recognized lenders for supplier's credit? The supplier himself. Okay, so buyer's credit, just simply understand this with a flow chart. Importer, importer, importer of goods located in India. Now, who is a recognized lender? He is importing goods from a supplier located outside India. Located outside India. Okay. Now, the trade credit. Let's say case number 1. The supplier will only give the trade credit. Like in which format, madam? The payment, let's say the payment is around $15 million. Now, in this case, if the supplier is providing the trade credit to the importer, it is nothing but deferring the payments. Deferring the payments over the trade credit period. These details are not there in your textbook, but simply in order to make you understand, I'm telling you. What happens is this importer of goods will pay to the supplier in installments, or else over the trade credit period he will be paying with the help in, let's say, in the same example what you do in your concerned for the purpose of purchasing your mobiles. What do? You pay equated monthly installments, EMIs will be paid, right? Likewise, this concerned importer also will defer the payment of that concerned import over the trade credit period. Okay, so that is the provision that is given for you. That is the first recognized lender. Second recognized lender is banks, financial institutions, and foreign equity holders. All of these are located outside India. Located outside India. Now, how will these people extend the credit? Very simple. Banks, financial institutions, foreign equity holder, they will provide TC in the form of a loan to the importer, and they will first pay back the full price to the supplier. Who will pay the supplier? The banks, the financial institutions, and foreign equity holder will first pay the supplier. The transaction between importer and supplier is done. Now, who is involved in this concerned transaction? That is the trade credit, the importer and the banks, or the financial institutions and the foreign equity holder. The importer is obligated to pay to these people with interest as well as the original amount of the goods that has to be paid for. Okay, that is the second format. This is called buyer's credit. This is called supplier's credit. Supplier himself will say that, okay, don't pay right now. I know your status, Ray. You will not be able to pay now. So, of course, what you will do, principal plus a little bit of interest every month you pay to me for this 3 years. This is my trade credit offering for you. Now, the supplier will be like, I should give you trade credit. Giving you goods is only one major task that I do. I can't take that much risk.
ask your bank to give me the amount, then that bank will give you trade credit. Now what happens? That is called buyer's credit. Now this person is taking a kind of a loan. You won't call it as a loan, you won't call it as ECB, but that is a trade credit. Because why? That is just for the purpose of importation of that goods. So that is why that is called a trade credit, that will be extended in the form of a loan to by the banks and financial institutions to the foreign equity holder to the importer. Then originally that amount will be paid by whom? To the banks, to the supplier. Banks will only be paid to the supplier. But that will be eventually be repaid in the form of installments by the importer to the banks. Okay. Now this importer will pay to these institutions in installments, but these lenders will immediately pay to the supplier. Immediately. Okay, I hope you have understood the meaning of these. There are some other recognized lenders also. So one of the recognized lender is, we've already seen, for buyer's credit. Who are those? Foreign equity holders in our company, and banks and financial institutions. The third one, if we observe here, they say it is financial institutions in IFSC, International Financial Service Center. So in India, there will be few international financial service centers. These are like, let's say, few cities, just like an organization, like a place where financial institutions will be located, and these financial institutions will easily provide loans or debt services or banking facilities to both the residents as well as non-residents. Okay, so these concerned financial institutions will provide loans in the form of foreign currency, INR. So that is why these are called financial institutions located in India, but in which regions? International Financial Service Center. One of the examples, beautiful examples, very simple, you will strike in the first chapter. Before 8 hours, if we go back, what we have discussed, one of the meanings, what is it? Authorized persons. In authorized persons, we have seen 3 category of persons: authorized dealer, money changer, offshore banking unit. This is a banking unit situated in SEZ, which will provide, how do you say, easy banking facilities, foreign exchange facilities. Yes. So one of the example for financial institutions located in International Financial Service Center is offshore banking units. Okay, so these banking units will provide us loan in foreign currency, Indian currency, will extend foreign currency, foreign exchange transaction facilities, and it will give loans to both residents as well as non-residents. Okay. Now, both residents as well as non-residents can also deposit amounts in any form of currency, foreign currency or Indian currency, in this financial institutions located in this region. Okay, so that is also classified as one of the recognized lenders under trade credit framework. So again, let's just quickly revise it. Who are the recognized lenders? Supplier located outside India, banks, financial institutions, foreign equity holder located outside India, and financial institutions in international financial service centers located in India. Okay, next note. The specific note given here: participation of Indian banks and non-banking financial companies operating in IFSCs as lenders will be subject to guidelines issued by RBI. In international financial service centers, not only offshore banking units and foreign banks, but also Indian banks will also be there. But this Indian banks and NBFCs registered with the Reserve Bank of India, if they are operating in IFSCs, if they are, providing trade credit to the importer, they have to follow some other set of conditions also, okay, which are released by the RBI. That's all. And further, foreign branches and subsidiaries of Indian banks. So Indian banks will have foreign branches and their subsidiaries located outside India. No? So if
this concerned importer is trying to procure trade credit from those foreign branches or from those subsidiaries of Indian banks, then it is permitted, but only foreign currency. They can only extend the credit in the form of a foreign currency. Okay, next. I hope I am clear with this. Once again, if you give a reading, you will understand. Don't get confused regarding this. Trade credit in the form of foreign currency means payable in the supplier will be paid in the form of foreign currency. At the same time, trade credit will be extended for us from the banks and financial institutions in the form of foreign currency. And if it is coming to INR denominated trade credits, payment will be done in the form of INR, and the trade credit facility extended by banks, financial institutions is also done in the form of rupees, that is INR. Okay. Now, next is period of TC. So, what is the maturity period of TC? Maximum. Here we don't call it maturity period, but credit period. Okay. So, capital goods. If you are trying to import capital goods and you are procuring trade credit for the purpose of importation of capital goods, then the trade credit period can be maximum up to 3 years. Okay. Next, non-capital goods in general, maximum credit period is up to 1 year or length of the operating cycle. Operating cycle of that concerned non-capital goods. That means, what do you mean by operating cycle? The period from which the raw material will be converted into finished goods. So that operating cycle period, or else the trade credit period, which is it up to 1 year. Okay. Maximum. Next, whichever is less. Remember this, whichever is less. 1 year or operating cycle period, whichever is less. That will be the credit period, maximum credit period for non-capital goods. But specifically non-capital goods like shipyards and shipbuilders, maximum credit period is up to 3 years. Okay. That is the period of trade credit. Recognized lenders, amount which is allowed under automatic route, eligible borrowers and forms. Now next, all-in cost ceiling. Of course, if that banks or financial institution or that concerned lender only, poor people, they are giving you credit. They are giving you time to repay. Yes. Will they give it freely? Of course not. They will charge some interest amount, time value of money. Even small rupee will have time value that will be keeping on increasing as a time. Yes, increases. Yes or no? So that is why relevancy of rupee 1 10 years back is 1 chocolate. Yes, yes or no? And also 1 chocolate, sometimes a drink. But now relevancy of 1 rupee, you're not even getting 1 toffee also. What happened here? Time value of money. Rupee value depreciated as the time passes. So that is why they charge interest. Okay. Now, all-in cost ceiling, I've already told you, which is interest cost plus other costs. The maximum how much can the cost be levied on this concerned trade credit is given. For foreign currency denominated TC, it is given benchmark rate plus 350 base points, or else benchmark rate plus 300 base points. But Indian currency denominated TC, benchmark rate plus 250 base points per base points. Okay. But here why two different things are given? Very simple. Not that important, but I'll explain you. Previously, for existing TCs linked with LIBOR, whose bench rates are changed to alternate rate. Now, alternate recovery rate. Simply, when the trade credit is given to them, they said that all-in cost ceiling will be LIBOR plus 350. But afterwards, that LIBOR is changed to alternate, recovery rate. Okay, so that's simple. So if that concerned all-in cost ceiling, which is linked to LIBOR, has been changed to ARR, for them the limit is benchmark plus 350. Now, if that is not happening for new trade credits, very simple, benchmark rate plus 300 base points. Okay, why, madam? What is the logic? That is again I have to go I have to go teach you what is LIBOR, why it has been changed to alternate recovery rate. That is all not at all required for us. Very simple. If previously for old TCs the benchmark rate is linked to LIBOR, What is it? London Interbank Offer Rate. But this benchmark rate is changed from LIBOR to ARR. What is it? Alternate recovery rate. Madam, why didn't you mention full forms here? In your textbook also they did not mention. That's all. Okay, so for this kind of TCs, benchmark rate plus 350 base points. What are 350 base points? 3.50%. Okay, don't think much. And for new TCs, this change from LIBOR to ARR, all that nonsense is not there. Simply benchmark plus 300. Now coming to Indian denominated TCs, INR denominated TCs, benchmark rate plus 250 base points spread. Okay, that's all. Next, so the basic things we have covered. What is it? All-in cost ceiling, period of TC, recognized lenders, amount of trade credit allowed under automatic route, eligible borrower, and forms of procuring it. Okay. Now moving on to the next concept. Difference between foreign currency denominated trade credit and INR denominated trade credit based on the exchange rate. So very simple, foreign currency denominated trade credit is a trade credit facility which is extended in the form of foreign currency. And the trade credit is payable by the Indian importer in the form of foreign currency. Now what happens if he has to pay, let's say today, he has come into an agreement with an overseas supplier for purchase of goods. The goods value is $10 million. Now, the exchange rate today is around, let me just explain this with an example so that you will understand in a very better way. Okay, I think I've already written the example. So, Indian importer is importing capital goods worth $10 million from the overseas supplier. Now what happens is he has to pay this $10 million after the trade credit period. Let's say the trade credit period here is 6 months. Now, on August 14th, the date of transfer of goods, that is they enter into an agreement that the concerned overseas supplier is providing foreign currency denominated trade credit. Okay, on that day the exchange rate is $1 is equals to 75 rupees. Now if there is no obligation for making payment in future, what would be the outflow in the form of foreign currency in the hands of importer? 75 rupees into $10 million, that is 75 crores. Yes or no? If all this future trade credit, everything is not there, if I have to make immediate payment, how much amount will I make? 75 crores. Now, the trade credit period is extended. That means I have to make the payment after 6 months. Yes or no? The payment is made in the future. And is there any certainty that in future the exchange rate will be $1 is equals to rupees 75? No. So that is why. Now what happened is very simple. That concerned the concerned borrower, the importer, is in a scary mode. Oh my god, if by mistake after 6 months the exchange rate will become $80, where should I get the extra money from? So that is why what he will do, he will convert his foreign currency. Let's say in the same example, after 6 months, the amount is $1 is equals to 70 rupees. Oh my god, he will do festival and he will say, I have saved $5 per dollar. Do you know that? Oh my god, it's a profit. But in the same case, after 6 months, if $1 is equals to 80 rupees. So that is why, in order to, mitigate this risk, if the importer wants to convert its foreign currency denominated TC into INR denominated TC, he can do that. Very simple. Why, madam? If INR denominated TC means, what is the advantage?
it is fixed that you have to pay 75 crores only. If it is like foreign currency denominated one, it is not fixed. There is a risk involved that the exchange rate will increase. Yes or no? So that is why maybe the US dollar will appreciate and I have to pay more. Maybe the Indian dollar will depreciate and I have to pay more. So that is why what happens is very simple. If you convert it into INR, you can simply pay in Indian rupees. So that is why that is possible. Then in which kind of rate you, at which exchange rate will this be converted? At the date, at the exchange rate prevailing on the date of agreement. On the date of agreement in which both the parties agreed that we will convert foreign currency denominated foreign currency denominated trade credit into Indian currency denominated trade credit. On that date, whatever the exchange rate is applicable, that exchange rate, they will convert the money in that exchange rate, or is lesser exchange rate if it has the consent of the lender. If lender agrees that okay, today is 76 rupees, but you're crying, no, I'll give you for 74. If he is giving that consent, then that rate will be applicable for conversion of foreign currency denominated trade credit into Indian currency denominated trade credit. Now, the second one, for conversion to rupee, exchange rate shall be the rate prevailing on the date. Here what happens is, INR facility will be given to whom? To the importer. Now INR facility means payable in INR only. So but even then if it is payable in INR, the main good value will be represented in the form of foreign currency. No, on which date you have to convert that foreign currency into INR? On the date of final settlement. That is what specified here. Very simple. Okay. Now coming to hedging provisions. What is it? Hedging provisions. If in your strategic financial management subject, Ravi sir has already taught you regarding the hedging provisions, maybe in the chapter of derivatives or maybe in the chapter of forex, because that is one of the key concepts, hedging provisions. Yes or no? So what do you mean by hedging, madam? If you have listened to sir's class, though, set you will not have any confusion. Very simple. But if you didn't listen to Ravi sir's class, I will just make it very simple. Now in the same case, I'll explain with my handwritten notes. Now in the same case, the goods value is $10 million. $10 million. $10 million. Now what happened is, if it is foreign currency denominated TC, Indian currency denominated TC. Now what happens is, on the date of entering into the contract after the sale of goods, or on the date of extending credit facility, let's say the exchange rate is $1 is equals to 75, $1 is equals to 75 rupees. Now, if it is FCY payable, I've already told you, in future, the exchange rate may be increased. Yes or no? That may be increased to rupees 80, or that may be increased to rupees 85, or that may be decreased to rupees 70. We are not sure about that, because there is a foreign exchange risk involved. In order to mitigate the foreign exchange risk, the concerned importer can enter into a hedging contract. What is hedging contract? Hedging contract is a contract for mitigating the foreign exchange risk. Now, what do you mean by entering into hedging contract, madam? This concerned importer will come into a forward contract. With an Indian bank. Or else an authorized bank, whoever it is. Specifying that on this concerned date. So, if importer after 6 months he has to pay, $10 million, what he has to do? He has to purchase the $10 million. By selling rupees.
by selling rupees. Yes or no? Now, this concerned importer will come into a forward contract that after 6 months, I will definitely purchase 10 million US dollars, but I want the rate to be fixed at rupees 76, let's say. At rupees 76, I will purchase $10 million after 6 months on this particular date. This is called entering into a forward contract. Now, on the same date, let's say after the 14th June, let's say on 14th December, the concerned importer has bought, what do you say, the dollars for around 76 rupees from the bank, from the Indian bank, authorized dealer. Why? Because he has entered into a forward contract. If he has not entered into a contract, let's say the foreign exchange rate on that date in India is around 80 rupees. What happens? Instead of 75 crores, he has to pay 80 crores. But if he had entered into a forward contract by hedging the risk, he would have just paid around $76 only, 76 crores only. Now understood the provisions regarding hedging. So this is a kind of hedging which can be done both by Indian citizen, that is the importer, as well as the borrower also. Second case, INR denominated. If the concerned overseas supplier is receiving in INR, then he has to convert the INR into dollars. No. Now he is scared that, what do you say, the Indian rupees, here also he is scared that he will receive less dollars. Here also foreign exchange risk is involved. Same way, just a minute. Same way, if INR denominated, sorry, I'm getting ECB, trade credit is there. Now, 75 crores, let's say 100 crores is the payable amount. How much? Rupees 100 crores is the payable amount. Now, on the date of settlement, on the date of final payment, now the exchange rate is $1 is equals to rupees 75. Okay. Previously, it used to be $1 is equals to rupees 74, let's say. Now, case number 1, $1 is equals to 75. And case number 2, $1 is equals to rupees 70. Now, if the exchange rate is this much, how much will this concerned person receive in the form of dollars if the payable amount is 100 crores, in this case, how many dollars will this person receive? Very simple. 100 crores divided by 75 rupees. How many dollars will he receive? $13.33 million. $13.33 million. If there's any calculation error, please ignore it. Okay, but if the rate is 70, let's say 100 crores divided by 70 divided by how much? $14.285 million. Now, in this case, when the dollar value has, appreciated, then what happened? He has received less dollars. When the dollar value has depreciated, he has received more dollars. Yes or no? Now, he will also be under the risk. Yes. Now, in order to hedge this risk, he can also enter into a contract. Who? The overseas supplier. The overseas supplier is scared that at the time of final payment, he might receive less number of dollars due to the exchange rate fluctuations. If
let's say if dollar value has depreciated, what happens? Less number of dollars will be received from the concerned Indian rupees. Very simple. If dollar value has appreciated, more rupees, less dollars. Yes, more rupees, less dollars. If dollar value has depreciated, less rupees, more dollars. The same way, you can see the example only. If the exchange rate is 75 rupees, he is receiving only $13.33 million. After 6 months, if exchange rate is decreasing, he will receive only $14.28 million. That means, this case, he is happy. In this case, he is not happy, because he would at least receive around $14 million, let's say, as per the date. So that is why both importer can hedge his rupees as well as this concerned overseas supplier can hedge his dollars. Okay, hedging means mitigating the foreign exchange risk. That's all. We don't think much. If you finish the concept of hedging provisions in the strategic financial management concept, this will be much more easier for you to understand. Okay, not much to think about. See this. Hedging provision, the entities raising TC are required to follow the guidelines for hedging issued by the concerned sectoral. So, sectoral and prudential regulatory in respect of foreign currency exposure, they will give you guidelines where to hedge your contracts. Okay, that you have to follow. And overseas investor can hedge their rupee exposure using permitted derivatives. Permitted derivatives like futures, options, like other forward contracts and all that you can engage in for hedging contracts. Okay, so you can carry out hedging. That overseas supplier can come and carry out hedging in hedging through authorized dealer category 1, through Indian banks branches outside India, or foreign banks with operations in India. Okay, clear everyone? So of course the hedging contracts, all these derivatives will be purchased through banks or Indian financial institutions. Yes or no? So that is why a foreign overseas supplier, if he wants to hedge his rupees, then what he has to do, he can enter into hedge contracts by purchasing the derivatives through authorized dealer banks, through Indian banks having branches or subsidiaries overseas, or foreign branch operating in India. Okay. So this is the provision regarding hedging provisions. And change of currency of borrowing. This is very simple. If I have initially the trade credit facility is provided to me in US dollars. Okay. Now that concerned supplier is telling, no, I don't want you to pay in US dollars. I want you to pay in my home currency, that is euros. So can we convert that one foreign currency from one foreign currency to another foreign currency? Yes. Very simple. Change of currency of TC from one freely convertible foreign currency to another freely convertible foreign currency is permitted. And we have seen here also, foreign currency to INR is also permitted. Okay. So if initially the Japanese supplier is telling me, US dollars is global currency, no, please give me US dollars. But then after 1 month, he was like, no, I'm not sure. Please give me yen only. So can that concerned overseas supplier come into an agreement with the concerned importer to convert the TC into one freely convertible foreign currency into another freely convertible foreign currency? Yes. One freely convertible foreign currency to INR? Yes. But if initially the trade credit facility is extended in INR, after that you cannot convert that into FCY. Okay, see this. The change of currency from INR to any freely convertible foreign currency is not permitted, because initially the concerned supplier says, I will accept rupees. Yes. Now what happens? There will be no flow from the foreign exchange reserves of India. Foreign exchange reserves in first evolution we have seen. Yes. From the treasure there will be no foreign exchange flow outside India. Yes or no? Now what happens if suddenly that concerned person wants payment in the form of foreign currency? What happens? There will be flow of foreign exchange. There will be funds taken from the foreign exchange reserve. The foreign exchange reserves will deplete. Yes or no? So that is why RBI has played a trick, and it's told that you can convert foreign currency payment into Indian currency payment because it will protect the reserves, but you cannot convert Indian currency payment into foreign currency payment because the reserves will decrease. Yes or no? So this is just a behind logic, but simply very simple. What you have to remember, change of currency of trade credits denominated in foreign currency to another foreign currency is possible. Foreign currency to Indian currency possible. But trade credit denominated in INR cannot be converted into any freely convertible representative trade credit. That's all. Okay. So these are the provisions regarding the trade credit framework. So I'm just telling you very simple. If I am not teaching a certain concept using my handwritten notes, simply I am portraying that this is not important. That's all. In order to explain it, I'm using few examples, but not that important because it is very, there is no proper way to frame the question from these unimportant, confusing sections or confusing frameworks or rules or conditions. Okay, what you have to do is very simple. Listen to my class again after you're done with the regular, after you're done with listening to my class once. If you still don't understand, go back, play it again, and then listen. But all the concepts that I have covered in my concerned, handwritten notes, that has to be revised before going to the examination. Okay. Moving on to the next concept, which is trade credit in SEZ, FTWZ and DTA. SEZ, okay madam, what is this FTWZ? This is free trade and warehousing zones. So SEZs, free trade and warehousing zones, domestic tariff areas, all these are like special zones where the main motto is promoting exports, promoting imports, and they will have a lot of tax reductions and special financial facilities for them. So the TCs, which can trade credits be raised in STZs and FTWZs? Yes, of course, trade credits can be raised by units or developers in SEZs, including the free trade and warehousing zones for purchasing capital and non-capital goods. Likewise, the trade credit facilities available to other business entities, it is available for SEZs. So that's not much to talk about. But entities in domestic tariff area can raise TC to purchase capital and non-capital goods from units and developers from SEZ. See, what is TC? Trade credit raised from a non-resident supplier. If an entity which is there in domestic tariff area and it is purchasing capital goods or non-capital goods from SEZs and FTWZs, and they are extending trade credit, they are extending some credit, that will also be called as trade credit, and it will be coming under this ECB or trade credit framework. Because SEZs are like foreign companies only, because they will have a lot of exemptions, they are mostly oriented for exports, and foreign companies come and make investment here. So even if trade credit is procured from SEZs located in India by DTAs, that will also be qualified as trade credit. Okay, that is given here. And the next, compliances and regulations is TC transactions must comply with SEZ Act 2005. Of course, you have to follow the SEZ Act 2005. And for SEZ transactions, the date of transfer of ownership of goods is treated as trade credit date. On which day the trade credit period will start? On the date of transfer of ownership of the goods. Next, no bill of entry is required for sales within SEZs. Sales within one unit of one entity of SEZ to other entity of SEZs do not require any bill of, bill of entry. Okay, but then how can we represent it if the transaction has happened or not? Like, what is the document that we have to show? There is a document which is released by NSDL. Okay, what is it? The inter-unit receipt generated through NSDL. Just a moment. No bill of entry is required for sales within SEZ. So within one entity of SEZ to other unit of entity and SEZ, there is no bill of entry required. Then instead of bill of entry, what is the document that you show? Very simple, the inter-unit receipt. The inter-unit receipt, which will be generated by whom? Generated through NSDL, National Securities Depository Limited. National Security Depository Limited. Through this concerned depository, we will generate an unit receipt, and that will only act as bill of entry. Not much important for us, very simple. Trade credits can be, what do you say, the trade credit facility is available for SEZs and FTWZs. And also, if goods are being sold from SEZs and FTWZs goods are being sold from SEZs and FTWZs to domestic tariff areas. Here also the credit facility extended by these SEZs will still be called as trade credit, and it should comply with the framework given here. Okay, now, and the next concept is security for trade credit. What is it? Security for trade credit. Previously we have discussed regarding the security for ECB. Yes or no? What is it? For the loan we are extending some security. Now for trade credit also, they are not sure that you will repay or not. So that is why what they are doing, they are asking for a security. Now, what are the different kinds of securities that can be given to a trade credit? Bank guarantees. The authorized dealer banks can provide bank guarantees on behalf of the importer to overseas lenders. The guarantee period cannot exceed the maximum permissible period for trade credit. Very simple. Who is between this overseas supplier and importer in India? Authorized dealer. So to this overseas supplier, this authorized dealer bank will only give guarantee that, okay, I am giving you a guarantee even if the stupid importer won't pay you in future. Okay, fine. So this is called, what do you say, guarantee extended by whom? Bank guarantee extended by authorized dealer. So this guarantee period should not be more than the trade credit period. Of course, it can't be more than trade credit period. Okay. Next, overseas guarantee. What is it? Overseas guarantee. TC can be secured by overseas guarantees issued by foreign banks or overseas branches. Not only the guarantee is not only like coming, it should only be given like authorized dealers. It's not there. It can be given by foreign branches or foreign banks of foreign branches of Indian company, Indian banks or foreign banks. Whoever can give, what is it, guarantee for this concerned trade credits. Okay. So TC can be secured by overseas guarantees given by foreign banks not incorporated in India or overseas branches of Indian banks. And the next, security options. What kind of, other than guarantees, what kind of securities you can give? Importers can offer movable assets and other financial assets and immovable assets, and excluding land and SEZs. If SEZ is getting a trade credit from an overseas supplier, so can he give his SEZ land as a security? No. Okay. Or corporate or personal guarantees as a security. Same, which is similar to ECB. Bank guarantee can be given by AD Bank, number one. Bank guarantee can be given by overseas guarantors like foreign banks or overseas subsidiaries of Indian Bank. And the next thing is, the importer can give his immovable assets, or else, what do you say, this corporate or personal guarantees by some other individuals can be given as security. Okay. And moving on to the next concept, reporting requirements. Okay, just a moment. Reporting requirements. So under ECB, we have seen that the borrower of the external commercial borrowings should be reporting regarding the status of ECBs and regarding the extra ECB transactions, whatever so happened, regarding repayment, everything on monthly basis. To whom? To the RBI through authorized dealer. Okay. So this ECB, the borrower will be informing in the form of ECB2 form to the AD, then AD will inform to the RBI. Here directly the authorized dealer will be reporting to the whom? The Reserve Bank of India regarding what? The trade credit status. Very simple. See, the monthly reporting, AD category 1 banks must report. Who is obligated to report here? The banks, not the borrower or not the importer. Must report the details regarding the TC drawal, utilization of the TC and repayment and consolidated statement each month using the TC form. Okay, so the status of the importer, like how many goods have he imported in the form of trade credits? So did he use the trade credit facility or not? Did he repay the trade credit or not? All this will be consolidated together, and in the form TC will be submitted monthly by the authorized dealer
to the Reserve Bank of India. Likewise, here quarterly reporting should also be done. Quarterly reporting should also be done. Here the reporting requirement is not only about TCs but also about bank guarantees. AD category 1 banks must report data on bank guarantees for TCs in consolidated statement quarterly on XBRL platform. What is XBRL platform? Extensible Business Reporting Language. Okay. Through this platform, AD category will be doing quarterly reporting regarding bank guarantees, and monthly reporting will be done by authorized dealers regarding the TC drawal, utilization, repayment of the trade credit by the concerned importer. Okay, that's all regarding this. And coming to the last, miscellaneous concepts related to the trade credit. Okay, so as in the concerned FDI, as well as not FDI, yeah, FDI only, we have seen the do's and don'ts of authorized dealer. No, here let's understand, not FDI, actually LRS, it's just a small confusion. LRS, we have seen do's and don'ts of authorized dealers, rather we have seen the duties of authorized dealer. Now here, what is the role or what is the duty of authorized dealer in this trade credits framework? Very simple. Ensure compliance with trade credit policy and FEMA provisions. Whenever this concerned importer is is importing goods and taking trade credit facility, this authorized dealer should verify if he is satisfying all the parameters of the trade credit framework or not, if he is satisfying all the provisions in the Foreign Exchange Management Act or not, who has the duty to ensure the compliance with all these norms? Authorized dealer. He has to verify properly and then initiate the transaction. Next, verify TC arrangements and avoid double financing for SCZ and FTWZ transactions. Now, what do you mean by double financing? For one import, for one import of goods, two persons or two banks is providing the trade credit facility. Yes or no? That's called double financing. So the TC, authorized dealer should ensure that double financing won't take place. Okay, that's all. Next, he should also verify what are the TC arrangements, like what is the credit period, what is the all-in cost ceiling, and who is the overseas supplier, is there any security which is given, or is there any guarantee which is given. The verification of the TC arrangements as well as avoiding double financing is the duty of authorized dealer. Next, the last one, ensuring the TC period for non-capital goods is lower of the operating cycle or 1 year. Here we have already seen under the framework, for non-capital goods in general, the maximum credit period, that is the TC period, should be 1 year, or operating cycle. Operating cycle means the conversion of raw material into the finished goods. The period, that operating cycle period, or 1 year, whichever is low. That period shall be ensured by whom? Authorized dealer. Okay. We have finished the role of authorized dealer. Now, non-resident guarantee for domestic facilities. Here, forget about the trade credit facilities or forget about ECB. Very simple. If I am procuring a loan, I am an Indian resident, I am procuring loan from a Indian bank. Now, will FEMA provisions be attracted? No, because I am a person resident in India, and I am taking rupee loan from an Indian bank. FEMA provisions won't be there. But for this loan, I am giving security. Rather, the security is given in the form of guarantee given by non-resident. So my father is giving a guarantee who is person resident outside India. Now this guarantee is given by a non-resident. Even if the guarantee is extended to this concerned loan, still FEMA provisions won't be attracted until and unless I make default and that person who is giving a guarantee should make the payment. Then only FEMA provisions will attract. That's all. That is the provision which is given in this concerned heading. Borrowing and lending in Indian rupees between two residents does not attract FEMA provisions, but non-resident guarantees for rupee facilities do not invoke Foreign Exchange Management Act until the guarantee is invoked. The original person who has to pay, that is me. If I have made default, then who has to pay? The bank, the person who is giving the guarantee, yes or no? So at that point of time, the FEMA provisions will attract, because who is making the payment to the Indian bank? Person resident outside India. Okay, so we have left out with last concept, which is facility of credit enhancement. Facility of credit enhancement. Basically, in general, what do you mean by credit enhancement is a larger and a stronger financial institution will back up or will give a guarantee to an Indian company or some other company who is trying to attract investor. Let's say an Indian company is trying to raise foreign debt by issuing rupee denominated bonds or debentures. Bonds or debentures. Sorry. Just a moment. Bonds or debentures. Sorry, I just told foreign debt, but not. Indian company issuing rupee denominated bonds or debentures to attract investors in India. Rupee denominated bonds cannot be given to foreign debt, or cannot be given for raising foreign debt, for Indian investors only. Whom? Indian investors only. But Indian investors are scared that if we purchase, or if we purchase the bonds, or if we purchase the debentures, maybe the credit risk is involved. The credit rating of this Indian company is a little low, and maybe our debt is at a risk. Maybe we might not receive a good returns, or maybe we might not receive our principal amount only. So they are scared. So now what happens is, this Indian company will come into an agreement with an international strong financial institution, which will support or back up. It will tell to the public that me, who is a strong international financial institution, is backing up, is giving you a guarantee that yes, you can invest in this concerned Indian company, you can purchase the rupee denominated bonds or debentures in this Indian company. I can give you a guarantee that you will definitely get a return. Now what happens? The people's trust will increase, because the credit enhancement is done by whom? By a person who is a much more stronger financial institution. International financial institutions or regional financial institutions or multiverse financial institutions provide this credit enhancement facility. What is this? Increasing the credit worthiness of a concerned entity. Now, in this case, what did they do? This international financial institution has increased the credit worthiness. That means it has increased the trust of these Indian investors, and it is giving them a guarantee that yes, you can purchase the rupee denominated bonds or debentures, because I am backing up these securities. I am there behind this company, so you can blindly trust me and invest. So that is a simple way of improvising the credit worthiness of a concerned entity. Okay, that facility is provided by whom? It is provided by multiverse financial institutions, regional financial institutions, and government-owned financial institutions, direct or indirect equity holders. Okay, this multiverse financial institution, regional financial institutions, government-owned financial institutions, we have already seen in recognized lenders in ECB framework. Yes or no? So all these banks are like international financial institutions, where so many countries will be members of these financial institutions. Okay, so this will have a lot of power and strength to give a guarantee for any debt for any entity, be it in their country or else any other country outside. Okay, so this concerned financial institutions will provide credit enhancement facility to domestic debt raised through capital market instruments like rupee denominated bonds and debentures. They will provide credit enhancement in the form of guarantee or backing of these securities to the concerned Indian entities. Okay, so who are raising the money through through rupee denominated bonds and debentures. So who is eligible to get that credit enhancement? Available to all borrowers eligible to raise ECB under the automatic route subject to specific conditions. So I am an Indian company and I fall under the category of eligible borrower for raising ECB. Now I can come into an agreement with a stronger financial institution like multiverse regional financial institution to provide me credit enhancement. That's all. So if I am eligible to raise ECB, I am eligible to come into an agreement for provision of credit enhancement to me. By whom? Multiverse financial institution, by regional financial institutions, government owned financial institutions. Okay, done. So that is the whole concept of credit enhancement. So that is simply increasing the credit worthiness of a company. With this, we have completed the Foreign Exchange Management Act 1999. I think the video has reached, I still did not merge all the videos. Maybe the video has reached around 10 to 11 hours. So that is why I'm not discussing question and answers in this concerned session. Of course, I will release a video regarding the discussion of question and answers of FEMA with my question bank, again on YouTube only. You don't need to worry about that. So on YouTube only, I will be releasing the video regarding the discussions of question and answers in FEMA. That will be a very short video because, of course, we've already discussed the concept. We've already discussed the concepts and everything in this main video only. But again, I won't go and discuss the question and answers there. Simply, I will say what is the question, how do you write the answer, how do you frame the answers, and that's all. Past question papers and MCQs. Okay. So with this, I think I have given you a clarity regarding this. If any concept I did not explain using my handwritten notes, or I have explained it a little fast, or I didn't give detailed explanation, that means that concept is not important. Okay, so don't think like you are a faculty and you need to know each and every line of the study material, each and every line of the concerned concept, and I have to understand from A to Z of FEMA. That won't happen. Then you will simply go write an exam which is especially oriented for FEMA and you will gain marks there, but you will not be able to score good marks in CMA Final Law examination because FEMA is only asked for maximum 7 to 14 marks. That's all. You can't risk 14 marks for losing the remaining marks, right? So that is why what will I say is the important concepts are covered in my handwritten notes. The unimportant concepts I have tried to cover here by using my concept book. So of course you have to give a single novel reading at least once for all the concepts before going in your first revision. But before going to the examination, the day before the examination, you have to just revise my handwritten notes. That's all. So that's the end of the session. I'll be coming up with more videos regarding exam tips or how to prepare or how to learn. So you don't need to worry about that. I'm going back. Bye bye, ma'am. No, I will come back. Okay. So that's all with the Foreign Exchange Management Act. I have covered each and every concept which is there in your Foreign Exchange Management Act study material of the ICMA. Okay. So which are unimportant, I have not included in my handwritten notes, but which are important, I have included in my handwritten notes. The question bank discussion will be released in a separate video because this is becoming a long video. Okay, so that is why. So thank you so much, guys. So please, if you like the video, do share it with your CMA final students or the person who needs to learn FEMA. And that's all. Thank you so much. Bye bye. I'll see you again with another video.